Honorable members, let us pray. Almighty God, we humbly beseech thee to look with favor upon this Parliament of the Republic of Ghana. Grant that it may perform its high duty as in thy sight. Give divine guidance to the President of the Republic. Endow members of Parliament and ministers of state with discernment and vision, integrity and courage, that through the labors of government, this land and people may be well and truly served, and our good purposes for the common human life be realized in our midst. O God, grant us a vision of our country, fair as it might be, a country of righteousness, where none shall wrong his neighbor, a country of plenty, where evil and poverty shall be done away with, a country of brotherhood, where all success shall be founded on service, and honor shall be given to the deserving, a country of peace, where government shall rest on the will of the people and the love for the common good. Bless the efforts of those who struggle to make this vision a living reality. Inspire and strengthen our people, that they may give time, thought, and sacrifice to speed the day of the coming beauty of Ghana and Africa. Amen. Honorable members, I have two formal communications to be made to the House. The first one has to do with the ongoing National Development Conference. You recall I drew your attention to it, and as a result of the importance we place on it, we decided not to have a sitting yesterday. Honorable members, it's important I bring you the greetings from the meeting which is being hosted by the Church of Pentecost at the Pentecost Convention Center in Gomoa, Fete. It started yesterday and is expected to end today. The two-day conference under the theme Moral Vision and National Development sought to bring together major stakeholders in national development for a sober reflection and dialogue toward developing a framework that significantly impacts and shapes the moral fiber of Ghana's development. Honorable members, the opening ceremony of the National Development Conference brought together the three organs of state, including the Vice President of the Republic, His Excellency Alhaji Dr. Mahamudu Bawumia, who represented the President of the Republic, His Excellency Nana Addo Dankwa Akufo-Addo. You are aware from the communication I read to you that he is out of the country presently. The leadership of this House and some members of the House, led by my good self, also participated in yesterday's forum. The Chief Justice, Her Ladyship Gertrude Araba Isaba Tokunu was also president. We had two former presidents also honoring the invitation. We have the former president of the Republic of Ghana, His Excellency John Agyekum Kufuor, and the former president, His Excellency John Dramani Mahama, being present. We had a host of ministers of state, a lot of the clergy, members of the diplomatic corps, and a delegation to represent the National Chief Imam, led by Sheikh Aremiyao Shaibu. A host of traditional leaders were there, queens, queen mothers, kings, and a lot of statements, heads of professional bodies, civil society organizations, security services, MNDCs, political functionaries of all divide. The chairman, the general secretaries of all the political parties were there. The Ghana Journalists Association, this is just to mention but a few, were all present to give their diverse contributions towards a secular discourse that engendered consensus building. Honorable members, like I stated the other day, this conference could not have come at an opportune time than this. Why? The recent erosion of trust in leaders, not only political leaders, leaders, whether traditional, religious, professional, there's a loss of trust in our leadership, and the declined public confidence in the state institutions doesn't hold good for the country. It's a signal that we, the leaders, must act fast and conduct ourselves by living above reproach and upholding the highest standards of ethics and morality to salvage what is left, if any, at all. Honorable members, I need your attention. This is exactly what I'm talking about. If you want to have a discussion, the practice is for you to move out, to go and do so. You don't sit on the floor and interrupt proceedings with discussion. I'll be emphatic again and say we need to renew our commitment and dedication to placing Ghana first in everything we do. We need not to only have a change of mind, but also a change of heart. This is the only way we can reinforce the moral fiber of this country for the national development we all desire. Honorable members, renowned speakers of yesterday's conference alluded to a gradual disconnection of conduct and behavior from leadership, in that in recent years, our society has come to accept that greed, weaponized cruelty, self-serving, arrogance in public service, corruption, and undisciplined sources of wealth, among others, have replaced the hitherto rich Ghanaian moral standards. Regrettably, empathy, truthfulness, humility, and kindness are rather considered weak principles of leadership, as intimated by Reverend Kobina Opuni Frimpong. Honorable members, permit me to thank the Pentecost Church, the leadership, particularly the chair and the vision bearer, Apostle Eric Nyamiche, for not only conceptualizing this dream, but taking steps to actualize it in such a national character. Indeed, Nyamiche is God's gift to Ghana. And I'm sure that is the meaning of the name. Nyame Che. So God has gifted him to us. A key question is heart. Hey. My friend wants to mislead me, and I will not be misled. At least my father was in Kumasi before you were born. A very key question that he raised yesterday in his exhortation and quoted the Holy Book is that righteousness exalts a nation. And I want to share that with you. The question he raises, why is the church burdened in spearheading a national development conference? Why not civil society organizations as we are used to? But his answer was this: the purpose of the church is not only the salvation of souls, but the transformation of society and by extension, the nation. A church cannot say, I have saved a soul, and not care about the environment the soul lives in. So, honorable members, as legislators, businessmen, politicians, doctors, lawyers, laborers, teachers, in fact, all professions in the country, the products, our acts and inactions, our conducts should inure to the prosperity of the nation and lift the country's image. I think that is what we have committed ourselves to do. And let me appeal to you all not to treat this with levity, and to know that our calling is not limited to the four walls of the church, and that was what he said, or the mosque, or to our professions, but to the service of God and mankind. Ours is not to make money or wealth, but to serve the people. And we should do this with diligence, sacrifice, hard work, and passion. We must recapture the faith in leadership. I am optimistic that the deliberations from the conference will be characterized by constructive dialogue, whose outcome and recommendations would inform how Ghana charts its path into the future. As such, the dialogue will create a watershed for a renewed commitment to ethical, moral, and effective leadership that cherishes the trust and confidence of the citizens. Let me end by thanking the leadership of this House and all the members who were able to participate in this all-important national conference. I can tell you that I left yesterday more committed than I was to sacrifice to make sure that this country doesn't experience what we are going through now again. With this, I thank all of you for your attention. The second formal statement is to try to erase or clarify some misinformation that is peddling in the country. This is in respect of the matters arising out of the passage of the Narcotics Control Commission Amendment Bill 2023. Honourable members, I am before you today to address a matter of national importance that has recently found its way into public discourse. My attention has been drawn to a series of media reports and various social media discussions revolving around the legality of cannabis, the use of cannabis in Ghana. It appears that there is a significant misunderstanding or misinterpretation of the nature and intent of recent legislative changes. The subject at hand, has its origins in the Narcotics Control Commission Act, passed by Parliament in 2020, Act 1019, which served to modernize and strengthen our country's approach to narcotics control. This legislation, as noted in the memorandum to the bill, was born out of diligent research, extensive consultation, and careful consideration of our societal realities. Recent reports, however, seem to have misunderstood or misrepresented some sections of the Act, causing unnecessary confusion and alarm, especially in light of the recent passage of the Narcotics Control Commission Amendment Bill 2023. It is my intention today to provide accurate information, thereby restoring a level of understanding, confidence, and trust in our legal and legislative process. Honourable members, at this juncture, it is essential to shed light on the historical framework that has led to us to pass this legislation. You all recall the Narcotics Control Commission Act was passed in 2020, as stated, numbered Act 1019. This was a pivotal legislation which transformed the Narcotics Control Board into a commission. The primary intent behind this statute was to retrofit the then existing National Narcotics Control Board, a body entrusted with the crucial task of supervising the handling of narcotic drugs and plants cultivated for narcotic purposes, alongside addressing other associated matters. Central to our discourse today is Section 43 of the aforementioned Act. This particular clause bestowed upon the Minister of Interior the authority, subject to the Commission's recommendations, to grant cultivation licenses for cannabis. These licenses, however, were specifically limited to cannabis with a tetrahydrocannabidiol, which is usually shortened THC content, that did not exceed 0.3% on a dry weight basis, and the cultivation was to be geared towards industrial and medicinal purposes. Industrial because they use it to produce jute sacks. And medicinal because they use it for a lot of medicinal purposes. Now, that type, I'm informed that we don't even yet have the seeds in Ghana. And so, we are yet to commence the cultivation of it, and through it, you can extract fiber, apart from just using it for medicine. To underscore the intent of these licenses, subsection 2 of section 43 expressly stated that they should not extend to the cultivation of cannabis intended for recreational usage. Thus, the prohibition against unlawful cultivation, possession, and use of narcotics clearly outlined in sections 39 to 42 of this Act remained unaffected. Despite these intentions, the provision met a judicial challenge in the case of Ezuami Manam versus the Attorney General. The Supreme Court, in its wisdom, declared Section 43 to be unconstitutional, citing a failure to adhere to Article 106 of our Constitution, 1992, during the enactment of the provision. The landmark ruling of the Supreme Court on Section 43 of the Narcotics Control Commission Act 2020 necessitated a period of critical reflection and renewed legislative action from this House. The Constitution serves as our nation's guiding document, and any contravention within our statutes needs immediate redress. In response to the Court's determination of the unconstitutionality, the Minister for the Interior introduced the Narcotics Control Commission Amendment Bill 2023 to rectify the identified shortcomings. The Amendment Act introduced a new provision, Section 42A, into Act 1019. The objective of this insertion was to re-establish the Minister's discretionary power to issue cultivation licenses for specific strains of cannabis. The cultural condition being that such strains possess not more than 0.3% THC content on a dry weight basis. Importantly, the license for cultivation was expressly limited to industrial applications such as the production of fiber or seeds, or for medicinal uses that could potentially contribute to advancement in health care. It is imperative to understand and underline that the intention of this provision is not to endorse or legalize the recreational use or smoking of cannabis. We must dispel any such misinterpretation. The provision's design aims to strike a prudent balance between the harnessing of the industrial and medicinal potential of certain low THC cannabis strains and maintain our robust control on narcotics to ensure the safety and well-being of our society. The second schedule of the Act remains in full force, detailing an extensive list of penalties for unlawful activities associated with narcotics. Further, the sixth schedule of the Act unambiguously categorizes cannabis as a narcotic drug. These provisions underline our unwavering stance against the illicit use of narcotics while simultaneously recognizing their potential for beneficial industrial and medicinal application. Honorable members, the law is there for all to use, and you have to read it carefully. I don't need to refer to the provisions anymore. But we have maintained all the stringent measures to make sure that it's only the beneficial uses that are allowed by the law. In conclusion, in the light of the foregoing, it becomes clear that our legislative actions, both past and present, are guided by a careful and considered approach. The evolution from the Narcotics Control Commission Act 2020 to the subsequent amendment in 2023 has been a journey of refining and enhancing our legal framework in response to evolving circumstances, judicial scrutiny, and the need for balance between potential benefits and social risk. It is imperative to reiterate, particularly in the face of the inaccurate media representations, that the purpose of our legislative actions has never been and is not now to promote or legalize the recreational use or smoking of cannabis. In conclusion, therefore, the House remains steadfast in its commitment to enforcing the law against the unlawful use of the cannabis. We will continue to act in a manner that upholds the Constitution, serves the public interest, and advances our nation's development. I want to implore all members of Parliament, and indeed all Ghanaians, to share and communicate this understanding so as to dispel misinterpretations and misinformation and foster a more informed dialogue on the matter. I reiterate, the cultivation, the manufacture, the processing, the production, the sale, the distribution, or the use of narcotic plants, including weed, marijuana, or synthetic or semi-synthetic drug, without lawful authority remains an offense and is punishable by our laws. I therefore call on the law enforcement authorities to continue to investigate, to prosecute, and to commit offenders to the sanctions of the law. With this, I want to thank honorable members for your attention and direct you in your advocacy during the recess to convey this message to all your constituents. Honorable members, I'm compelled to be copious in this matter because of the troubling nature of current trends. There are a lot of people now in the streets telling their colleagues that we have legalized the use of marijuana, of weed, of narcotics. We haven't done such a thing. And I want to once again urge the law enforcement agencies to continue to enforce the law. We haven't done such a thing. I thank you so much. We now take item 4, correction of votes and proceedings and official report. Page 1. Sorry, Majority Leader.
Mr. Speaker, given the importance of the two renditions that you're giving us. I was really caught in between what to do with it. Because you first started by saying that you have 2 communications to give us. If it is communication, we cannot comment. But when we came to the second leg, you said you are giving us a formal statement. If it's a statement, maybe some comment could be made on that. And so I wanted some directions from you, because they are very important matters that you have raised this morning. And if you permit me, Mr. Speaker, just brief comment. Now, this second leg about the Parliament allegedly legalizing the use of weed. Mr. Speaker, I think we should make that clear distinction. You have emphasized it. The consideration involved was is the chemical content, and was made clear that the marijuana or weed has excess anywhere that is grown of more than 3% THC content. Here in Ghana is anything between 3.5 and 5.2. The weed that is grown in Ghana is between 3.5 and 5.2 THC content. Mr. Speaker, that could be very, very injurious to the health of users. And Parliament was clear in our minds as to what we were doing when we said we should not grant any space to this. On the other hand, for industrial purposes, Mr. Speaker, you mentioned it. Whilst we were doing it, some people had even come to Ghana to what is now the Bono East region. And they had secured some vast tract of land. They wanted to start the cultivation of kenaf to be used to produce jute. Kenaf has THC content of 0.2, usually 0.2, 0.22, and certainly doesn't qualify as a narcotic drug. But because of the THC content, Mr. Speaker, we needed to be very scrupulous and diligent in setting the levels, which is what we did. Unfortunately, Mr. Speaker, as you alluded to, the ruling from the court that Parliament did not subject that matter to a debate and therefore struck it down, to me is very unfortunate. The Speaker, as we said, they are related to Article 106. Article 106, 6, which provides that the report of a committee, that is in crafting a bill, the report of the committee, together with the explanatory memorandum to the bill, shall form the basis for a full debate on the bill for its passage with or without amendments or its rejection by Parliament. The Speaker, that provision in the Constitution really relates to the second reading of the bill, not a clause-by-clause consideration. It's at the second reading that we subject the principles and policy to a full-scale debate. It is not at the consideration stage. And I think there was a mix-up. I think there was a complete mix-up of the Honorable Dafiamepo is telling me that I should rather say that they misread the Constitution. The Speaker, those are not my words. They are words being supplied to me by Honorable Dafiamepo. But clearly, I think the presiding judge got it wrong. But the Speaker, it tells us that we need to have maybe a structured way of engaging our justices. We have crafted the Interpretations Act, which now compels presiding justices to not only look at the letter of the various statutes or enactments, but also to look at the Hansard, what informed Parliament in all the provisions that Parliament approved relating to the various acts that we pass. And I think it becomes imperative from this that maybe from now onwards we should have a structured way of meeting the justices to have some understanding of what we do here, and if they have also a way of informing us to maybe do a better job than we have been doing, it will inure to the benefit of the country. Sometimes they take some of these provisions out of context, and it could be harmful to the administration of justice. The Speaker, the other one, in respect of the event of yesterday at the instance of the Church of Pentecost, I think is a very important event. It has taken a church, the Church of, to bring us back on track. As we said, it related to the erosion of trust. And the principles that they espouse to reinvigorate and rekindle the spirit of nationalism and patriotism in us. Mr. Speaker, I think that the very preamble of our Constitution encapsulates patriotism, the elements of patriotism. It tells us that we have resolved as a collective to establish a framework of government which shall secure for ourselves, not only ourselves, but also posterity. One, the blessings of liberty. Two, equality of opportunity. And three, equality of prosperity. If we resort to greed, self-aggrandizement, corruption, and so on, how do we cater for generations yet unborn? So the principle of sustainable development, also contained in the preamble of the Constitution, should tell us that if this nation should be stable and viable, we should be one another's keeper, which was at the pivot and indeed the pith of the various presentations. Mr. Speaker, I would propose that we, as you led the House yesterday, that the various presentations that are made there individually by the members, the resource persons, and also the final communique that may ensue, be made available to us. So we distribute to members for us to really scrutinize. Because, as you do know, and as also established by the preamble of the Constitution, we should stress on probity and accountability, in full recognition that all the powers of government spring from the sovereign will of the people. The Speaker, nothing, we should not shortchange ourselves as a country, as a people. We should not allow our people to lose trust in democratic governance. If they do, the Speaker, I don't know where as a nation we will be heading towards. It will not be to purgatory, it will be to hell. And that must be avoided at all costs. The dividends of democratic governance should be assured and guaranteed to all the citizens of this country. And it should be done equitably. Mr. Speaker, I thank you very much.
Minority Chief Whip.
Right, Honourable Speaker, the norm is that whilst the leader made the application to you, you would have allowed the minority to make a few comments before he tops up that. He's taking the lead to do so. So, Mr. Speaker, with your leave, I'll also make a few remarks about the statement you made, with your pleasure.
Yes, you may do so.
Okay. Mr. Speaker, I thank you for taking time to attend this very important function under the auspices of the Church of Pentecost, of which the national leadership, including yourself, attended to reflect on some of the things we all complain about and are finding it difficult to have solutions to it. Mr. Speaker, the purpose of this conference was to reflect on our conscience as a country, to see whether we can return this country to where ethics, civility, culture, and a sense of nationalism can return to the way we do everything, Mr. Speaker. Ever so often these days, even professionals that take decisions based on professionalism, when these decisions are taken, Mr. Speaker, people question the rationale behind these things. And Mr. Speaker, the church itself has come under severe scrutiny for certain decisions by the church as a body and then individuals in the church. So it is good that the Church of Pentecost decided that some of these things should be looked at again. And Mr. Speaker, we thank you for representing the legislature and the issues you talked about. Mr. Speaker, I believe the principles espoused by the various speakers at the function, if we follow them, Mr. Speaker, can lead to a situation where we have a more orderly society, a more peaceful society, and then a more prosperous Ghana. And I hope that the main key, the key issues raised would go beyond the conference and seep into whatever we are and the way we do things, Mr. Speaker. Mr. Speaker, the second issue you talked about, which has to do with the issue of the law we passed and its understanding by a section of the public. Mr. Speaker, I want to thank you for taking the opportunity to reiterate exactly what we did. This is not the first time we passed laws in this country and certain individuals in the country took it to be or misread whatever we did. I agree with leader when he says that in certain situations we probably should have better engagement with our counterparts at the judiciary, so that the way we do things in this house is not misunderstood. We make the laws and they interpret the law, so it is important they know the lawmaking process. And that is why the Interior Minister came to the House to help us tidy up that section. But Mr. Speaker, we should also be careful what we have done in terms of that law. The understanding of certain people who know what we have done is that it is actually the climate that changes the THC content of the plant we are talking about. So if you were to grow this plant in Norway, maybe the THC content would have been different if you planted the same plant in Tamale, because the climate alone could increase the THC. So yes, in Ghana. So this understanding that, but the understanding that this plant, when planted in Ghana, will automatically be of a lesser THC. Maybe let the scientists guide us. Mr. Speaker, the concern also was that with all the chemical composition and the nice things that is said, I am not sure if those who use weed in my village are going to be looking for the one with the less THC. And is the state capable of monitoring the growth of the one that is left THC? I doubt. Because even the one that is cultivated, which is illegal, the state has no control. Nobody in this country can tell me that they have a record of who is growing, selling, and consuming weed in this country. Once in a while, they catch somebody. So whilst we feel that the cultivation of this has got medicinal purposes, have got economic value, Mr. Speaker, we have been growing cocoa, coffee, we have been mining gold, diamond, bauxite, whatever in this country. We didn't manage to get ourselves out of economic quagmire. I doubt, Mr. Speaker, if the cultivation of weed is going to be the savior of our economy. That is the point some people are making, that what we are doing is just to serve a few people's interests. But who in this country believes that if everybody begins to grow industrial weed in his background, is going to improve his economic situation? So let those who are going to be in charge of licensing, monitoring of this particular brand of whatever they call it, I don't know whether it's a low-grade weed or it's a different name, let them be guided that it will be on their chest to monitor that what we do does not exacerbate the already growing problem of drug abuse in this country. So I agree that those people who have concerns have legitimate concern, but the misinterpretation that what we have done actually means that you can be on the street of Accra, as it happens maybe in New York, where you can see, or Montreal, when you can see somebody openly smoking weed on the street. That is not what we have done in Ghana. Nobody in this country have legalized the smoking of weed. As Mr. Speaker rightly said, you will be arrested, investigated, prosecuted, and punished if you are found to be in possession, distribution, and use of any controlled substance in this country. And let the public be aware that Parliament, the representative of the people, did not actually legalize the use or abuse of controlled substances, and let that be clear to everybody in this country. Mr. Speaker, with these few words, I thank you for bringing this issue back and bringing the clarity to our countrymen and women to set the record straight. Thank you very much, Mr. Speaker, for the opportunity.
Honorable Muntaka Mohammed Mubarak.
Thank you, Mr. Speaker. Mr. Speaker, I'm very grateful that you've given me the opportunity to say a word, even though the leaders will have spoken for all of us, but you still were gracious to offer some of us an opportunity to say a word or two. Mr. Speaker, the conference that was held yesterday by the Pentecost Church, I would say, is long overdue. And like you rightly pointed it, it is my wish that it is just not a talk show that we are usually familiar with. We'll go to raise all the issues and raise all the concerns. We'll live there and we do not have, as you rightly said, the change of hearts and the change of mind, and Mr. Speaker, to add the change of attitude to reflect the things that we say. Mr. Speaker, I was looking at Article 34 and 35 of the 1992 Constitution. That is the directive principles of state policy. And Mr. Speaker, my belief is that if each and every one of us in Ghana decide to even concentrate on just these 34 and 35 and try to imbibe them and work with it, almost all the things that were said there will have been achieved. Mr. Speaker, you are right. The danger we are having today is the people of our country, Ghana, really reaping the benefit of this democratic dispensation. Mr. Speaker, even those of us who are the political actors will admit that our people are not driving the benefit of the democratization. And Mr. Speaker, when you go to the World Bank and the IMF documents, there's a connotation they have given Ghana that we are having growth without development. because the growth are in numbers, GDP, and what have you. And the usual slogan that when you grow with development is not there. It's not the same. The democracy that we seem to have seems to concentrate so much on election. So we've been successful in terms of election. But the actual dividend is not being reaped by the people. Mr. Speaker, with your permission, I just want to read some sections of this chapter 6 of our Constitution. And to be precise, 34(1). Mr. Speaker, with your permission, I read that the directive principles of state policy contained in this chapter shall guide all citizens, Parliament, the President, the Judiciary, the Council of State, the Cabinet, political parties, and other bodies and persons in applying or interpreting this Constitution or any other law, and in taking and implementing any policy decision for the establishment of a just and free society. Mr. Speaker, the word, my emphasis is just and free society. Mr. Speaker, this call, if you relate it to 35(2) of the same chapter, and your permission, I read again, that the state shall protect and safeguard the independence, unity, and territorial integrity of Ghana, and shall seek the well-being of all citizens. Mr. Speaker, to further quote 35(4), that the state shall cultivate among all Ghanaians respect for fundamental human rights and freedoms and the dignity of human person. Mr. Speaker, I just want to quote this last one, the same 35(6)(a). The state shall foster the spirit of loyalty to Ghana that overrides sectional, ethnic, and other loyalties. Mr. Speaker, let's be brutally frank with ourselves. This is what we are doing. Our governments are not doing it. Individually, we are failing to do it. Mr. Speaker, with all humility, I've been in this house since President Kufuor's term. We have gradually pushed ourselves into we and them. That is the frank truth we should speak to ourselves. Our governments are not doing it. Even those of us who are also actors, let's ask ourselves in our own constituencies, how do we relate to our people? We still are doing the we and them. Mr. Speaker, where I come from in Kumasi, they say that when the kukuru, if the kukuru doesn't stop, the kika will not stop. You have a system that is tilted that once you have power, the power should be used for only you and your people. How will the others feel? And Mr. Speaker, I'm not accusing any one regime. That's why I'm saying I've been here since President Kufuor. I've been there when we were in opposition, President Kufuor. We saw how it happened. When we had power, I saw how it played. Now we are in opposition, we've all seen how it plays. Mr. Speaker, to the extent that we are virtually creeping this country into everything that you have to be either one political party or the other. And Mr. Speaker, the sad thing, I'm happy that the church is the one doing this. The sad thing, Mr. Speaker, the truth to be told, the church and the mosques are equally guilty of this. They can't run away. In fact, they are those who are exacerbating it. Because on their pulpit and on their member in the mosque, what are the imams and the pastors, what are they telling we the ordinary citizens? They themselves are also hyping the division within our country. If you go and you are Pentecost, how do you perceive Jehovah's Witnesses? Even within the same Christendom. How do you perceive the Presbyterians? How do you perceive the Catholics? What do you tell your people about these other groups within even your own faith? Not alone as a Christian priest, what to tell your church members about Muslims. When you come to the Muslims, the same thing. You have the Sunnis, what they preach about the Ahmadis, what they say about the Sufis, what they say about the Shias, all this, Mr. Speaker, it culminates itself into the situation that we find ourselves, that almost everybody is going to be greedy, self-centered, inward-looking, and yet we say we want to build a country that is united and just and free society. How do you do that? When you are in your silos, teaching each other how to hate the other. Mr. Speaker, let me conclude by saying, the biggest problem we have in our country, for me, it is three things that we have to sincerely, as people, address. One of it is negative ethnocentrism, ethnicity, negative ethnicity. It is not wrong, Mr. Speaker, for me to see myself as a Togomba and be proud of it. For you to see yourself as a Dagari and be proud of it. For my colleague from Bekwai, first Deputy Speaker, to see himself as an Asante and be proud of it. The only time that it becomes a problem is when I want to think that because I'm a Togomba, I am better than you as a Dagari, or I'm superior than him as an Asante, or he as an Asante, I'm inferior, or they should, because maybe their numbers are more, putting their numbers together, they should have everything. That is when it becomes a problem. And the second thing, Mr. Speaker, is religious discrimination. We all keep running away from it. Nobody says that you being a Catholic, me being a Muslim is bad. We should be proud of it. How do we play this in our society? Do we play it to divide ourselves, to discriminate against each other, to play down on each other, or how do you do it? And the last thing, Mr. Speaker, which is fed by these two, is the corruption. Because when I'm corrupt and you are going to raise it, the Dogombes will rally behind me. Because also, my colleague Honorable Osewusu and Honorable Second Deputy will tell you where we come from. They say that Obi our prayer once I'm perceiving the thing to bring to Asante, don't play mischief to me. Regardless of how am I playing to bring it. Once I bring it home, it is okay. How I get it to bring it home should not be questioned. Mr. Speaker, my wish is that we should allow all these things that seem to be dividing us to rather unite us using humanity. We are first human beings before any other thing. If we have that, I'm sure the conference will be meaningful and it will continue to play significant role. I pray that from the conference, more steps will be developed to adhere to most of the things that were said there. How do we implement them in our real life? I know the starting point may be also to look at our constitution and where to make the necessary amendments. If we do that, Mr. Speaker, I'm sure we may be able to build a free and just society. We should remember, sadly, Mr. Speaker, only yesterday, Niger have added to the long list of coup d'etat countries within the West African country, which is very scary. Why? It is because of the failure of the democracy to give the dividend that the ordinary citizens expect of all of us. I pray that all of us do not just talk, but will do whatever it takes to act. And like you rightly said, Mr. Speaker, to put Ghana first before our parties, before our tribes, before our religion, before any other parochial interest. I thank you sincerely, Mr. Speaker, for the opportunity to have contributed to this comment. Thank you.
Honorable members, what just happened is grounded in the standing orders of the House. Order 53-1. You have 1E giving opportunity to the Speaker to make formal communications, which I have just done. And then also you have 53-1I giving the Speaker the opportunity to make statements. And that is why the two statements, one was a formal communication and the other was just a statement. In the case of a formal communication, you cannot make comments. But in the case of a statement, comments are permitted. And so I permitted the comments, but you did not limit the comments to the statement. You also went into the area of the formal communication. I indulge you because it's necessary. All what you stated were acknowledged by the conference. They did not point accusing fingers at any particular person or section of a society or profession. They all acknowledged that we are all guilty and that it is time for us to confess our sins and ask for God's forgiveness, and that we should turn a new leaf. So we are waiting on the whether it will be a resolution or a declaration or communique, whatever it is, we'll make it known to the House again, and as requested by the majority leader, we'll make copies available to you. I have allowed you to do this because you can see that the public gallery is now full to capacity. We have encouraged more participation by the people we represent. And I'm happy that the youth, the young ones, the students have taken advantage, led by their tutors and their headmasters, to come to see, to listen, and to learn from you, their worthy representatives. And so I will acknowledge them before we proceed, but usually the department that we've established here takes them through a process. And so they'll give them some intro and show them a few things for them to start learning about Parliament and what parliamentary democracy is about. And so I'll acknowledge them, and I'm sure the officials are waiting to take them through what I just mentioned. We have at the public gallery a number of institutions and groups. The first is students from the Howard University Law School. And they are definitely coming from the United States of America, being led by the country representative, Mame Konedu Menta. Please, may we see you so we can acknowledge you? Yes, yes. You are most welcome. This is the Parliament of the Republic of Ghana. It's a unitary parliament, and this is where we deliberate on matters of importance to the state. We are a hybrid parliament. We are not like the American type, neither are we like the House of Commons. Because in Ghana, we don't have commons and lords. We don't have a class society. We are a hybrid society, and our history, our custom, our culture are unlike yours. So we fashioned out a different system, and you can see how the seats are arranged. So you are most welcome, and I'm sure the officials will take you through some of these rudiments of our parliamentary practice. But Ghana is a very hospitable country, and I'm sure you will enjoy some of the hospitality and the warmth of the people. Once again, you are welcome. I wish you all the best. Memorable stay in Ghana, and please be worthy ambassadors of Ghana when you go back. Thank you for coming. We also have the language school called Cabinet Evergreen from the Kita South constituency, led by one of their teachers by name Caleb Setoglu. Caleb Setoglu and his team. Where are you? Yes, they are up there. They are coming from a language school called Cabinet Evergreen. You are most welcome to, and I'm sure you convey what you just listened to your colleagues. I don't know what language school it is, whether it's Spanish or it's Ever, or you said Evergreen, or is it Dagare, my native language, or it's a French institution. But you are most welcome, and we want to have more of you convey the good news to your colleagues. We also have Krobo Girls Student Parliament. I'm sure Krobo Girls Senior High, this is the student parliament in that school. Congratulations for deciding to make politics a career. I hope you learn a lot from here. It's a sacrificial job, but the glamour of the office is what attracts people into it. There's some glamour and there's some perception about the holders of that office. But I can tell you, at the end of the day, you see that it's emptiness. So you are welcome, but it's a very honorable profession and a career for you. I have enjoyed it throughout my life, so I encourage you to join. So young ladies, you are welcome. Please, you may resume your seat. You are being led by your patron, Paul Abrakwa, and this is from the Lower Manya Krobo constituency. Is there MP around? It's not available. Now we have the students from Bonsuaku, Reverend Dr. Erickson Basic School, and they are coming from Owutu Senya West constituency. They are led by their head teacher, Aishatu Adamu. Wow, that's quite a large number. I'm sure they came with about 3 buses. Aishatu Adamu, where are you? Congratulations. You are leading from the back. That's good. It's a good strategy. We hope you learn something from your visit, particularly what you have seen, what you've heard, and maybe what you'll be taught. So you are warmly welcome, and once again, I will encourage you to come again. Thank you for coming. We have also students from Aveno Senior High School. They are coming from the Akachi South constituency, led by their government tutor, Mr. Owen Doji Akusa. Doji Akusa. Yes, please. Where are you? Yes, another one leading from the back. Thank you. Thank you for bringing them. That's also more than a bus full of students. And this one is not only girls, it's not only boys. Mix. Congratulations. Keep on coming. We expect that all of you visiting us will perform better than us in the future. That is what we call development. If we perform better than you, then we have not achieved anything. So please, take a better attitude, take more loyal, more committed, than what you are seeing today. Honorable members, I am to vary the order of business, and I will do so by letting us move to business before we come to take the votes and proceedings because of some. So please, let's move to public business, and that is item 7, presentation of papers. A, the following papers will be presented by the Minister for National Security.
Mr. Speaker, with your leave, I pray that the Minister of National Security, not immediately available, the Deputy Minister for the Interior be granted leave to lay the papers on the item 7. A, I, and B all the way to VII. Respectfully, sir.
Yes, minority from bench.
Mr. Speaker, we have no objection to the laying of those papers.
So, honorable members, I'll permit the Deputy Minister for Interior to present the papers for and on behalf of the Minister for National Security. Item 7A, Roman 1, 2, and 3, we take them together with a bow.
Annual report of the Ministry of National Security for the period January to December 2022. Budget performance report of the Ministry of National Security for the period January to December 2022. Budget implementation report of the Ministry of National Security for the to March 2023.
Honorable members, the said annual report, budget performance report, and budget implementation report itemized as item 7A, Roman 1, Roman 2, Roman 3 are laid accordingly and referred to the Committee on Defense and Interior for consideration and report to the House. We will now move to 7B by the Minister for Finance.
Mr. Speaker, I made a composite application. Yeah, we agreed. My prayer, yes, Mr. Speaker, my prayer was for 7A and B, and my colleague.
I granted for 7A.
Very well. Then I shall repeat.
I'm not sure the Deputy Minister for Interior is in the position to present papers for Minister for Finance.
Speaker,
because I'll ask a few questions and see whether she can brief me on that.
The Minister for Lands and Natural Resources is in the chamber, and with your leave, he would proceed to lay the papers listed item BI to VII. Respectfully, sir.
Yes, minority leadership.
Right, Honourable Speaker, we have no objection for the Minister for Lands and Natural Resources to lay this, but Mr. Speaker, it's just becoming too often. Too many tax waivers have been laid. They are probably in their dozens now on 1D, 1F. Just to draw attention of the leader that we are laying too many of these things and we don't see the reports. So with that, I have no objection for the Minister to lay the paper on behalf of the Finance Minister.
Well, this is a call on committees to be up and doing and to present the reports. But let's present the papers first. So 7B, Roman 1, 2, 3, 4, 5, 6, and 7 will take a bow for all from the Minister for Lands and Forestry for and on behalf of the Minister for Finance.
Request for waiver of import duties, import VAT, import NHIL, get fund levy, and exim levy amounting to the Ghana cedi equivalent of 9,566,392 United States dollars and 82 cents on machinery, equipment, and raw materials to be procured by Multipack Company Limited under the implementation of the One District, One Factory program. Request for waiver of import duties, import VAT, import NHIL, get fund levy, exim levy amounting to the Ghana cedi equivalent of 7,043,270 United States dollars and 94 cents on machinery, equipment, and raw materials to be procured by Happy Sunshine Company Limited under the implementation of the One Factory program. Request for waiver of import duties, import VAT, import NHIL, get fund levy, and exim levy amounting to the Ghana cedi equivalent of 6,491,213 United States dollars and 32 cents on machinery, equipment, and raw materials to be procured by the Everpack Limited under the implementation of the One District, One Factory program. Request for waiver of import duties, import VAT, import NHIL, get fund levy, and exim levy amounting to the Ghana cedi equivalent of 2,351,354 United States dollars and 65 cents on machinery, equipment, and raw materials to be procured by the Golden Africa Consumer Products Limited under the implementation of the One District, One Factory program. Request for waiver of import duties, import VAT, import NHIL, get fund levy, and exim levy amounting to the Ghana cedi equivalent of 1,330,889 United States dollars and 36 cents on machinery, equipment, and raw materials to be procured by the EPAC Flexible Packaging Ghana Limited under the implementation of the One District, One Factory program. Request for waiver of import duties, import VAT, import NHIL, get fund levy, and exim levy amounting to Ghana cedi equivalent of 1,341,537 United States dollars and 92 cents on machinery, equipment, and raw materials to be procured by the Golden Africa Soap Industries Ghana Limited under the implementation of the One District, One Factory program. Request for waiver of import duties, import VAT, import NHIL, get fund levy, and exim levy amounting to Ghana cedi equivalent of 1,4 $166,883 United States dollars and 94 cents on machinery, equipment, and raw materials to be procured by the Mass Industries Limited under the implementation of the One District, One Factory program.
Honorable members, the items listed 7B, Roman 1, 2, 3, 4, 5, 6, and 7 are accordingly laid and referred to the Committee on Finance for consideration and report to the House. Honorable members, let me add that the practice we've adopted will be better and in accordance with the law when we are dealing with cabinet ministers. A cabinet minister will have knowledge, unless otherwise proven, he will have knowledge of all the matters happening in government because they are discussed at cabinet meetings. Deputy ministers of various ministries are not by our constitution defined as ministers of state, except you are a deputy regional minister, and that's for good reason. And so they don't have the opportunity of having knowledge of many of the happenings in the government. And those who have been deputy ministers will tell you that even sometimes in their sector, they don't know what is happening. So it's not advisable to always be allowing ministers of sectors to be laying papers that they have no knowledge about. And they don't have any responsibility, because their duty is just to assist the Minister of State. And that is why when a cabinet minister is absent from duty, they cannot ask the deputy of the sector to act instead of the cabinet minister. They have to bring another minister from another ministry to act in place of the absentee minister. This should be known, and this should be accepted by us, and that should be the practice of the House. May we now go to, yes, Deputy Majority Leader.
Yeah, Mr. Speaker, Mr. Speaker, with respect, I pray that we move to item 26 for the Minister of Lands and Natural Resources to proceed to do that on behalf of the Attorney General, Minister of Justice.
You said item 26?
It is so, Mr. Speaker.
Honorable members, it's a very simple matter. Item 25 is not necessary because it's been on the order paper for a long time. So we'll go straight to item 26. Sorry? Yes, any issue?
Yeah, yes, Mr. Speaker. Mr. Speaker, I just heard you refer 7F to the end waivers for 1D, 1F, without respectfully including the leadership of the Trade Committee, as you've always been doing. I just wanted to find out if it was an oversight or you want to have a...
No, it's not an oversight. This is purely financial matter. It's not a contract agreement where you need the sector to make some inputs. But it's just dealing with waiver. In fact, what I slipped from adding was to direct the committees of those sectors to proceed to ensure that these waivers we are granting are actually creating opportunities for those industries to commence work. So that is your oversight. You don't need that directive from me, but the committees can take up these matters, visit the usual factories, and see whether actually these things are being done. But as for reporting on the request, they are purely financial, and I don't need to add the various sector select committees to be part of it. So please, that is a general thing for you to do. You don't need a directive from the Speaker. Can we go to the item 26? Motion. Attorney General and Minister for Justice. There is an application that the Minister for Lands and Forestry should do so for and on behalf of the Attorney General. The third reading of the Contract Amendment Bill.
Calm down, leader. Mr. Speaker, we have no objection. We have done the bill already. So, third reading, we have no objection for our colleague to move for the third reading.
Yes, Honourable Minister for Lands and Natural Resources.
25 or 2. Thank you, Mr. Speaker. Mr. Speaker, that notwithstanding the provisions of Standing Order 1311.
Honourable Minister, 26. Yes.
Thank you, Mr. Speaker. Mr. Speaker, that the Contract Amendment Bill 2022 be now read the third time. So, I so move, Mr. Speaker.
Honourable members, motion moved. Any seconder?
No?
Yes, please.
Mr. Speaker, I second the motion.
Honourable members, motion moved and seconded. It's now for the consideration of the House. Honourable members, there being no consideration, I put the question. Those in favour of the motion say aye. Those against say no. Honourable members, the ayes have it.
An act to amend the Contracts Act 1960, Act 25, to provide for the type of interest to be paid on a sum of money due to a party of a contract or transaction entered into on behalf of the Republic.
Honourable members, the Contracts Amendment Bill 2022 is duly read the third time and passed.
Yes, Mr. Speaker.
Yes.
Mr. Speaker, if you may be pleased, we shall proceed to item 28, motion. Same as before.
Honourable members, item 28, same application. I take it that no objection. So, Minister for Lands and Natural Resources, for on behalf of the Attorney General and Minister for Justice.
Mr. Speaker, that the Whistleblower Amendment Bill 2023 be now read the third time. I so move, Mr. Speaker.
Any seconder?
Mr. Speaker, I second the motion.
Motion moved and seconded is for the consideration of the House. Honourable members, there being no consideration, I put the question. Those in favour of the motion say aye. Those against say no. The ayes have it.
An act to amend the Whistleblower Act 2006, Act 720, to expand the sources of money for the fund, provide a ceiling for the fund, specify the mode of rewarding a whistleblower, and provide for related matters.
Honourable members, the Whistleblower Amendment Bill 2023 is duly read the third time and passed. Yes, please.
Mr. Speaker, with respect, may we proceed to deal with matters under item 5. Questions, Mr. Speaker.
Honorable Leader, before then, let me take the votes and proceedings.
Very well.
Because we didn't do that and the application came. So, honorable members, let's go to item 4, correction of votes and proceedings and official report. We start with the correction of votes and proceedings of Tuesday, 25th July, 2023. Page 1. Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Page 11. Page 12. Page 13. Page 14. Page 15. Page 16. Page 17. Page 18. Page 19. Page 20. Page 21. Page 22. Page 23. And page 24. Honorable members, in the absence of any corrections, the votes and proceedings of the 27th sitting dated Tuesday, 25th July 2023 are adopted as the true record of proceedings. Honorable members, I have a copy each of the official reports dated 27th June 2023 and 29th June 2023. We start with the one dated 27th June 2023. Any corrections? Honorable members, in the absence of any corrections, the official report of Tuesday, 27 June 2023 is hereby adopted as a true record of proceedings. Now we move on to the one dated Thursday, 29 June 2023. Any corrections? Honorable members, in the absence of any corrections, the official report of Thursday, 29 June 2023 is hereby adopted as a true record of proceedings. We can now move to item 5, questions. First Deputy Speaker to take the chair. Questions. We'll start with question number 1285. standing in the name of the Honorable Member for Keita, Honorable Kwame Jijole Gakwe. Honorable Member, you may ask your question now.
Thank you very much, Mr. Speaker. Thank you for giving me the opportunity. I rise.
Sorry, the minister to take his rightful seat. Sorry. Yes, Honorable Member, you may proceed now.
Thank you, Mr. Speaker. I rise to ask the Minister for Lands and Natural Resources the status of the contract between Minerals Commission and Kensington Industries Limited of India and the nature of the license granted.
Yes, Minister.
Thank you, Mr. Speaker. Mr. Speaker, the Minerals Commission has no contract with Kensington Industries Limited, which is now called Seven Seas Salt Limited. Mr. Speaker, by Section 5 of the Minerals and Mining Act 206 Act 703, mineral rights are granted by the minister responsible for mines on behalf of the President of the Republic, in whom these minerals are vested, and on the advice of the Minerals Commission. Mining leases are therefore signed by the minister on behalf of government. Mr. Speaker, by a restricted mining lease made on 29 December 2011, Seven Seas Salt Limited was granted a 15-year lease over an area of Keita Lagoon measuring approximately 6,004.48 acres. The area subject matter of the lease is located at Adina, Agaveji, and Blekusu, all in the Ketu South municipality. A restricted mining lease is a lease for the mining of industrial minerals such as clay, sand, gravel, limestone, marble, and salt. The lease is valid till 28 December 2026, when the 15 years granted will expire. Mr. Speaker, on 7th October 2020, the company put
Honorable Minister, just a minute, you've got to take the chair.
Yes, Honorable Minister, you may continue.
Thank you, Mr. Speaker. Mr. Speaker, on 7th October 2020, the company put in another application for additional restricted mining leases in the Adafianu area, also in the Ketu South municipality. On the recommendation of the Minerals Commission, pursuant to Section 102 of the Minerals and Mining Act at 703, the then Minister, Honorable Kweku Asumachiremi, on 23rd December 2020, gave approval for the company to be granted a restricted mining lease over the area, subject to the payment of the required fees. Mr. Speaker, pending the payment of the fees and the issuance of a formal lease, the Minerals Commission noticed that the company had commenced operations without a lease and without an operating permit, contrary to the mining laws of our country. The Commission, therefore, on 23rd November 2022, recommended that the approval given for a mining lease to be granted to the company be revoked. On 1st February 2023, acting on the advice and recommendation of the Minerals Commission, the approval given for a mining lease to be issued to the company was revoked. The Minerals Commission has taken the necessary steps to stop the company from operating in the area and are liaising with the Office of the Attorney General for the necessary sanctions to be applied. Therefore, Mr. Speaker, the only existent mining transaction between Kensington Industries Limited, now Seven Seas Salt Limited, is a 2011 restricted mining lease signed by the then Minister, Honorable Mike Allen Hammer, on behalf of government. It is a restricted mining lease for the mining of salt, and it is valid till 28 December 2026. I thank you, Mr. Speaker.
Yes. Thank you, Mr. Speaker. I'd like to thank the Minister for providing this information to us in the House. Drawing from his answer, he said both applications have been rejected on the recommendations of the Minerals Commission for non-compliance with the mining laws. I would like to find out from the minister, is he aware this company still continue mining processes in the area where a lot of people are dying day in, day out? People are dying, and they also deprive the livelihood of the people in the countryside. Is he aware? And what measures are they put in place?
Honourable Minister, are you aware?
Thank you, Mr. Speaker. Mr. Speaker, I'm not aware about the claims my good friend, the honourable member, is making. But as I said, following the revocation of the approval, the Minerals Commission is taking steps to stop this company from continuing with the mining operations in that enclave. I will further follow up, and if there are additional measures which has to be implemented, we'll do so. Thank you, Mr. Speaker.
Yes. Thank you, Mr. Speaker. In the minister's answer, he provided the companies will be sanctioned. I would like to know when would that sanction happen?
It says you verify. You don't get to punishment until you verify. So he said he's not aware. He will verify, but you're asking for punishment before he has verified. Can we ask another question, please?
Mr. Speaker, no. He provided the answer that he will liaise with the Attorney General for breaching the company breaching the mining law. So they will make a necessary sanction. So I was asking, when would that happen?
Honourable Minister, this is different from the answer you just gave. Anyway, if you heard him.
Thank you, Mr. Speaker. Mr. Speaker, these are matters relating to the legal regime which governs the mining sector and the alleged breach of the tenets of this legal regime. I will refer this subject matter to the Attorney General, and the Attorney General will take the matters from there. Thank you, Mr. Speaker.
Yes, we have one more question.
Thank you, Mr. Speaker. I would like to actually remind the minister, if in any way he can visit the place to ascertain some of the things that are happening over there. Thank you very much.
Very well noted. Yes, the next question is question number 1320, the name of the honourable member for Lower Menya Krobo, Ebenezer Oklete Telabi. The honourable member is house. The next two questions are also in his name. We'll jump them and move to question number 1573 in the name of the honourable member for Sisala West, Mr. Mohammed Adam Suparo. Yes, you may ask your question now.
Thank you, Mr. Speaker. Mr. Speaker, I rise to ask the Minister for Lands and Natural Resources, what is the state of government's agenda to digitize the operation of the Office of the Administrator of Two Lands? Thank you.
Yes, Honourable Minister.
Mr. Speaker, as part of government digitalization agenda, the Office of the Administrator of Two Lands, OASL, began a process of digitizing its operations to increase productivity and revenue mobilization. With the support of the German International Corporation GIZ, an online portal known as OASL Revenue Application has been developed. The application was launched on 27th October 2022 at the Accra International Conference Center as part of Government Digitization and Innovation Week celebration. It will assist the office to collect data, automate rent assessment procedures, print rent demand notices, and distribute bills to clients electronically. Staff in all 9 operational regions of the office have been trained, and the app is currently in use for for statistic collection and billing. It enables users to pay stool land revenues from the comfort of their homes. The portal also has an interactive session that allows clients to interact with the office. Mr. Speaker, the Ministry of Lands and Natural Resources will continue to work with all stakeholders to adopt innovative measures to deliver on this mandate. Thank you, Mr. Speaker.
Yes.
Thank you, Mr. Speaker. Mr. Speaker, I would like to find out from the Minister. It says, with the support of the German International Corporation, GIZ, an online portal known as OASL revenue application has been developed. I want to find out from the Minister how much have been paid for it, because it is a support. I don't know whether it's a partnership. If it is a partnership, how much are we paying as a country for it? Thank you.
Kindly ask that as the main question, so he'll prepare and bring you the details. But do another follow-up question.
Mr. Speaker, I will go to my second question. Mr. Speaker, I rise to ask the Minister for Lands and Natural Resources whether the drones, patrol boats, tracking devices, etc., that were supposed to be used in combating the activities of illegal miners have been procured by the Ministry. Thank you.
Yes, Honourable Minister.
Thank you, Mr. Speaker. Mr. Speaker, since the promulgation of the Minerals and Mineral Operations Tracking of Earth Moving and Mining Equipment Regulations 2020 LI 2404, the Commission have been working to track all earth moving and mining equipment in accordance with law. Mr. Speaker, with the approval having been sought from the Public Procurement Authority for the purchase of drones and tracking devices for this purpose, the Minerals Commission has, however, already established a control room at the Commission to monitor the operations of excavators and other earth-moving equipment, and some 68 excavators in Takwa, Pristia, Obuasi, Bibiani, and Bolgatanga have all been installed with tracking devices for piloting. Mr. Speaker, several other logistical supports have the Minerals Commission to enable it effectively monitor mining operations, including vehicles, blast monitors, survey equipment, plotters, among others. Mr. Speaker, admittedly, we are not out of the woods yet when it comes to illegal small-scale mining, but we will continue to work with all stakeholders and adopt the necessary measures to come to grips with this canker. I thank you, Mr. Speaker.
Yes.
Mr. Speaker, I do not have any follow-up question with regards to that.
So move on to your last question.
Mr. Speaker, I rise to ask the Minister for Lands and Natural Resources what measures the Ministry has put in place to ensure that the 5 Ramsar sites are protected. Thank you.
Yes, Honourable Minister.
Thank you, Mr. Speaker. Mr. Speaker, the Convention on Wetlands of International Importance, especially as waterfall habitat, also known as Ramsar Convention, was adopted at the International Conference on the Convention of Wild, Fowl and Wetlands on 2nd February 1971 in Ramsar, in the Islamic Republic of Iran. Among others, promote the conservation of wetlands and waterfowl by establishing nature reserves on wetlands. The convention enjoins contracting parties to designate suitable wetlands within their territory for inclusion in a list of wetlands of international importance. A wetland, Mr. Speaker, refers to a land covered by fresh water or saturated water and serve as natural waste water treatment and carbon saturation. They are crucial for food security, water supply, agricultural production, energy resources, and transport. They also serve as habitat for migratory birds and support food control, as well as shoreline and storm protection. The convention entered into force in Ghana on 22nd June 1988 And in accordance with Article 2 of the Convention, 6 areas were designated as wetlands of international importance, or Ramsar sites, between 1988 and 1992. These Ramsar sites were subsequently given legal authorization through the Wetland Management Ramsar Sites Regulations 1999, LI 1659, to promote effective management and regulation of these sites. Of the 6, Mr. Speaker, 5 are coastal wetlands, namely Keita Lagoon Complex Ramsar Site in the Volta region, Muni Pomazi Ramsar Site in the Central region, Songo Ramsar Site, Densu Delta Ramsar Site, and Sakumono Ramsar Site in the Greater Accra region, and 1 inland wetland, that is Owabi Ramsar Site in the Ashanti region. Together, the 6 Ramsar sites cover an area of 178,410 hectares. So, Speaker, international practices require that each country adopts wise use of wetlands, which has been defined to mean the sustainable utilization of wetlands for the benefit of humankind in a way compatible with the maintenance of natural properties of the ecosystem. In accordance with this principle, several measures are being implemented by the Ministry of Lands and Natural Resources through the Forestry Commission for the protection and preservation of all our Ramsar sites. They include law enforcement mechanisms, the use of traditional and community sanctions, stakeholder engagements, education and awareness creation, research and monitoring, ecosystem restoration, tourism promotion, and the use of community resources management areas, CREMA, where feasible. In the Keita Lagoon Ramsar site, for example, a total of 57 hectares of degraded mangroves areas have been restored, and 6 hectares of community woodlots have been established in partnership with Arocha Ghana, CASA Initiative, and Sea Solutions. Some additional 15 hectares of degraded mangroves and 6 hectares of community woodlots will be restored and established respectively by the end of this year. Just because schools and communities in the catchment area are constantly engaged, and 5 informal networks have been established to prevent the killing of marine turtles. 4 community resources management areas, CREMES, have been established at Avu Lagoon, Anlo West, now Ango, and Galu Sota, Galuche, now Dosonu, with others due to come on stream to support these measures. In the Songo Lagoon Ramsar site, over 18 hectares of red and white mangrove plantation have been established at the Obani community, and an additional 12.1 hectares established along the peripheries of the Wasakusi Lagoon. Several thousands of seedlings have also been planted in Pute, Fifth, Kope, and Futuyang. The site also serves as a major ecotourism in the area, with attractions such as bird watching, Nine Turtle Walk, and mangrove plantation visitation. Officials of the Forestry Commission, Mr. Speaker, undertake day, night, and dawn patrols to protect the 4 endangered species of marine turtle that use the site as their nesting ground. That is, leatherback sea turtle, green turtle, olive redley sea turtle, and hawksbill turtle. Mr. Speaker, similar restoration, conservation, education, law enforcement, and other ecotourism promotion measures are being implemented at all the other Ramsar sites. At the Sakumono Ramsar site, for instance, which has come under severe attack in recent years, particularly from encroachers, we have intensified community engagement, undertaking some demolition exercises to protect the core area of the site, and more structures within the zone, the core zone of the site, are earmarked for demolition. Currently, structures within the core area are being marked, and once completed, all these structures will be demolished. We are working with the Greater Accra Regional Security Council and the traditional authorities to make sure that we safeguard these international assets. So, Speaker, wetlands are crucial to environmental protection and constitute a resource of great economic, cultural, scientific, and recreational value. Let me assure this august House of the commitment of the Ministry of Lands and Natural Resources and my personal commitment to ensure the protection, preservation, and effective management of all our Ramsar sites. I thank you, Mr. Speaker.
Yes.
Thank you, Mr. Speaker. Mr. Speaker, I would like to find out from the Minister. We know the Land Protection Act gives the Ministry the authority to prosecute persons who encroach on public lands. Most of the times, just as he indicated in his answer, Mr. Speaker, he said several demolitions exercises
have been carried out by his ministry in their quest to protect the Ramsar site, particularly at the Sakomono. Mr. Speaker, I want to find out from the minister, after demolition, whether persons that are engaged in encroaching those lands, if there is any person that has been prosecuted per the Land Protection Act. I'm just trying to find out from the minister, because we only see government moving in to do demolitions. Tomorrow, same people will come and start putting up structures again. Tomorrow, next government is moving there to destroy people's property. But, Mr. Speaker, if the needed law, because there's a law that gives the government the authority to prosecute persons who encroach on those lands, at least people will be punished, and as a result of that, some other people will not go into that. Thank you, Mr. Speaker. I just want to find out from him.
Minister, have you prosecuted any of the encroachers on the wetlands, as you are empowered by law to do?
Thank you, Mr. Speaker. Mr. Speaker, I'm not familiar with the law referred to or described as the Land Protection Act. I don't know if my colleague is talking about the Land Act, Act 1036. But be that as it may, Mr. Speaker, when these demolitions take place, we conduct investigations. And we are at the stage of investigations being conducted. And once that is done, Mr. Speaker, whatever findings come out of it will be referred to the Office of Attorney General, who will make the determination whether to prosecute or not. Thank you, Mr. Speaker.
Are you done? Oh, very well. Yes. Available leader.
There's a leader here, Mr. Speaker. Most grateful, Mr. Speaker. Mr. Speaker, when you invited Honorable Tel Labi to ask his questions as advertised on page 3, he was not available. I rise to crave your indulgence to permit him to ask his questions on page 3. Thank you, Mr. Speaker. Question from number 1320 to 1322. About 3 questions. Yes, we can crave your
indulgence. I thought you were doing a follow-up question on his own.
He has finished, and I'm craving.
You don't intend to do a follow-up question on that?
No, Mr. Speaker.
And then kindly resume your seat. Honorable Senior Colinzada on his feet. I thought he also wanted to do a follow-up question. No. All right. Now I may hear your application again.
Most grateful, Mr. Speaker. Mr. Speaker, when he invited Honorable Tenabi to ask his questions as advertised on page 3, he was not available, and I'm craving your indulgence to permit him to ask the questions. Now he's available.
In what capacity are you? I called you available leader. You pointed to the leader as present. So in what capacity are you making the application? The person is here. If he applied himself, then I'll tell him why I won't admit it. But in what capacity are you applying if you are not available leader? But you still haven't answered. In what capacity did you apply?
Thank you, Mr. Speaker. Mr. Speaker, in my absence, he acted as available leader. So, Mr. Speaker, he had all the powers granted him to be able to make that application to you. So, Mr. Speaker,
I called him as available leader, and he pointed to you that you are there. That's why I'm asking him if he says the leader is there. In what capacity is he asking the question? Anyway, yes, Honorable Telabi, you have lost your chance, but the answers have been provided. So I direct that the answers are published in the Hansard as answered.
Mr. Speaker, there are a few clarifications that I would want to seek from the Minister. So, if you permit me.
Because your beard is growing white, I'll consider that. But otherwise, for being absent when the questions were called. Now I'll take the questions again.
I'm grateful, Mr. Speaker. Mr. Speaker.
Question number 1320.
Yes. Mr. Speaker, I rise to ask the Minister for Lands and Natural Resources the current state of the National Cathedral. What is the state?
Yes, Honorable Minister.
Mr. Speaker, the National Cathedral does not fall under the Ministry of Lands and Natural Resources. The Ministry's only involvement in this project was the provision of land for that purpose. The Ministry, through the Lands Commission, provided public land measuring approximately 16.26 acres and gave vacant possession of the land to the National Cathedral Secretariat. Beyond this, Mr. Speaker, the Ministry has no official information on the status of the National Cathedral. I thank you, Mr. Speaker.
Thank you.
Before you
Minister,
proceed,
the Ministry of Lands.
Before you proceed, honourable members, having regards to the state of the business of the House, I direct that the House sit outside the regular sitting hours. Now you may continue.
Thank you, Mr. Speaker. Mr. Speaker, this is the second ministry that is supposed to answer this question. The first one was directed to the Ministry of Works and Housing. The minister wrote to me telling me they don't have any jurisdiction. Lands is also telling us they don't have any jurisdiction. So which ministry is responsible for this? If you may guide me so that I will direct my question to them.
Who may guide you? The chair. So this is not for it's not for plenary. If you come to me privately, I'll help you inquire.
Can I go on with the next?
Very well. So the next question is question number 1321.
Mr. Speaker, okay.
Yes.
Mr. Speaker, I had a follow-up question, so I thought he was going to get his third question. That's why I was waiting. But since he has no question, can I ask my question on this matter before you move on to the next question?
On which one? 1320?
Yes, Mr. Speaker.
1320.
Mr. Speaker,
Very well, yes.
Mr. Speaker, may I find out from the Minister of Lands and Natural Resources, since he's a cabinet minister, has he at any point in time received any form of briefing on the status of the National Cathedral to date? Thank you, Mr. Speaker.
Honourable Minister, do you have any information from Cabinet on the status of this project?
Mr. Speaker, the leader is asking me to divulge information relating to cabinet deliberation. Mr. Speaker, as you should know, I take an oath of secrecy. I'll be unable to divulge that information. Thank you.
Honourable Minister, the question was simply, have you received any briefing? That is not any information.
As a minister or
as a member of cabinet?
Sorry, Mr. Speaker.
A member of cabinet. Has cabinet received any information to your knowledge on this program?
Mr. Speaker, but that is the answer I'm giving, which is that if he's asking me a question as a minister, have I received any briefing in relation to National Cathedral? That I can provide. But if he's asking me to answer whether or not cabinet...
So answer the question as a minister. Have you received any briefing?
Mr. Speaker, as a minister, I have not. Thank you.
Yes, do you have any more follow-up questions? No, very well. So 1321.
I rise to ask the Minister for Lands and Natural Resources, how many judges are still being housed? Mr. Speaker, this question I think has lapsed because I asked it about a year ago and I got some, information that, so let me move on. I'll stand that down and then move to the next one.
Very well. So you are not asking 1321. Very well. So I'll move on to 1322.
Yeah, Mr. Speaker, once again, I want to ask the Minister for Lands and Natural Resources whether all private persons whose properties were destroyed at the sites for National Cathedral have been adequately compensated where they qualify.
Yes, Honourable Minister.
Thank you, Mr. Speaker. Mr. Speaker, the land on which the National Cathedral is being constructed, measuring approximately 16.26 acres, forms part of a large tract of land acquired by the state in 1910 by a certificate of title dated 29 September 1910. Mr. Speaker, apart from the public institutions that occupy the area, 4 private institutions have interest in the land, in addition to the Embassy of the Republic of Mali. All these institutions have been provided with alternative public lands. The Embassy of the Republic of Mali and Waterstone Realty Limited have been relocated to airports. The Africa Center for Energy Policy, ACEP, has been relocated to Roman Ridge. Numo Logistics Limited has been relocated to Cantonment, and Comsys Limited has been relocated to East Ridge. Thus, Mr. Speaker, all persons, both public and private, who were affected by the construction have been adequately compensated by way of alternative properties. Thank you, Mr. Speaker.
Yes.
Mr. Speaker. Mr. Speaker, I would want to inquire from the minister if he can give us dates on which these private persons took possession of the lands that were given. Oh, please. Allow the minister to. Allow the minister.
Boss, sit down.
Yes, Chief Whip.
Speaker, my colleague should revert to Order 69. And Speaker, for the benefit of doubt, as soon as a question is answered in the House, any member beginning with the member who asked the question, without notice, asks a supplementary question for further elucidation of any matter of fact regarding which the answer has been given. But a supplementary question must not be used to introduce a matter not included in the original text. And so, Speaker, what is introducing is strange compared to the original text. And so he should either rephrase his follow-up question, or should rather ask a different question.
Honorable Member, do you have those details? Honorable Minister, do you have those details of the specific dates when the people were compensated?
Mr. Speaker, I don't have that information immediately. Thank you.
Yes.
Speaker. Mr. Speaker, I want to ask the minister if they have any any issue in court with any of the private owners of original owners of the land.
Sorry, clarify your question.
If there's any suit pending in any of the courts in this country, any litigation whatsoever.
Sorry, I'm not clear. That has any of the owners sued the government?
Yes, that's right.
Honorable, has any of those you have replaced, have they, any of them taking action against government?
Mr. Speaker, not that I'm aware of. As I speak, I will have to check with the Lands Commission. As I said in my answer, Mr. Speaker, the records I have and the information that has been given to me indicates that everybody, every institution, both public and private, who had interest at the site of the National Cathedral have been relocated. And to that extent, I'm not aware of any suit. I have to check. Thank you.
Yes.
Thank you, Mr. Speaker. Mr. Speaker, I'm going to be specific. Is the minister aware that Waterstone, the land allocated to Waterstone, has not, the company has not been able to enter Lala? Are you aware?
That's what the chief raised objection to. This is not a follow-up question. It's a specific question, but I suggest that these matters you can find out from the ministry. If there's anything outstanding to be done, they'll do it. But for this specific question, I'll not allow it. Can they ask another one?
Mr. Speaker, in the answer, the minister provides the name of this company as one of the companies that have been relocated and reassigned. And my question is, are you aware that they have not been able to take possession of the land?
Simple question.
I have declined that question. I have refused it. If you want that answered, I suggest that you put that up, you file that as a main question. If you don't have any more questions, I'll move on.
Yes. Thank you, Mr. Speaker.
Very well. That brings us to the end of question time for today. Yes.
Mr. Speaker, I wanted to ask a follow-up question, a supplementary question.
Let me hear you.
Mr. Speaker, the minister indicates in his answer that government provided 16.26 acres of land for the construction of the National Cathedral. So I wanted to find out what the cost of this land was in financial, in monetary terms to the state.
Kindly ask your own question. He will answer you. Yes, Honorable, we thank you for attending upon the House to answer questions. You're discharged. Yes.
Speaker, may we now turn to page 27 of today's order paper, and we are taking item 40. Speaker, I will respect item 40, page 27.
You intend, yes, item 40. The Wildlife Resources Management Bill 2022 at the consideration stage. Yes. We are continuing at clause 11. Is that right? Item 1.
Clause 11.
Very well.
Amendment proposed.
Kindly wait for the clause to be read out, please.
Yeah. Activities prohibited in protected areas.
Yes, Chairman.
Mr. Speaker, amendment proposed. Subclause 8, paragraph B. Delete vegetation and insert vegetation. Just spell it.
Yes, you may move your motion now.
Clause 11, amendment proposed. Subclause 8, paragraph B. Delete vegetation and insert vegetation. It's just spelling mistake.
Yes. Honourable members, the proposed amendment is for the consideration of the House. I'll put a question. All in favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Now they put a question on clause 11 as amended. The question is clause 11 as amended shall stand part of the bill. All in favor, say aye. All against say no. The ayes have it. Clause 11 as amended is ordered to stand part of the bill. Clauses 12 and 13 have no proposed amendments to them. Kindly read the clauses out. So,
Establishment of protected area management advisory committees. Functions of a protected area management advisory committee.
there are no advertised amendments to these clauses. I'll put the question. All in favor of clauses 12 and 13 being a part of the bill, say aye. Aye. All against say no. The ayes have it. Clauses 12 and 13 are ordered to stand part of the bill. Clause 14.
Management plan for each protected area.
Amendment proposed. Chairman.
Clause 14, amendment proposed, subclause 4, line 2, delete, reviewed, and. So the new rendition will be a management plan prepared in accordance with subsection 3 shall be approved by the Commission before implementation by the Division.
The amendment is for the consideration of the House. I'll put the question. All in favor of the proposed amendment, say aye. Aye. All against, say no. The ayes have it. The amendment is carried. Item III, also on clause 14.
Mr. Speaker, subclause 5, line 1, delete 5 and insert 10. So an approved plan shall be evaluated every 10 years and may be modified.
And why do you prefer 5 to 10? Tell us.
Mr. Speaker, okay.
Yes, he hasn't finished his motion, so let him tell us why he prefers 10 to 5.
Mr. Speaker, in 5 years, there will be much changes in the management plan. So we plan that in 10 years, I think there will be enough changes for review. Thank you.
Very well. Yes.
With respect to my chair, who I know is very passionate on these matters, I find that a bit arbitrary. 5, even though there's a difference, 5 and 10 there's a difference. Why won't he say 7, 8, but 10? What is it based on? Is it scientific or what is the standard practice? I don't know. The Honorable colleague that is looking at me. Maybe he'll be able to profess some reasons. I'm just curious to know why 10, but not 9, 8, when you are moving from 5.
I think he has already offered the answer. He said he expects that sufficient changes would have been made within 10 years, then it would be made in 5 years. Unless you think we should take it to 15 years. Yes, honourable members, the proposed amendment is for the consideration of the House. I'll put the question. All in favor of the proposed amendment, say aye. Aye. All against, say no. The ayes have it. The amendment is carried. Now the question is clause 14, as variously amended. Shall stand part of the bill. All in favor, say aye. Aye. All against, say no. The ayes have it. Clause 14, as variously amended, is ordered to stand part of the bill. Clause 15.
Liability for damage.
There's no advertised amendment to clause 15. In the absence of any proposal to amend clause 15, the question is, clause 15 shall stand part of the bill. All in favor say aye. Aye. All against say no. The ayes have it. Clause 15 is ordered to stand part of the bill. Clause 16.
Establishment of community resource management area.
Amendment proposed. Chairman of the committee.
Mr. Speaker, clause 16, amendment proposed, subclause 1, line 4. Before May, delete community and insert area. So the new rendition will be a geographically defined area outside a protected area, which is endowed with sufficient resources and where the community is organized for the purpose of sustainable resource management, the area may be established and managed as a community resource management area.
Other members, the proposed amendment is for the consideration of the House. Yes, Chairman.
Mr. Speaker, it will be right for the chairman to educate us as to why they are changing, is proposing to change or delete community and to replace it with area. The way he read it, I cannot understand why we are changing the name. So it would be right if he can explain to us, because I think geographical community still makes sense, unless it's not defined to reflect it. But can you please explain to us why you want to delete the name, the word community, and replace it with area?
Mr. Speaker, it is not the complete community that is to be managed. It's an area within the community. That's why the community should give way to the area. Thank you.
Yes, Honorable.
Thank you, Mr. Speaker. Mr. Speaker, I have looked at the proposed amendment, and my view is that the replacement of community with area is not necessary. We'll take off the community and not replace it with anything, and the meaning will still be same. And I wish to read my proposal: a geographically defined area outside a protected area. So the area is already captured, which is endowed with sufficient resources, and where communities have organized themselves for the purpose of sustainable resource management may be established. So you don't replace the community with area, and you still have the same meaning.
If you delete the community and you insert area, there's another area at the end.
Yes, it's too much.
It rather introduces confusion. Yes, Honorable Minister.
Thank you, Mr. Speaker. Mr. Speaker, I heard my colleague, the Honorable Collins, the order. And, Mr. Speaker, I think we have to be aware that it is not just establishing the establishment of the community resource area, but its management as well. So if we take this, what about the management or the management aspect? Mr. Speaker, that will be out. And it's important that at least we add that as well.
Yes, Honorable.
Mr. Speaker, the title of that clause is Establishment of Community Resource Management Area. And the opening sentence says a geographically defined area outside a protected area. And you are saying that we should take the community and replace it with area. And I'm saying that if you take the community and you don't replace it with area, you have the same meaning, nothing will change. I think the area has been used too many times in this particular.
In fact, I think it is good as it is. You are establishing a community resource management area. That is what we are establishing. And then we are defining what and how an area can be called a community resource management area. I think as it is, without any amendment, this is sufficient. So rather, I'll suggest that you abandon your proposed amendment, Chairman. Yes, I want to hear you, Chairman.
Mr. Speaker, I have no objection to that.
Well, so let's go on to item V. You have another proposed amendment.
Mr. Speaker, clause 16, amendment proposed, subclause 2.
Very well. I think somebody else has something to say on the same. Yes.
Mr. Speaker, is it a case that the chairman is abandoning the whole amendment? Is that the case?
Yes, that's what my suggestion. He agrees with me that.
Mr. Speaker.
Yes, please.
The community must go as proposed by the committee. But instead of replacing it with area, we don't do that. We'll take away community. We don't replace it with area. And that will give us, yes, a better rendition.
Why do you want to why do you want to remove the community?
Mr. Speaker, if you put the community there, the meaning doesn't come out well. Because community has already been used. And where the community is organized for the purpose of sustainable resource management, the community may. So if you take out that community, you are still okay. Yes, you are still okay.
Let's go through again. The headline, establishment of community resource management areas. That's the headline. 1, a geographically defined area outside a protected area which is endowed with sufficient resources and where communities have organized themselves for the purpose of sustainable resource management may be established and managed as a community resource area.
Exactly.
And it says if you remove the community, then it becomes may be established and managed as a resource management area.
Yes.
The danger is that somebody from outside will come and take it. It's a resource management area. But the intendment is for the place to be reserved as a communities area. So I think we should retain it as it is, so that you rich people will not go there and with the head office go and take it from the communities. And yes, leader.
Mr. Speaker, I agree with you perfectly on this matter, Mr. Speaker, because the emphasis should be on the community. And it's only right that the community is maintained. It shouldn't be deleted. Thank you, Mr. Speaker.
I think we should leave it as it is. Yes, Chairman, let's go to, yes.
Mr. Speaker, I kindly would indulge you to do a second reading if we keep the community. We'll do another reading of it, the same clause, if we keep the community, whether it makes sense. Mr. Speaker, a geographically defined area outside a protected area which is endowed with sufficient resources and where the community is organized for the purpose of sustainable resource management, the community may be established. The community may be established and managed.
No, then the community is there, but we want an area reserved for them. We want the area reserved for them to manage. So the community...
Without the community, you have the same meaning. With the community, I cannot understand how the community may be established. If you look at, there's a comma after management.
No, I don't know which one you're reading, 16.1.
Yes, 16.1.
May be established and managed as a community resource management area. There's no comma anywhere.
I have a comma here, then the community.
No, I think we...
Oh, you are reading... Mr. Speaker, I guess you are reading the one which was withdrawn.
Wildlife Resources Management Bill 2022, that's what I'm reading. Is that what we are working with?
2022. There's one which was withdrawn.
Which one?
2022. This one to 2022. There was one which was... There was one which...
So, which of us is using the wrong one? Yes. Let's go through them again because it's, for me, it's the same thing. Okay, let me hear other people. I'm getting. I'll come to the film. Let me listen to Sanjay Nanja.
Mr. Speaker, thank you. I was thinking that the B may be established. The B should be deleted, so that it will be read as the community may establish and manage a community resource management area. You see, if you read it, the community may be established. If you read it fully,
yes,
Speaker, thank you for the opportunity. Speaker, let me persuade the Honorable Collins Dawda to disengage and on grounds of having recourse to the definition of the community resource management area. It's assumed a term of art, so it's been defined. It says, a community resource management area means a geographically defined area endowed with sufficient resources where residents of a local community have organized themselves for the purpose of sustainable resource management. So this is not in reference to human settlements as it appears is being conveyed, but it is to determine a certain geographical area which may contain several settlements. So if you read the definition, it gives purpose to the provision, and so it has to stay the way it's been crafted in the bill.
I'm now actually, since I got the proper one, what I was using was the withdrawn one. Now I'm looking at the proper one. The amendment makes sense. The area, the community may be established. No, is the area may be established as a community resource. Yes, I think the amendment makes sense. If you delete the community and insert area, then it makes sense because you're defining the area which you will call the community resource management area. So I think that the chairman's amendment makes sense. Yes. Chairman, you may move your amendment now.
So, Mr. Speaker, subclause 1, line 4, before may, delete community and insert area.
All in favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Now, item V. Chairman.
Subclause 2, clause 16, subclause 2, paragraph E, subparagraph 1, delete and insert the following. I, traditional decision-making structures, and 2, local land tenure system in the area for which the community resource management area is established. And
members, for the consideration of the House. All in favor of the proposed amendment, say aye. Aye. All against, say no. The ayes have it. The amendment is carried. Now I'll put a question, and the question is clause 16, as variously amended, shall stand part of the bills. All in favor, say aye. Aye. All against, say no. The ayes have it. Clause 16, as variously amended, is ordered to stand part of the bill. Clause 17, 18, 19, 20, and 21. There are no advertised amendments, so you may read ahead notes so that I'll put the question on them.
Functions of an executive committee of a community resource management area. Role of traditional authorities in community resource management area. Protection categories for wild animals. Wildlife use rights. prohibition of utilization of wildlife without wildlife use rights.
Honourable members, all in favour of clause 17, 18, 19, 20 and 21 being part of the bill, say aye. All against, say no. The ayes have it. Clauses 17, 18, 19, 20 and 21 are ordered to stand part of the bill. Clause 22.
Types of licenses and permits.
Amendment proposed. Chairman.
Clause 22, amendment proposed, subclause 2, paragraph A. After import, insert wildlife end. So, Mr. Speaker, the new rendition will be, a permit may be granted for the following activities. A, to export, re-export and import wildlife and wildlife products.
All in favour of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Now the question is clause 22 as amended shall stand part of the bill. All in favour, say aye. All against, say no. The ayes have it. Clause 22 as amended is ordered to stand part of the bill. Clause 23.
Application for license or permits.
Amendment proposed. Chairman.
Clause 23, amendment proposed, subclause 11, line 2, after May, insert within 14 days. Mr. Speaker, the new rendition will be a person dissatisfied with the decision of the Commission made under subsection 6 may within 14 days appeal to the Commission for a review.
Yes. Yes, Chairman.
Mr. Speaker, why 14 days, not 21 days? And Mr. Speaker, this is because you are going to appeal, and why 14 days? Why can't you extend the date? Because 14 days is a bit too short. Can you make it say 30 days or 21 days? Is there any reason why you are using 14 days? Can the chairman explain why 14 days, Mr. Speaker?
Yes, Chairman. Why do you prefer 14 days and not 21 days? What is the regular period for appeal for lawyers?
Mr. Speaker, we had some stakeholders who joined us, and they think 14 days is enough time for the person to appeal.
Yes, Honorable Afemapo, you are a member of the committee. Why 14 days and not 21 days?
Speaker, unfortunately, I'm not a member. But
very well.
Yes, but I have in my hand Plant Variety Protection Act 2020, and provision and appeals when a license. I believe that in respect of appeals, 21 days, it gives the person more opportunity to be able to do so. I don't see the rationale why we are reducing that to 14 days.
The wildlife one, the plant protection is how many? 21 days?
No, we didn't indicate 21 days. Yes.
You didn't give any time?
Yes. But now, going forward, we are placing timelines.
All right. But if it is an application for refusal of a license, it means that all the information is gathered already before you applied for the license. So appealing is...
Speaker, you see, its processes, they are such that there may be peculiar circumstances. You may put in the application and perhaps travel. So don't say, oh. So between the time of the decision and when you are, if you return and the statutory time period is gone, you may lose out. So reasonably, we could say 21 days. It's to enhance the legislation, Mr. Speaker.
Yes, Chairman, do you have any specific objection to 21 days?
Mr. Speaker, I think 14 days is enough because we have given the same 14 days for the office to also respond. And I think 14 days, most of these, they are companies, not individuals. So I think 14 days should be enough.
Yes.
Mr. Speaker, the fact that the applicants are companies even makes it worse. Mr. Speaker, this is because of the bureaucracies within companies. And some companies' approval levels takes you all the way to the board level. And so it is important that you can extend the time in such a way that they will have enough time to appeal. Mr. Speaker, if it's an individual, he can easily appeal the next day. But in this case, you are saying it's a company. And you know the bureaucracies within companies and reporting mechanism. I think 21 days for appeal will be ideal. But Mr. Speaker, I'm not pushing it that much. I'm only making an appeal that if you are requested to make an appeal, 21 days will be a good time. Thank you, Mr. Speaker.
Yes, Honorable Minister.
Thank you, Mr. Speaker. After listening to the debate, Mr. Speaker, I think we'll take the 21 days. But the 21 days will be for the applicant. But then the institution must be forced to do the right thing. You must ensure they do the right thing. So DS will be within 14 days. But for the applicant, at least the 21 days period should be okay.
Well, yes, quite as so.
Honorable Speaker, respectfully, I think in an era where we want to expedite processes, if we give opportunities for lengthy periods, I don't think it's even going to augur well for the applicant. So for me, reasonably, within 14 days will even make the applicants be content, because then the applicants will want it to be done quicker for them. Now we are talking about bureaucracies, inefficiencies. Why do we want to hide behind bureaucracies and inefficiencies to delay a process? So I think that, and also in the era of digitization, I think that within 14 days is reasonable enough. Then we can as well go to 100 days if the argument is to lengthen the process. So it's not for that thing that 14 days is reasonable. Thank you.
Yes.
Speaker, let me refer the House to the Plant Variety Protection Act. Mr. Speaker, I just discovered that under the appeals provision, which is Section 55(2) says that a person aggrieved by a decision or order made by the registrar may appeal to the appeals board by submitting to the appeals board a notice of the appeal within 60 days after the publication or receipt of the notice of the decision. We speak of a decision that may deprive a person of not being given a license. And so he must have the statutory time frame within which he should be able to appeal the decision that he is aggrieved against. So I think that this House has given 60 days under this law. So 21 days, Mr. Speaker, or even 30 days is reasonable enough. The Honorable Deputy Minister, you are huffing and puffing, but we speak of a decision to deny somebody a license. So please, let's enlarge the time within which the person can appeal. It's an appeal that the person must have the right to appeal again. So I think that we should enlarge that time frame.
Yeah, you have the last word, Honorable Deputy Minister. Yes.
Thank you, Mr. Speaker. Mr. Speaker, thank you very much for the opportunity. Yes, but if you look at the whole of 23, it talks about application for license or permit. And 2, 3, 4, 5, 6 of that clause plus 7 details are the process. For example, 2, the application shall be accompanied with the prescribed fees and any document determined by the Commission. 3, the Commission shall, within 7 days after receipt, and there's also a report that is to be given. If that is 6, the Commission shall consider the report and may grant or refuse the license or permit. So if you are denied, or you are denied the license and you are dissatisfied, I guess before you make the appeal, you must be seized with some of the reports, the reports based on which you were refused. And you know our bureaucracy, Mr. Speaker, to go through the bureaucracy, get these reports and recommendations will take time. And therefore, 14 days certainly may not give you the reports that you require based on which you can make your appeal. And so it is better to look for more days than this 14 days. I will suggest 30 days. $30 days.
Yes, honourable members, I have the amendment was 14 days now. The leader proposed 21 days. Honourable member, former minister, is now proposing 30 days. Yes. Now, what is your? Yes, honourable deputy minister, now I hear you.
Thank you, Mr. Speaker. Mr. Speaker, I think we'll take the 30 days. It's not going to cause any harm. Let's accept it and then go ahead.
Very well. So the amendment will now insert within 30 days. Is that right? Subparagraph 11, line 2, after may insert within 30 days. All in favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Now, item VIII. Yes, sorry. Chairman, hold on.
If you may indulge me, subparagraph 9 of 23, where it says the commission refuses to grant a license or permit, the commission shall communicate in writing the reason for the refusal. So I don't know if there should be a duration within which that writing should be communicated to the applicant, because I think that is left vague.
Only take it from 7.
Yes.
The commission shall, within 10 days after the receipt of the report, inform the applicant in writing of the decision. So the time period is provided.
I'm guided.
Yes, Chairman, you may move item VIII.
I'm bringing some takeaways.
Clause 23, amendment proposed. Add the following new subclause. As 12, the Commission shall, within 14 days after receipt of an appeal for review the decision and communicate the response to the applicant.
Yes. For the consideration of the House.
Speaker, yes, but regrettably, let me take you back to the amendment needed by...
Let's finish with this one. We have moved this one. Let's item VIII. Let's move that first. Honourable members, the proposed amendments for the consideration of the House. All in favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Now let me hear you.
Mr. Speaker, if listening to my leader regarding its submission on the subclause 9 and 23, I suppose. No, under 23. If if we maintain that the Commission shall within 10 days after receipt of the report inform the applicant in writing of the decision of the Commission, then I think that the existence of clause 9 is surplusage, because clause 9 says where the Commission refuses to grant a license or a permit, the Commission shall communicate in writing the reason for the refusal. Because I think this is implied in 7, that the Commission shall within 10 days after receipt of the report inform the applicant in writing of the decision of the Commission. The decision could be a refusal or a grant.
I think, yes, indeed, you're right.
Yes, so in my...
So, the 9 may not be necessary, because the 7 actually takes care of that.
So leader is right.
Yes. So,
thank you very much.
It's the same thing that the 7 is saying. Whatever decision you came to, whether you grant or you refuse it, you communicate it in writing. Is that right?
So, Mr. Speaker, I think the 9 can be off.
Okay, our draft person is advising me differently. It's suggesting that whereas 7 says communicate the decision, there's no compulsion to provide reason for the decision. So, in her view, or they suggest that we maintain the 9 so that whatever decision you communicate as a result of 7, you must give reason for refusing it. So 7 says communicate the decision in writing, but phase 9 says the writing must include your reason for refusal. Otherwise, if you just write, application is refused without giving reasons, and that's communication in writing. But when you write, then you must give the reasons, and that is what 9 covers. That's the draft person's advice.
Speaker, thank you. Speaker, I agree with the reasoning of the draft person, but we also advise that in legislation we must be effective and economical, so that we can then transfer the phrase containing the reason with in writing the reasons for the refusal, and find a place for it in 7 and take out 9.
I'll direct the draft person to consider whether it is practicable to do that. Yes. Now, clause 23 adversely amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 23 as variously amended is ordered to stand part of the bill. Clause 24.
Revocation or suspension of a license or permit.
Yes. Amendment proposed. Chairman.
Clause 24, subclause 4, line 2, after may, insect within 14 days. I don't know whether this will not change to 30 as the previous one. So please, we make it within 30 days.
Very well. All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item X.
Add the following new subclause. 5. The Commission shall, within 14 days after receipt of an appeal for review, review the decision and communicate the response to the applicant. You say?
All in favor of the proposed amendment say aye. All against say no. The amendment is carried. Now put the question on clause 24 as variously amended. And the question is, clause 24 as variously amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 24 variously amended is ordered to stand part of the bill. Clause 25.
Keeping of wild animals.
Amendment proposed. Chairman.
Clause 25, amendment proposed, subclause 4, paragraph A, subparagraph 1. I. Line 1, delete a species and insert species. Species.
Honourable members, the proposed amendment is for the consideration of the House. All in favour of the House adopting the amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Item XII.
Mr. Speaker, in the two other paragraphs, we have the same correction. Species should go for species.
All in favour of the proposed amendments contained in item XII and XIII, say aye.
Aye.
All against, say no. The ayes have it. The amendments are carried. Now I'll put the question on clause 25. The question is clause 25. Honourable, kindly turn on your mic. Yes.
Speaker, let me bring this matter. Speaker, in reading 25, the House seems to be mandating the chief executive. For instance, 25(1), it says a person shall not keep a wild animal if that person has not been issued with a license for that purpose by the chief executive or an authorized representative of the chief executive. The Speaker, know that our practice has been to inherit in the board those powers and not the office holder. And so I have a problem in crafting the legislation this way. I have a problem because it's the board that will make those decisions. And in this case, even the grant and or refusal of license is inherent in the commission. Is inherent in the commission. And so if we are asking the chief executive or we are giving these powers to the chief executive under 25, I find it a bit problematic. Why we are leaving the commission and now saying the chief executive, so that in my opinion, a person shall not keep a wild animal if that person has not been issued with a license for that purpose by the commission or an authorized representative of the commission. Thank you very much.
Yes, Honourable Minister.
Thank you, Mr. Speaker. Mr. Speaker, in going through the winnowing process with the various stakeholders also present, we were very, very much concerned about the fact that these is like grants of natural resources to people, because these animals, in some way, are natural resources of the nation, and the person who has been mandated is the president, and the president also delegates the minister to act in his stead. So we were very careful. The chief executive is working under the instructions of the minister upon approval by the minister. So if we say we are bringing in the board, and then it will be like, just like we have our mineral rights also as well. Is it a board that grants mineral rights? No. So, Mr. Speaker, that was the reason behind our thinking.
The boards actually will approve the rules and regulations, but the administrative part of issuing the license should be management, and therefore the chief executive is the appropriate one. Management, that is the administration part, but the policy and the rules will be approved by the board. But this one is the administrative part. So the chief executive would be the appropriate person. And if he authorizes somebody else, then he will still be ultimately responsible. I think that's appropriate. So yes.
Speaker, I wish that the minister's explanation would convince me. But it hasn't, because, Mr. Speaker, if we look, so are we saying that under 25, what do you require to activate the activities under 25? Is it not a license? Is it not a license? It is a license granted by the commission as in 24, or it is a different license that we speak of. I need that clarification to be carried along. Because if the commission's license will permit me to keep these animals, then, so my difficulty is, then why am I being told under 25 that if I'm not permitted by the chief executive or his representative, I cannot keep the animal? That's my difficulty.
If you look at the main headings, management of wildlife in captivity, right? So then you come to the place before 25, management of wildlife outside protected areas. So you're looking at different ones. Yes. So I think that this one is looking at one person keeping a wildlife as a pet in his home. The circumstances are different.
Speaker, I'm guided.
All right. So clause 25 as variously amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 25 as variously amended is ordered to stand part of the bill. Clause 26.
Artificial propagation of plants.
Clause 27.
Establishment of private zoological gardens and private wildlife sanctuaries.
Clause 28.
Implementation of sites.
Clause 29.
Functions of the site National Scientific Authority.
Clause 30.
Executive Director of the Division.
Clause 31.
Functions of the Executive Director.
Honourable members, there are no advertised amendments to all the announced clauses. I'll put the question. All in favour of the said clauses being a part of the bill, say aye. All against say no. The ayes have it. Clauses 20, 26, 27, 28, 29, 30, and 31 are hereby ordered to stand part of the bill. Clause 32.
Staff of the division.
Advertised amendment and chairman.
Mr. Speaker, clause 32, amendment proposed, subclause 3, delete. That is, the minister may appoint honorary wildlife officers in accordance with modalities prescribed by regulation. We want it deleted. The reason being that we don't want the minister to appoint people as honorary officers, because after a little while, when the minister is changed, these people may also be changed, and we didn't want that discretion for the minister.
Honourable members, for the consideration of the House. All in favour of the proposed amendment say aye. Yes. Honourable Minister. Yes.
Thank you, Mr. Speaker. Mr. Speaker, we looked at various jurisdictions where this particular wildlife act exists, and we saw that in those jurisdictions they had what we term as honorary wildlife officers. Mr. Speaker, we have, like in UK, you have people who have dedicated all their life to help protect and conserve wildlife. These people are not public officers, neither are they people who are staff of the Wildlife Agency of the UK. But everyone in UK know that that is their dream and their passion. These people, nothing stops the minister from granting them honorary wildlife officer status. Mr. Speaker, the word honorary has a meaning. So what are we scared of?
Do you have any such person in Ghana? Have any such person with passion for keeping and protecting and guarding wildlife in Ghana?
Yes, Mr. Speaker, we have some existing in Ghana. But then because for all these years, we never had a wildlife bill or act. Those people, although they do their advocacy around, they are not heard.
Without being appointed, they are able to do it. Well.
No,
so why do you want to compound the problem by introducing honorary around their name? And
once you appoint and then you grant them that status, then you can restrict them and then also they become liable. So it's important. Mr. Speaker, we have friends of river bodies, we have friends of timber or trees. We can also have friends of monkeys, friends of elephants.
Has the ministry appointed friends of river bodies? Has the minister appointed any? He has not, but they are able to operate without your appointment. So why do you want to bring challenges to the public service by appointing people honorary? They may soon apply for compensation in this country. Other members, the vote was that we should delete. So, Clause 32 is ordered to be deleted from the bill. Clause 33. Sorry. Clause 32, subclause 3 is ordered to be deleted from the bill. In that case, I'll put a question on clause 32. And the question is, clause 32 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 32 as amended is ordered to stand part of the bill. Clause 33.
Power to arrest without a warrant.
Clause 34.
Indemnity for acts done in good faith.
Clause 35.
Offences by a wildlife officer.
Clause 36.
Other offences.
Honourable members, there are no advertised amendments to the aforementioned clauses. I'll put the question. All in favor of the aforementioned clauses being a part of the bill, say aye. All against, say no. The ayes have it. Clauses 33, 34, 35, and 36 are hereby ordered to stand part of the bill. Clause 37.
Regulations.
Yes, Chairman, amendment proposed.
Clause 37, subclause 1, paragraph K, delete. Thus, K is implement international conventions which relate to wildlife and to which Ghana is a signatory and has ratified.
Other members for the consideration of the House. All in favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Now, clause 37 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 37 as amended is ordered to stand part of the bill. Clause 38.
Interpretation.
Amendment proposed. Chairman.
Clause 38, interpretation of honorary officer. Delete.
All in favor of the proposed amendment say aye. All against say no. Yes, Honorable Minister, we have removed the honorary officer, so there's no need to keep its interpretation in the bill.
Minister, sorry, Speaker, Mr. Speaker. Mr. Speaker, I'm very sorry. But then, you see, they even had an interpretation for the honorary officer. And, Mr. Speaker, what it meant is that with best practices, we are trying to have better legislation, better laws. And we are copying from those who have had these legislations pertaining in their jurisdictions all these years. And they have found it worthwhile to have an honorary officer.
Let me
so, Mr. Speaker, we can even remove the officer. If it's the officer that is carrying the house, we can say an honorary friend.
Let me share an experience with you. I was being driven around a certain area in New Jersey. Then one of these big wild animals just blocked the road, and for about 8 to 10 minutes we were standing there watching the animal standing in the road. Then the driver said, "You're just lucky to have been given birth to abroad. You see that by this time you'll be in our soup." This is the kind of honorary awards you want to give to people like that, you know. But once the clause assigning that role has been deleted, there's no point in keeping the definition there. So it's just a matter of course. So, yes.
Speaker, thank you for the opportunity. Mr. Speaker, this is a very important legislation. And I think that I want to draw the attention of the draftsmen to two provisions that this House accommodated in the plant variety protection law. Mr. Speaker, if you look at that law, there are two provisions on varieties bulletin. Mr. Speaker, the provision on the variety...
Kindly let us finish with this interpretation clause.
Mr. Speaker, I thought we were done.
No, we are not done.
With the honorary officer matter?
Yes, let's finish with that one. Yes. So, interpretation of honorary officer is hereby ordered to be deleted from the clause. Now, item XVII.
Clause 38, amendment proposed. Interpretation of license. Delete and insert the following. License means a written authorization granted by the Commission for the activities specified in Section 1 of subsection 22.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Yes, item XVIII.
Add the following new definitions. District Assembly includes a municipal assembly and a metropolitan assembly.
All in favor of the proposed amendment say aye.
Mr. Speaker,
all against say no.
Mr. Speaker, I haven't finished.
Oh, okay. It's a continuation down there, yes.
Ecosystem services means the processes and inputs that nature provides to the
humans,
including provisioning services, regulating services, and supporting services, cultural services, as advertised on page 30 of the order paper.
Very well, honourable members. The interpretation of ecosystem services as defined is for the consideration of the House. All in favor of the proposed amendment say aye. All against say no. The ayes have it. The interpretation as advertised of ecosystems is hereby ordered to stand part of the bill. Now, clause 38, as variously amended, shall stand part of the bill. Oh, yes.
Speaker, I want the chairman to consider the interpretation of hunt. And hunt. Under 38, you say hunt means kill, injure, shoot at or follow an animal. B, willfully or recklessly disturb or molest an animal by any method. But then, Mr. Speaker, there is a provision in this act that gives license to hunt. But you are describing hunt as molestation as well. Is it the case that you are saying that you can give a license to somebody to molest animals and other things? Why would anybody give a license for you to shoot to kill for a purpose? I can understand. But to molest, and in fact use the word recklessly. I wonder why anybody will give a license for you to go and recklessly molest an animal. Why would you want to do that? I know you can get a license to go and shoot as a sport or whatever. Then that one you have terminated the pain and everything. But to say to recklessly, willfully or recklessly disturb, molest an animal by any method. So you can be given a license to go and set fire to the leg of an animal and say that you have got a... I think there's something wrong with this. I don't believe you can give a license to anybody to molest an animal. Yes, yes.
Yes, Honorable Minister.
Thank you, Mr. Speaker. Mr. Speaker, I can understand the honorable member's concern regarding the B. That is the definition under B. Willfully or recklessly disturb or molest an animal by any method. Yes. But Mr. Speaker, apart from there being the provision for you having a permit to hunt, what about, I know there is a provision also in there for illegal hunting. Although it says permit to hunt, what about illegal hunting? So it's the word hunt that we are defining here.
So if I molest a wild animal without killing it, would you say I've hunted it? If I disturb a wild animal without killing it, you charge me with hunting. That's the definition here. Whether it is reckless or, let's say, for those of us who like driving, you're driving through a forest area. An animal was otherwise crossing the road, but because of the speed of your vehicle, you startle it. You have disturbed it. Would you be charged with hunting by this definition? Yes, Doc.
Yes, I think that's rightly so, because we are talking about wildlife, and that is why when you go to areas where there are game, you would always see that there are enough warning signs. Sometimes you are told not to hoot. Sometimes you are told not to make certain noise beyond a certain decibels. Sometimes you are told not to drive beyond a certain speed. These are all part of the things that are to be regulated, so that the ecosystem of these wildlife will not be disturbed. Mr. Speaker, if you look at the B part of the definition of hunting, willfully or disturbing, you may find a situation where a mother animal may be in a certain area with offspring, and any disturbance that will make the mother flee would expose the offspring to danger. And so, technically, if you are talking about wildlife, then hunting is not limited to just the act of killing, but anything that practically disturbs the ecosystem of the animals.
Kidnapping the baby.
Yes. Speaker, if my colleague reads 22 and head note, it reads 22.1. A license may be granted for the following activities: A, to hunt or capture any partially protected animal. And I'm asking that, so you are saying the state would grant a license to hunt, and your definition of hunting includes willfully molesting animals, and I'm saying that the state cannot possibly grant you a license to go and molest any animal. That is the point I'm making. I'm not talking about the 38 completely. I'm saying that particular one, I can't see how you will be given a license to willfully molest an animal. Yes, to kill, it happens, yes. You can hunt and have a trophy. It happens as a way of tourism and everything. But I can't see how you will grant a license to anybody to go and molest, disturb a wildlife. That particular one needed to be deleted, Mr. Speaker. Exactly.
Yeah, so the draft person is suggesting that we break the definition of hunt into two. The A is hunting, then B will cover illegal hunting. Is that acceptable? Very well. Yes, Honorable.
Thank you, Mr. Speaker. Mr. Speaker, I think to give more meaning to the word hunt, we should add capture.
Yes.
Kill, injure, capture.
Yes.
Yes, Chairman. Okay, so hunt will mean kill, injure, shoot, or follow an animal, and he's suggesting we add capture. All right. But then illegal hunting will be willfully or recklessly disturb or molest an animal. In that case, kill should also be added. Yes. Shoot, kill, all be added to illegal. We will leave the draft persons to fill in the gap, but
Mr. Speaker,
capture has been added to hunting.
Should also be added to the definition under illegal.
Very well. So the draft persons will take note and capture it appropriately, not the illegal hunting capture. That's all right. So clause 38 as variously amended. Yes, Leader.
Mr. Speaker, thank you very much. The hunt as defined now, when you were reading the word kill, injure, shoot at, or follow an animal. You kill, injure, shoot at, or follow an animal. When you say follow an animal, what will be the relationship between following that animal and killing that animal, or following that animal and injuring that animal? So we further may have to refer that to the draft person, because the rendition there says kill, injure, shoot at, or follow an animal. Now, if you shoot at, if you injure at, I can't see the relationship between injure at and follow.
and follow an animal. There must be something fundamentally wrong with the construction of the language there. Thank you.
Yes. Once we are agreed on the term, the draft persons will capture the appropriate and acceptable international definitions as covered. Yes, Honorable Dr. Mafu.
Yeah, Speaker, I can see the problem that leader is trying to say, but I think that the way the rendition there can stand. Again, we are talking about wildlife, and if you know the practice of how young people chase rats in this country, or they chase animals, you see the way they follow them. So it's all part of the effort to catch the animal. I think the definition is trying to prevent any action that will not only kill, but also any action that may lead to you, perceiving that wildlife in a way that will disturb it or may make it easier for you to kill it. So I think the definition should be right. Thank you.
Speaker, I agree with leaders' view on the meaning we seek to place on follow an animal. I think that the appropriate word will be to track. And also we must also include the word poach. To poach under hunting. If we want to define the word hunt in the law, we should include poach. Yes. So the drafters should find a way to include poaching as part of the definition. And also replace follow an animal with the word track. Yes. No, for purposes of the hunting. It's not follow. So I do believe that I cannot be following an animal. You are tracking an animal.
Yes.
Mr. Speaker, I agree as well. Mr. Speaker, a classical example is if you see fox hunting, which is a normal thing they do in the UK, where they use hounds, a type of dog to chase. Many of the times, it's just fun to use the dogs to chase track and chase the foxes out of their hiding and see them running, people running. Hardly do they actually kill them, but the law allows them because foxes are not like endangered in the UK, you can kill them. So they use the word, as they said, tracking and chasing. It connotes the fact that there could be differences between tracking and chasing. So instead of using following, I agree that we could use a different rendition instead of following, because following doesn't, follow properly. So if the chairman doesn't spoil anything, we can introduce those as recommended.
Is that agreeable to the House? All in favor of the proposed amendment, say aye. Aye. All against, say no. Ayes have it. The amendments are carried. We shall leave those parts to the draft persons to tidy up, and appropriately capture it in the bill. Now the question is, Clause 38, as variously amended, shall stand part of the bill. All in favor say aye. Aye. All against say no. The ayes have it. Clause 38, as variously amended, is ordered to stand part of the bill. Yes.
Speaker, thank you. Speaker, I believe on Tuesday, we carried an amendment in respect of Clause 1. Under Clause 1, lines 2 and 3, we deleted the phrase "and in trust for." Mr. Speaker, let me draw the House attention to Article 257, Clause 1 of the Constitution. All public lands in Ghana shall be vested in the President on behalf of and in trust for the people of Ghana. Mr. Speaker, that's a constitutional language. And so the drafters discovered that omitting this from the legislation will have some effect it will be that we are amending the constitution. So we need to bring that that phrase back, the one we deleted. And so if the...
Which clause are we referring to?
Mr. Speaker, we are referring to clause 1, lines 2 and 3, where you see an interest 4. Yes.
Yes, Chairman.
Mr. Speaker, the deputy leader made that amendment and later he conceded that it should be as it is. So I think, yes, so, yeah.
Very well.
Mr. Speaker, is reflecting he has been deleted, so I'm guided. Mr. Speaker, the other matter that I want to draw the House's attention to is that if we go to the Plant Variety Protection Act, which this House enacted in 2020, two very important and forward-looking provisions were incorporated in that legislation by this House. Mr. Speaker, I refers to the Varieties Bulletin, which is Section 57 of that law, as well as the publication of notices and information, Section 58. The rationale that we considered in making these provisions is that if you have regard to the schedules attached to the bill, Mr. Speaker, very, very instructive. If you look at the first schedule, Mr. Speaker, is titled Fully Protected Animals. And Mr. Speaker, in that schedule, you see it says Series A, mammals, then their scientific names. They are all captured in a certain chronological order. And then we have Series B, which is reptiles. Then Series B, birds, and all that, Mr. Speaker. If we go to the second schedule, it also has animals in that category as they reflect in the first schedule. So my humble view is that as we did, it's a drafting style that we adopted in the Plant Variety Protection Act. So we made a provision that these animal varieties, there will be a publication of their names in a certain, of the notices and the information in a certain register. And then we are also saying that there should be a certain bulletin where these variety names are also published. So that, for instance, under the Section 57 of this law, it's 57.1 says there is established by this Act the varieties bulletin which shall contain matters related to this Act. So we are saying that the animal varieties for which we are crafting this law there should be a bulletin in which they will be published, as we have done in the schedule, their names and their scientific names and in that order. Then we are also saying that the persons who will be granted their licenses, there should be a publication of the notices and information of those who have been granted the license by the Commission, so that we know the people who are licensed to either breed the animals or just deal with these varieties. So
I think the regulations can take care of these things.
No, Mr. Speaker, I think the model adopted in this law, I think is very important. So I'm not saying we can, but the House can just direct the drafters. There are standard provisions that they can simply borrow from this law and just incorporate it.
Okay, let me finish with the consideration of the bill now.
Very well.
So we'll go to clause 39 and clause 40. There are no advertised amendments to this clause.
Very well, Mr. Speaker. Thank you.
Please, clause 39.
Transitional provisions.
Clause 40.
Repeal, revocation and savings.
Honourable members, there are no advertised amendments to these two clauses. All in favour of these clauses being a part of the... All against say no. The clauses 39 and 40 are ordered to stand part of the first schedule.
Fully protected animals.
All in favour of the first schedule being a part of the... Yes, Leader.
Speaker, 39. Just maybe probably the chair and the policy sponsor to explain. A management area recognized by the division and existing prior to the coming into force of this act shall subject to necessary modifications to bring it into conformity. Necessary modifications. Do you need to bring the words to bring it in with this act? Be considered as having been established under this act. Now, when you say to bring it into conformity, I have a difficulty with it. There existed some legislation prior to this act, which provided for what was declared a management area. Why do you want to necessarily compel that the modification must sit in with this act? If you are saving, save. But if you say in conformity, so if it is not in conformity, Mr. Speaker, then it means we are throwing it off the window. Then what are you saving? Because the essence of savings and repeal is to recognize acts done before the legislation protecting them. So if you are now going to protect and say that I'm only going to protect those that are in conformity with this new act, you may not be able to save all the matters that were originally contemplated in the existing act. My thinking. So
is there any existing rule or regulation relating to management area? I thought that was a new thing that was introduced in law. Yes.
Mr. Speaker, 40 talks about the repeal revocation.
Let's finish with 39.
Yeah, what I mean is that if you read 40, it talks about the existence of something called the Wildlife Animals Preservation Act. We don't know the details of that. Maybe that is why they are saying that. But I don't know, but maybe the chairman or the minister can guide us on this.
Yes. Was there previously recognized as resource management areas? Honourable Minister.
Mr. Speaker, we have some management areas, but those ones, there were no legislations backing them because these are new practices that are coming. So I would say with the coming into force of this particular act, then we should conform to everything.
So, Leader, what is point is that there was some practice, not regulated by law, and so the law has introduced a new thing, but the practice should be brought in conformity with the new provision in the law. That is what this is intended to be. Yes.
Mr. Speaker, is the chairman averse to accepting the deletion of the words subject to necessary modifications to bring it into conformity? Those words. It does no harm. It could just read, a management area recognized by the division and existing prior to the coming into force of this act shall be considered as having been established under this act. That will pass as a transitional provision, in my view. But to say that it must be subject to modification.
That is the danger, because what is considered a management area is actually defined.
Abandoned.
That's it. Very well. Honourable, I'll continue. All in favour of the first schedule being a part of the bill, say aye. Aye. All against, say no. The ayes have it. The first schedule is ordered to stand part of the bill. The second schedule.
Partially protected animals.
All in favour of the second schedule being a say aye. All against say no. The ayes have it. The second schedule is ordered to stand part of the bill. A long title.
An act to consolidate and revise the laws relating to wildlife and protected areas, provide for the implementation of international conventions on wildlife to which Ghana is a signatory, and for related matters.
Yes. There is no advertised amendment to the long title, but yes.
Speaker, just to, with your indulgence, the second line, the word implementation, observance, enforcement. Now, Ghana is signatory to many international conventions. Now, when you use the word provide for the implementation of international conventions, what are we seeking to do? Do we want to observe it? When you say implement, I'm not sure, Mr. Speaker, the word implement means observe or enforce. International conventions that are adopted, the practice, as I understand it, is that you come back here and domesticate it into law. Perfect. So what are you implementing? What I just have the word implement. If there is a better word, I rather will go with it. But I just thought that the policy sponsors, you want to implement international conventions. Are international conventions implemented? Thank you, Mr. Speaker.
Yes. Will adoption be appropriate substitution? Provide for the adoption of international conventions. Would that be an appropriate substitution? Yes.
Mr. Speaker, these international conventions have been adopted under this law, like the CITES. And there's a provision that details out how CITES must be managed. And therefore, putting it as, or capturing it under the long title will not change anything. It rather re-emphasizes it. It re-emphasizes what we have done with the passage of the law.
So he's complaining about using implementation. And I'm suggesting, can we replace implementation with adoption? That's a suggestion to the House.
Mr. Speaker, as a country, these international conventions have been adopted already. We needed to domesticate them. And this law is the law that is domesticating it. And therefore, if we use the word implementation, we are adding more weight to it.
Very well.
Thank you very much.
Honourable members, all in favour of the long title being a part of the bill, say aye. All against, say no. The ayes have it. The long title is ordered to stand part of the bill. That brings us to the end of the consideration of the Wildlife Resources Management Bill 2022. Yes, Honourable Deputy Leader. And sorry, Chief Whip.
Speaker, may we now go on to item 6. Speaker, there were earlier statements. I think the Honourable Adelaide, the Honourable Evans Bobier, and then I hear on the other side we have the ranking member for the Committee of Health, and then of course another member. So, Speaker, I don't know the number we can do, but we'll leave this to your discretion. But essentially, we want to take the statements now.
Yes, Honourable.
Speaker, that is in order.
Very well. My attention has been brought to a member's intention to invoke Order 72. Yes, you may make your statement. This is supposed to be a brief statement. Yes.
Thank you, Right Honorable Speaker. I would like to express my profound gratitude to you for this opportunity and to crave your indulgence to come under Order 72 of the Standing Orders of this Honorable House to make this brief statement on an issue of considerable public importance. Mr. Speaker, the issue in question has to do with a reported incident involving the death of 2 fishermen while on sea at the Tema area. In the early hours of today, news broke out within the Tema East constituency of the death of these 2 fishermen who had gone to sea in a canoe in the company of several others. There are widespread reports, Mr. Speaker, to the effect that this incident occurred when a boat belonging to the Ghana Ports and Harbours Authority crossed these fishermen and hit their canoe, thereby causing it to capsize in the process. Right Honorable Speaker, as to be expected, the untimely death of these 2 fishermen has caused considerable agitation within the Tema area. The very inexplicable nature of this incident, in view of the alleged involvement of a security vessel belonging to the Ghana Ports and Harbours Authority, has heightened tension in the area. Many are those angry as we speak, that threatens the security and peace of the area. Right Honorable Speaker, the annual close fishing season, as recently announced, takes cognizance of the annual Homowo Festival of the people of Greater Accra region. As a precursor to the Homowo Festival, the practice known as Wolo, meaning bait fishing, usually takes place in search of red fish, known as Chile Awawu, which is needed for the preparation of pokwe during the Homowo. To this effect, the Tema Traditional Council duly notified the state security agencies about this search party. Bizarre and unpardonable for a vessel suspected to be a patrol boat to have crashed these fishermen for no apparent reason. It is against this backdrop, Mr. Speaker, that I wish to call for an urgent investigation into this incident in order to establish the following. 1. Whether this was a pure accident or targeted attack by the security agents of the GPHA, as has been alleged. 2. Investigate the propriety or otherwise of the action of these security agents vis-a-vis standard operation procedure for such patrols. 3. Recommend sanctions where necessary to anyone found culpable and compensation paid where appropriate. 4. Make recommendations on how these kinds of accidents can be prevented in the future. Mr. Speaker, while the key stakeholders continue to dialogue, as has been noted in the press release of GPHA, Ghana Ports and Harbours Authority, I respectfully invite this Honourable House to take a keen interest in this matter and initiate appropriate steps to ensure that we get to the bottom of this matter and establish the truth. This all-important issue borders on 2 precious lives that have been lost. The Homowo Festival of the people of Greater Accra, the fishing community, and the national close season. I thank you, Mr. Speaker, for the opportunity, and let me extend my sincere, heartfelt condolence to the bereaved families and wish all affected by this accident well in these trying times. May the souls of the two lost rest in peace. Thank you, Mr. Speaker.
Yes.
Speaker, let me commend my brother, the MP for Tema East, for bringing this very important matter to the attention of the House. Mr. Speaker, accidents amongst our fisher folks continue to rise. Mr. Speaker, even in my constituency in Southline, where fishing is done on the mighty Volta Lake, which in its expanse appears like an ocean, our fisher folks continue to suffer accidents. Mr. Speaker, but the very important matter that our brother has brought to the House is whether or not the involvement of GFA, the security of Ghana Ports and Harbours Authority in this matter was a willful one. Mr. Speaker, there has been fatalities, and so I think that it's become customary that when such incidents happen and they are brought to the attention of the House, some committee is established to look into, so that if necessary, like the Constitution demands, some regulation can be fashioned in that respect. So I want to join in to urge the House, and especially you, the Speaker, to look at this matter very critically and set up a committee to quickly look into the circumstances surrounding this matter, come up with some recommendations that he himself has captured in the statement, so that this House can be properly apprised and give the appropriate directives and sanctions in this matter. Mr. Speaker, with these words, I commend my brother for bringing this matter to the attention of the House. Thank you very much.
Leaders, leadership, can you advise me? Yes, Tema West.
Tema East.
Can you wait? Let me listen to Tema West. Yes.
Sorry.
Thank you, Mr. Speaker. Mr. Speaker, I rise to add my voice to my colleague, my next door neighbor from Tema East, and also commiserate with the families of the fishermen who have lost their life. And I must say, that Mr. Speaker, the dangers that our fishermen are exposed to these days is becoming alarming. Mr. Speaker, since the construction of the Meridian Port Services Port, the new port, Terminal 3, the space for fishing for our fisher folk are huge, and many of these fishermen find it very difficult, especially because they've created a niche for themselves within the sea. It becomes very difficult for them to change, and therefore always find themselves in danger encountering these huge vessels that are always berthed at anchorage. The Speaker, even that notwithstanding, the danger that the Chinese fishermen pose to these local fisher folk is alarming. It is high time that we decided as a country to demarcate, or actually consciously find space for these fisher folk on the high seas, for them to come to terms with themselves when it comes to looking for their daily bread. It is quite untenable for a father to wake up one morning, decide to go on the high seas to look for his daily bread and not come back. Why? Because of these dangers that they face at sea. If you look at the conservation for the safety of life at sea, it states clearly that fisher folk are supposed to be protected when they are at high seas. We don't do that. And I don't know when this country is going to consciously ensure that we find a way to, as it were, take care of these men who go look for their deliverance on high seas. So I side with my colleague, and I want this House to consider the conditions that he has proposed and see if it is possible to bring some kind of confidence back into our people for them to do their work peacefully. I thank you, Mr. Speaker.
Yes, leadership, I want your guidance. Yes. The statement is requesting that a committee of this House investigates that. That's why I want to hear leadership on that request. Yes.
Mr. Speaker, thank you for the opportunity. And I join my colleague to sympathize with himself and his constituents for this unfortunate situation. He's already told us that this is not the first time. Honorable member from South Nine also said it's something that has been happening. Mr. Speaker, it will be appropriate, if you so wish, to probably recommend an appropriate committee in Parliament to work with our colleague and GPHA to look into it. And the important thing is asking us to do whatever we can do to make sure that the occurrences that it doesn't occur again in the future. I think that is the most important thing. And if you are, if you be kind enough to maybe make the recommendation to an appropriate committee to look into it, that would be very helpful to himself and his constituents. Thank you, Mr. Speaker.
Yes, available leader.
Mr. Speaker, let me also support my colleague and also communicate with our brothers constituents. We believe that this should not be happening, especially when in times like this, families need their parents and they need their mothers around them. So I will join my colleague to say yes. We will be happy if you can set up a committee that will look into it to prevent any further occurrence of such an accident. I thank you, Mr. Speaker.
Very well. In this circumstance, I think the Committee on Roads and Transport is sufficiently endowed to be able to investigate and report to the House the circumstances of the accident, determine the culpability, if any, of the speeding boat, and recommend measures to prevent any such further occurrence. The committee is hereby authorized to request the assistance of any state agency that will enable it to get to the bottom of the direct. Now, all right, I will. How many statements did you agree you would take today in addition to, this is also an emergency? All right. One for health and one for, so honorable member for Nsuta Kwamang Beposo. You may read your statement. After that, the honorable ranking member of health will also read his statement. Yes.
Mr. Speaker, first and foremost, I would like to express my deep gratitude for this opportunity to address this honorable House. It is always a great privilege to stand before this distinguished assembly to lend my voice to the democratic dialogue that shapes our nation's destiny. I rise on the floor of this august House today to bring to your attention the attention of my fellow honorable members as a matter of significant concern that has been plaguing my constituency in Suta Kwamai Beposo. Our peace, our safety, and our very way of life have become under threat. Mr. Speaker, I'm referring to the escalating crisis brought on by a group of Fulani herdsmen whose activities have been increasingly characterized by lawlessness and violence. Mr. Speaker, in the Atonsu, Esreso, Jediako, Dagati, Konkomba, Oku, and etc. communities, the presence of these Fulani herdsmen is increasingly being associated with series of criminal activities. Among these are widespread destructions of farms, lands, and property, and the persistent threat of vandalism and reported incidents of rape. The information and of dangerous gangs and overall pervasive atmosphere of fear and panic. The constituents of Atonsu in particular, in their desperation and helplessness, held a public demonstration recently to express their worries, to call for immediate and effective solution to their difficulties. The people of Jediaku have had to endure the cruel and horrifying incidents of rape and extreme violence. Mr. Speaker, the presence of these Fulani herdsmen has transformed our peaceful constituency into a region gripped by fear and displacement of the residents in disrupting the social life of the community. Is something we, as the representatives of the people, must address immediately. Mr. Speaker, let me clarify that this appeal is not against the Fulani community as a whole. We acknowledge and appreciate the section that us in peace contribute positively to our society and respect our laws. Mr. Speaker, I implore this Honorable House and relevant stakeholders to intervene and ensure that peace is restored to Insuta Kwame Biposo. I thank you once again, Mr. Speaker, for the opportunity.
Well. Honourable members, the statement has been read. We invite a couple of contributors. So let me go to Tema East. Tema East.
Yeah, thank you.
You have the floor now.
Thank you, Right Honourable Speaker, for the opportunity to contribute to the statement made by my colleague regarding the activities of herdsmen. Honourable Speaker, whilst I identify with the concerns expressed, I would want clarity on issues bordering on herdsmen in this country, especially when we attempt to stereotype all herdsmen as Fulanis. I am particularly concerned because my late father had a ranch in the Volta region, Hohoi to be specific, even though he's a typical Gan. And he used Gadangbe's and others to advance that business in Volta region. I know other places in Adan, there are herdsmen who may not necessarily be Fulanis. And so my concern is the generalization and the term. I would recommend that the activities of such people be referred to as nomadic herds. I think that would be a more preferred description, unless in her particular case, she is having to deal with identified and really defined Fulanis. Having said that, I think as a nation, we ought to get concerned with the repeat of ills around herdsmen affecting both agricultural products, and even in some cases we hear of attacks, maiming, rape and other cases. And so we ought to show concern, have a bigger discourse on how we want to advance our cattle ranching and livestock and issues relating to that. But core to my concern is the reference being made to Fulani herdsmen. Thank you, Mr. Speaker, for the opportunity.
Thank you very much. Let me go to Manson Kwanta.
Yes, this one mark is not possible. Okay. Thank you, Mr. Speaker, for this opportunity to contribute to my dear lady's very important statement on the issue of agricultural point of view that I'm taking, and at the same time looking at the issue of the commonality among the West African zone and generally to the African perspective. Mr. Speaker, this is a very big economic activity that is giving job to some people. And at the same time, we look at it on the other way, creating another problem for other people who are also undertaking a different job altogether, providing a very good economic activity, whereby their produce is something that is giving people a source of protein that help us in our daily lives in terms of improving upon our health, because protein is a very good source of, one source that we get from the animal of cattle. Mr. Speaker, this issue of the Fulanis and other herdsmen, whether Ghanaians or from any other place, is an issue that has been overstayed, and you have overlooked it and creating problems for us as people. Mr. Speaker, when you look at the issue of the herdsmen and then the farmers in the crop area, you realize that the herdsmen are moving like nomadics from place to place in search of food for their animals. And in the process, they enter other people's farm, where they also get the opportunity to feed them with the produce of other farmers who have also contributed their economic activity through that. And they earn their living on that basis. How are we confronting this issue? How are we trying to solve it? There could be a way that you can do this. For example, Mr. Speaker, we can create a way that will provide a source of research for both economic and educational activity. These animals are moving from place to place. Their droppings is a source of organic manure that can be used for farming. So if as people we are able to work it out, where we may have these animal ranches across, so that when they move from place to place, you have a way of trying to do a research to gather these things for our farming issues, where we can also, in commercial terms, hide these ranches to them, so when they move from one place to the other, we use the opportunity to create an avenue for them to pay for the service, where people are also going to put across these feed for animals, whereby chronically we can have plantation of these grasses. They can move their animals there. As they move away, the issue of their dropping can also be developed. At the same time, those who are doing research can also have a way of improving upon these issues, and they're looking at the highs that animals can provide for other economic activity. Mr. Speaker, there's also an opportunity for Africa to use this as a means of trying to help us to come up or something to make it more economically viable. So that instead of creating this problem of confrontation between the herdsmen and the farmers, you have a way of getting them together as people and then collaborate and ensure that there's peaceful coexistence between these people. That is the farmers who are cultivating the vegetables and the farmers who are also rearing animals. So that at the end of the day, the trouble and then the criminal activities where they are always the killings, the beating, the rape and other things, we be able to solve it and ensure that this economic activity is well handled for our benefit. Mr. Speaker, thank you very much for this opportunity.
You know something? When a first timer is bold enough to speak, I'm inclined that I should give you the opportunity to speak. Yes, he's been speaking a lot. So he have no phobia in the house. Well, let him come to my namesake, Andrew.
I thank you, Mr. Speaker, for this opportunity to comment on the statement ably made by my colleague. Mr. Speaker, the issue that we are discussing is not a couple of weeks ago, Mr. Speaker, I filed a question on this particular issue in my constituency, that is the Solar Tona Kalba constituency. Mr. Speaker, that day we had the Interior Minister who spoke about the issue and indicated that his ministry was in talks with the police service and that the police were doing surveillance and the police were ensuring that security is being kept in areas that we have these herdsmen, animals destroying people's farms. Mr. Speaker, this is a very serious issue. We all do know that destruction of nomadics on people's farms didn't start today. I still remember very well there were issues in Asante Agogo. When I just Googled, I saw a story somewhere 2nd of May 2016 where Honorable Animadu Entry had serious issues with these nomadic farmers. So many stories surrounding these nomads. But, Mr. Speaker, the reason why we often link it to Fulani herdsmen is that most of the people who keep the animals or those who take care of the animals are of that ethnic descent. And that is why sometimes we just conclude that the herdsmen are Fulani herdsmen. Mr. Speaker, if you get to my constituency, most of them are Fulanis. We do not say that all Fulanis are bad people. We do not say that all Fulanis who keep animals do not take good care of them. But the fact remains that they are a nuisance to our farmers. Mr. Speaker, I'm guided to be very brief by my revered lawyer. The fact remains that the herdsmen destruct our farms. Let's find a very good solution to this. Mr. Speaker, we all depend on food to survive. Our farmers depend on their farms to survive. They depend on that to send their kids to school. That is what they use to take care of their hospital bills. And so every person that keeps animals must be guided. Let's have a law that will protect our farmers from these herdsmen. I thank you, Mr. Speaker, for this opportunity.
Yes. I think all the discussion falls under the Minister of Interior. So let him give the opportunity to the Deputy Minister.
Thank you, Mr. Speaker, for giving me the opportunity to contribute some few words on the statement made by my dear sister. Mr. Speaker, on this mess of some Fulani herdsmen, some of them in some communities have called the attention of the country and sought to be work on it very urgently. The threat on lives and properties, peace and security, livelihoods of individuals of some communities is very, very, very alarming. Mr. Speaker, I know the Ministry of Interior and the police are doing their best to protect the lives and properties of some communities. But these Fulani men, Mr. Speaker, I think the country and even the House have to have some measures so that they will know where to go and where to not go. Even our rivers, they are destroying it. And when you confront them, the problems and the fights they give to the communities is bad. I think, Mr. Speaker, with these few words, the House is going to take some measures as the Ministry of Interior and the police are doing. Thank you, Mr. Speaker, for the opportunity.
Let me give the last opportunity to my brother, member for Intamponov, yes. Yes.
Thank you, Mr. Speaker, for this opportunity to have this bite. 2 minutes, leader. Thank you. Mr. Speaker, the issue of Fulani herdsmen and crop farmers. I ever had the opportunity, and what I said is that we have 2 types of farms. We have the mobile and non-mobile farms. The mobile ones are the cattle, and we have the non-mobile one, which is crops. Because we have not put things well together, the mobile ones are able to get near the non-mobile ones and consume them. And this has been a perennial issue. Mr. Speaker, there has been a solution to this, but we have overlooked it. When I came to this parliament, one of the questions, when the cattle ranching project was going to go on. Cattle ranching is the solution for this issue. Annually, we can prevent Fulani herdsmen from entering Ghana. There is that protocol where they move from the Sahelian countries, come as far as through Kintampo North to Ejura to graze. Then, when they have started farm work at the Ejura area, then they move backward back to the Sahelian country. And this was the wisdom His Excellency late Dr. Kwame Nkrumah saw and established the beef factory at the Upper East region to take care of the advantage there. But we have left that project up to date to even rot. Mr. Speaker, the final solution to this Fulani cattle up and down, Afram Plains, Kintampo, and all these places we are talking of, especially the maker of this thing is talking of, is to have a cattle ranch sort of system where we can keep the animals, have them at particular locations, they graze there, then the mobile farmers, which are crop farmers, will also have their piece, because at the end of the day, we need the meat to be part of the food, for it to be complete as food. Thank you for this opportunity for the bite.
Well. Honourable members, we have another statement, and that statement is at the instance of a member for Jiaboso constituency, Honourable Kwabena Minta Akan, the ranking member for Health Committee, and the topic he wants to talk about is calling on Parliament to direct the Minister responsible for finance to release funds approved for the Food and Drugs Authority. Yes, Honourable Member.
I'm most grateful, Mr. Speaker, for the opportunity to make this crucial statement on the floor of the House. Mr. Speaker, Parliament should be deeply concerned about suspension of market surveillance and general manufacturing process inspection. Mr. Speaker, Parliament should be concerned about the suspension of market surveillance and general manufacturing process inspection by the Food and Drugs Authority due to the unavailability of funds. The unfortunate situation, Mr. Speaker, my sight is failing me. This unfortunate situation should warrant a bipartisan call of the House on government to release the FDA share of the 2023 budget allocation as approved by this House in order to facilitate the resumption of these essential services. Part 7 of the Public Health Act 2012, Act 851, deals with the establishment, functions, and issues relating to the existence and operations of Ghana Food and Drugs Authority. As stated in Section 81 of Act 851, the object of the Food and Drugs Authority is to provide standards for the sale of food, herbal medicine, cosmetics, drugs, medical devices, and household chemical substances. Mr. Speaker, to forties, the Food and Drugs Authority conducts routine and non-routine inspections and audits of product, facilities, and personnel. These inspections ensure compliance with the standards established by the FDA's compliance unit, thereby guaranteeing a high safety and efficacy level for the consuming public. Adequate funding is crucial for the FDA to perform these duties. Therefore, on an annual basis, an estimate is presented to Parliamentary Select Committee on Health to review and approve the FDA's annual budget. In the 2023 appropriation bill, Mr. Speaker, Parliament approved of 139.5 million for the FDA to ensure adequate funding for the performance of its key functions. Mr. Speaker, market surveillance enables FDA to verify the wholesomeness of food, the efficacy of drugs, and the safety of other products on our market. It also empowers the FDA to make remedial action against suppliers, distributors, and retailers who fail to meet the FDA's standards. General manufacturing process inspections are conducted by FDA to assess whether manufacturing companies follow the approved processes and methods aligned with best practices and standards. These inspections provide assurances regarding the safety and efficacy of products they introduce to the market. Due to the FDA's commitment to these functions, its officers are sent abroad as needed to ensure that products manufactured for the Ghanaian market meet conditions and methods before being packaged and imported. Regrettably, Mr. Speaker, government has delayed in disbursing approved funds for the FDA to fulfill these crucial, Mr. Speaker, responsibilities of ensuring public safety in 2023. It is worth noting that government utilization of internally generated funds from the FDA is inequitable. Government retains about 30% of FDA's total RGF and only retains 24% of the total RGF in an unscrupulous barter that is nothing more than robbing you to pay you when I want, resulting in withholding of over a quarter of FDA's resources, which are then disbursed at government's discretion, greatly hindering the FDA's operations. This unfair arrangement is not only reprehensible but also highly unconscionable, given that government, having agreed to this payment structure and not obtained approval in the annual budget, has refused to make payments that would bolster the FDA's to guarantee and maintain health and safety of Ghanaians. Mr. Speaker, considering the recent anthrax public health alert, it was expected that the FDA would intensify its surveillance programs across the country to ensure that meat supplied in our market is free of disease contamination. Unfortunately, government has chosen to deprioritize the FDA under these precarious circumstances. Mr. Speaker, recent investigation conducted by the Fourth Estate, the journalistic wing of the Media Foundation for West Africa, has brought to light a concerning issue. Out of a random sample of 300 sachet water brands available on the market, a staggering 142 were found to be operating without proper licensing from the Food and Drugs Authority. This highlights a serious problem, as the ongoing sales of these unlicensed brands by unscrupulous individuals and manufacturers poses significant risk to public health and safety. The resolution to this crucial matter lies in ensuring that the FDA is adequately funded to carry out its essential duties effectively. Prioritizing the funding of FDA is vital in safeguarding the well-being of consumers and maintaining the integrity of regulatory processes. The health and safety of Ghanaians must remain paramount in the prioritization of government's agenda. Even as government continues to invest in infrastructure development, it is equally important that government provides the needed funding that will guarantee the effective and efficient operations of agencies within the health sector. For this reason, I want to plead with government to expedite disbursement of funds to Food and Drugs Authority so it can continue providing the services for which it was established and continues to operate. Mr. Speaker, I thank you once again for the opportunity to make this statement on the floor of the House. Thank you, Mr. Speaker.
Yes. Thank you very much, Mr. Speaker, for the opportunity to contribute to the statement ably made by the ranking on the Health Committee. Mr. Speaker, any food we have to eat must be certified by someone that is wholesome. And also, the drugs, the water we drink, we must ensure its safety, we must ensure its efficacy, and we must ensure that it's of high quality. And it's this very important assignment that the FDA has been carrying out. But Mr. Speaker, the FDA has been doing very well. In fact, had it not been for the FDA, we have incurred a lot of cost at the hospitals because it prevented people from taking unwholesome food and drugs that are dangerous to their health. And so, if FDA is suspending market surveillance, which enable them get items that are, one, smuggled into the country, two, companies who don't go through their processes get their items into the market and fraudulently put on their packages approved and certified by FDA. If they are suspending this market surveillance, then we are in a serious problem, especially with the constituencies which are in the rural area. These are the areas some of these companies target and operate. And therefore, I support the call by the ranking that the FDA should be adequately funded. Mr. Speaker, why should the FDA be capped? Now, I find this strange. The capping of FDA is a high time, especially the agencies under the Health Committee and the health sector. Capping them is affecting their performance, especially FDA. And FDA relies on their IGF to do all this work. They've very experienced personnel, they have good equipment, and yet they can't do market surveillance to identify these particular products. Mr. Speaker, I support the call by the ranking that FDA should be first capped, be capped totally, and then secondly, adequate resource to help save Ghanaians from taking in unwholesome foods and drugs. Thank you very much for the opportunity, Mr. Speaker.
Yes, let me come to, is it Afutu? I've always forgotten. Awutu Senya West, yes.
Thank you, Mr. Speaker. Mr. Speaker, I'm appalled to hear that FDA is in such a crisis. And every Ghanaian and every citizen should be worried about this. Because if somebody is not, if they are the mandatory authority to be able to do this market surveillance and check the wholesomeness of foods that we are eating, and if they are being capped and their IGF is not going to them to be able to execute the mandate they are supposed to, then where are we as a country? Just today, as I was having lunch, I was just looking at the food house, and I was just thinking, what is the nutritional value in the food I'm eating? That is even a separate discussion altogether. But for the fact that they are capped, Mr. Speaker, we need to have a discussion on this capping. Because capping is causing a problem, and at some point, there should be a review of all this capping. Get fund is capped. 39% is released to get fund. FDA, 24% is released to FDA. If the capping, the amount that is being taken from the institutions is not adequate for them to be able to undertake their mandatory assignments, then what are we doing as a country? And what kind of country do we think we are actually preparing as leaders? Mr. Speaker, it's very worrying. FDA is supposed to be giving assurance to Ghanaians that the foods that they are being able to check are wholesome. And if this assurance is not being given to us, then there's a problem. Apart from the fact that, yes, they may have the expertise, but you and I know that if the resources are not there, they cannot do it. I remember in those days when they will actually go onto a market, they go to a market soup, they go to Makora, they go to other places where they know that people have imported and brought things. Mr. Speaker, I'm very worried about this because by now, it's even possible that expiry dates on goods may not even be true. And who is going to check the authenticity of an expiry date on an item, on a food item? Mr. Speaker, apart from that, we really must up our game in this country with compliance issues. Compliance issues with food, compliance issues with education, compliance with so many other things. And it is very worrying that if they are not being given the fair share of resources to do their work, then they cannot even see to compliance for us. I, as a private citizen, even if I'm a member of Parliament, I cannot go into someone's shop and start looking at dates of items and expiry dates and start raising hell over there. I cannot do that. But at least let the authorities that have been mandated to do that be able to do that. Mr. Speaker, let's also talk about food safety. I'm worried that if they are not able to do their surveillance, what happens to, for example, the buffer stock company? The buffer stock receives huge quantities of food items that they send to senior high schools. Is there a system to check even the food items that go to the buffer stock company that releases to the senior high schools, for example? What about the school feeding? Who is checking the food that even the children are even supposed to be eating? Are we going or we are coming as a country? Mr. Speaker, the authorities need to do the right thing. And if at some point the amount that is capped is not adequate, we should have this conversation. And apart from having the conversation, Mr. Speaker, I think that it is fair that whoever is mandated to be able to perform their duty should be given the free space to do that. Otherwise, we are all suffering. Mr. Speaker, if out of 300 sachet water producers, I have to refer to my colleague's statement, but 142 of them are without proper licensing. What water are we drinking? What food are we eating? That should really be a cause of concern to this House, and even beyond that. So, Mr. Speaker, please, the authorities that need to hear this, Ministry of Finance, if you are not releasing their funds, please release it so that people can do, FDA can do their work and do it properly. Because as citizens, I don't think that it is fair for health funds to be withheld and the necessary agency cannot do its work. Otherwise, one day we'll be sitting here, and if they are able to come and do an assessment on, even just take us as samples, you'll be surprised the level of arsenic that will be in our bodies, the level of other pollutants, and we can't be continuing to be living like this. Mr. Speaker, we need to move forward as a country. Too many things are going wrong, and please, at some point, certain things must be put right. I thank you very much, Mr. Speaker, for the opportunity.
Yes, and I will not play.
Speaker. Let me start off by commending my good friend. Speaker, I commend my friend highly, and also to say that the matters raised in context are germane, very important. We can't pretend about it. So, especially on the operations of the FDA, to market surveillance functionality is so critical because there is a correlation between its function and the availability or otherwise of products that are not healthy for our consumption. So we cannot pretend about it. Safe to say that my good friend should look at Order 155. Probably we could have avoided a situation where we have to go through all these and a statement being made. Our orders provide, and it gives us some powers. Our committees, and he's a ranking member of the committee, a very proud ranking member of the Committee on Health. The Order 155 gives the committee leadership and the committee itself powers. Powers equal to High Court of Justice. And probably, I'm not saying what you're doing is wrong, probably the committee could have come together and work. The leader, the chair, and the ranking himself could have brought the Minister of Finance and then the FDA at one platform to deal with these matters once and for all. Speaker, I concede that there are difficulties, especially when it comes to the release of funds to public institutions to work. The expectations of Ghanaians are very high. However, sometimes, I'm not saying that is what is happening in your case, but just sometimes, it's all about communication. For instance, yesterday, we followed up, following our expectation of the finance minister to come and meet a joint committee on releases to common fund. We realized that good amount of money has been released already. But it was a question of communication. And because leadership had not been apprised, as at the time we were lamenting, we didn't even know that volume of funds has been released to the common fund. So not to take anything away from the trusts and the essence of your statement, I also want to employ my colleague that he should work closely with his chief whip. His chief whip is a very capable hand, and we could have resolved this matter without it being made known through a statement. But it's regrettable that the FDA, such an essential public institution, will be denied its necessary oxygen needed to prosecute its public function. So, I think, Speaker, on this occasion, I think maybe leadership will also have to come in, and then we work together hand in hand, leadership together with the leadership of the committee, we work hand in hand. Just that our colleague has failed. He just came and gave us copies of the statement. He knows what to do. And he should go back to the chief whip and put himself in proper position so that we will also facilitate all we have to do to make sure that we do what we have to do. But I must commend him highly because right in the morning when he came, was very passionate about this matter and was insisting that, yes, his appearance speaks for it. He was very passionate that whatever it takes, the Speaker will admit. And Speaker, we must commend you for admitting this statement. But leadership must also put in a word. Not just a word, but put in a word to ensure that the right thing is done. As for the capping matters my good friend raised, it's a bigger matter that we should look in broader context, especially the Get Fund as she rarely related to. But I'm very proud. I'm very proud that this House, together with leadership, before we approved the last formula for Get Fund, there were critical requirements that this House stood by. And I cannot help it, but as I see my ranking member for the committee also commending, monies that were originally designed to service debt, this House had insisted over 500 million. Yes. I don't know if Chief will recall. Yes, we had insisted that no, we will use it for that function. And so we revised the original plan of the Exchequer and said that the people of this country, there are schools and the trees, there are other functions of the education sector that need to be prosecuted. And we're able to do it. So let's work together as a team so that because that burden, you can't carry it alone. My dear Randy, you can't carry this burden alone. All of us need to support you particularly the leadership, to make sure that we reverse this trend. Speaker, having said that, I still want to commend my ranking highly for the dedication and the passion with which he has gone to push this matter up. Speaker, I thank you for the space. We have one outstanding statement. It was admitted, I think 2 weeks ago. The Honorable Deputy Minister for Youth and Sports, Speaker, has been waiting patiently for your grace to find him. And so I will appeal that we'll take that as the last one before we draw the curtains for the day. I thank you, Speaker.
Honorable Leader, I don't have that statement here. And if I don't have it here.
Speaker, if you may endure me, it was actually given to the first deputy, but I have just ferried a copy of it to you, to your indulgence, Speaker.
Very well. Honorable members, Honorable Deputy Minister for Youth and Sports, I believe we've given copies to members. Because
Yes,
I can see it becomes a bit.
Yes, Mr. Speaker.
Very well.
Yeah, my colleague, Honorable Dafiamafo, has a copy. Honorable Kamnaminta Kano has a copy. Yeah.
So, honorable members, I'm just trying to urge members. If you are coming to make a statement, it is prudent that you share the statement to colleagues so that they will be able to also contribute. Because if you read and colleagues don't have copies and they are not able to contribute to the debate statement, then it makes it a bit boring. So, Honorable Deputy Minister, your statement is on the relevance of non-timber forest products to poverty alleviation. Honorable, the floor is yours now. Let's hear you.
Thank you very much, Mr. Speaker, for the opportunity to make this statement on the relevance of non-timber forest products to poverty alleviation in forest districts in Ghana. Mr. Speaker, non-timber forest products such as food items, medicinal plants, bushmeat, honey, forage and fiber play a very important socio-economic role at subsistence and commercial levels, as well as for their cultural and spiritual values in our communities. However, in Ghana, whilst they do provide cash and non-cash income for forest-fringed communities, they function merely as safety nets and gap fillers in times of emergency and low agricultural productivity, instead of as a tool for poverty eradication. Mr. Speaker, a critical analysis of non-timber forest products within the context of Ghana has revealed that they can play an important role in rural poverty alleviation. Mr. Speaker, forest-based poverty alleviation can be in two forms. One, poverty mitigation, under which forest resources merely meet subsistence needs, fulfill safety net function in times of emergency or gap filler in seasonal periods of low production, as well as two for poverty eradication, where it helps lift rural households out of poverty by functioning as a means of savings, investment, capital accumulation, asset building, and lastly, increase in income and well-being. Mr. Speaker, this feat can only be made possible if a premium is placed on non-timber forest products by promoting co-governance in the products. Mr. Speaker, non-timber forest products provide a wide range of goods for domestic use and for markets, among which are charcoal, fuel wood, game, fruit, nuts, honey, medicinal herbs, forage, and thatch for roofing. When communities benefit of non-timber forest products, they tend to protect the forest. Mr. Speaker, in contrast to timber, non-timber forest products tend to have a little or no capital requirement and tend to be available in open access or semi-open
settings. People who live around forest fringe communities generally use various types of non-timber forest products so they can be able to spread risk among different activities. Mr. Speaker, there is a strong evidence that poor around the world are those who engage in extraction of non-timber forest products. Therefore, there is a need to research into non-timber forest product value chains such as their production, collection, processing, storage, transport, marketing, and sale to tap their potential as a sustainable livelihood venture for people who live around forest districts in Ghana. Mr. Speaker, thank you so much for the opportunity.
Thank you very much. This is a very important statement. Yes, Honorable Dafiamapo.
Speaker, thank you for the opportunity to make some comments on this very important statement. And let me commend my brother, the Honorable Deputy Minister for Sports, for bringing this matter to the attention of the House. Mr. Speaker, this is very important in view of the bill we are presently engaged in passing into law. The Wildlife, Mr. Speaker, if I may seek your permission, Wildlife Resources Management Bill, which will soon become a law. And these are the matters that the bill seeks to tackle in making sure that it becomes a law. Mr. Speaker, if you look at paragraph 3 of the statement, my brother says that in Ghana, while they do provide cash and non-cash income for forest fringe communities, they also function merely as safety nets and gap fillers in times of emergency and low agricultural productivity instead of as a tool for poverty eradication. Mr. Speaker, in my constituency in Southern, I may not have a designated forest cover protected in law, but I have high forest areas where the communities are even prevented from entering the forest and having a sustainable life. Sometimes they're often confronted by officers of the Forestry Commission, men in uniform, harassing and all that. Mr. Speaker, if you go to Adaku, where you have a game reserve in my brother Kwame Agoja's constituency, communities that live around this forest cover are prevented from having livelihood dependent on the forest. But in times during the dry season, where they are supposed to ensure that the forest cover is not affected by wildfire, they are then called upon to help to weed around this forest cover. And so, Mr. Speaker, this statement is so important, especially in view of paragraph 3 contained on page 2 of the statement. My brother has this to say: non-timber forest products provide a wide range of goods for domestic use and for the market and for market demand, among which are charcoal fuel wood, game, fruit, nuts, honey, medicinal herbs, forage, and thatch for roofing. Mr. Speaker, when communities benefit from non-timber forest products, they tend to protect the forest better. And I thank my brother for this statement. When we allow the communities to have sustenance on the forest, they see it as a lifesaver. And therefore, they put in every reasonable effort to ensure that the forest, one, is not depleted by other human activities like galamsey. Two, it's not destroyed by wildfire during the dry season. And 3, like it is done in coastal fishing communities and elsewhere, they also have a season where they don't go hunting and undertaking other activities in the forest, so that the wildlife can breed. They give themselves time during which they allow the wildlife to breed. so that they can replenish the forest. So, Mr. Speaker, with these words, I thank my brother for bringing this matter to the attention of the House, and I hope that these matters that he has raised will find favor at the second consideration stage of the bill before it is finally passed into law. Mr. Speaker, thank you for the opportunity.
Honorable Eche, thank you very much. Yes, let me come to my brother from Kintampo North.
Thank you, Mr. Speaker, for this opportunity to contribute to this beautiful statement from my brother. Mr. Speaker, I want to narrow my contribution to his on the issue of honey, bee. Honey, as he mentioned in his statement. Mr. Speaker, but for the environmental issues we have in Ghana and other climate issues, especially bushfire, agrochemicals, non-forest items like honey production could have roped into our nation $5 billion. $5 billion. Currently, the country is able to only get to the world $168 million. Look at the capacity that we have to produce. So, I'll take the opportunity to advise that most of our rural folks and those by the water bodies should concentrate on honey production and even let our forests be reserved. We let the charcoal aspect be off our business. And then most Ghanaian youth should go into this non-forest products like beekeeping and others so that the nation will gain the rightful money or resource we need for the development of Ghana. Mr. Speaker, things like charcoal and other things we cannot do without. However, we are finishing our forest. We are depleting the whole forest. Meanwhile, in our nation is the continuous planting of trees. And acacia is the best tree that we could have used to support charcoal production. So I'm by this contributing and saying that the nation should educate, and especially those who have taken into charcoal production as their main profession, to let acacia tree planting be their job, as they can develop it into plantations and then harvest from their own plantations and continue to produce charcoal in commercial quantities. For these few words, I'm grateful for the opportunity. Thank you.
Yes. From Kintampo North, let him go to Doma East.
Mr. Speaker, let me congratulate the Deputy Minister and also add my voice to the important statement that he has made, and thank my colleagues. Just add a little part of it, and at last but one paragraph, of which I think is important we look at it. Mr. Speaker, visually, there is a strong evidence that the poor around the world are those who engage in extraction of non-timber forest products. Therefore, there is the need to research into non-timber forest products for value chain, such as their production, collection, processing, transport, and so on. Mr. Speaker, I think that is an important part that we need to look at. Looking at what my brother from Kintampo said, and what my brother from North Dai also have said, South Dai have said, it is important that we look at this non-timber forest product. There's the need for us to do a data collection on it to be able to ascertain how we can manage these resources and make maximum profit out of it. And I strongly believe where he comes from, there's a lot of timber, but he wants to go away from the timber and focus on non-timber products. It means that we need to look at what is there and take advantage of it to make some youth within his constituency useful and get some jobs for them. Mr. Speaker, we are tired of these few words. I thank you for the opportunity.
Thank you very much. Honorable members, we have brought statement to a close. We thank the owners of the statement and all the contributors. But like I said, leadership, let's take this on board. Henceforth, before you accept any statement from a member, let's make sure that he's made a lot of copies that will be distributed to members, because it becomes a bit bored if the only person read the statement and there's nobody else who is having a copy. So let's make a point, because I believe last Parliament, the majority chief whip, he used to make statement, and anytime he will come in the morning for a statement, he will be distributing the statement across members from this side and this side. So that immediately he reads the statement, people will have idea about it and also contribute. That will make the statement lively and people will also get paid off. So please, let's take note of that. So leadership, I come to you.
Speaker, I think we've exhausted all business as was scheduled. Safe to say that, Speaker, our colleague is not around, the ranking member for Health, Committee on Health. All the statements that were presented today are equally important. I want to plead for your intervention because the trust of it is on release of the necessary liquidity for the function of the FDA. And Speaker, we all know the importance of the FDA. I want to appeal, if you may, refer this matter to maybe leadership or limited to the whips and the leadership of the Health Committee to go into it quickly and report to the House before the House rises on Thursday because of the importance of this subject matter. Speaker, that's my application.
Well.
Mr. Speaker, I think the whip is right. The nature of the statement makes it quite very important if we are consuming products, including today, and whose quality and efficacy and everything cannot be guaranteed, Mr. Speaker. It's not something we should joke with. So I agree that just as we've done with Get Fund and other funds, we could add to the effort by the ranking to see what we can do to bring FDA and the Ministry of Health and then the Ministry of Finance together to see if we can have a quick resolution to the issue. So if you
very well.
We can see.
The application is hereby granted. The statement made by the ranking member for health is hereby referred to the Health Committee. And should I join the leadership itself? The two whips, the majority and the minority whips, I'm attaching you to the committee to quickly go into it and report back on Thursday, a week today. Leader of the backbench, we will recognize you when we adopt the new standing orders. So on that note, yes, leader.
Speaker, I wanted to be clear about your direction, because what my colleagues were trying to end up was that you direct the Finance and the Health Committee to invite the Ministry of Finance, Health, and FDA to be able to sit down to address the issue. I didn't hear that clearly from you.
Was that application?
Well, Speaker, with respect, that was not my application, but it will also not take anything away from the substance of my application. So I think it makes sense, and we can tweak it to do it, to approach it that way.
Because I'm looking at the period we find ourselves, that the finance minister is going to be in charge of the budget, media budget, as to whether he will get time to appear before your committee. I'm just looking at it.
Speaker, with respect, the practice in this House has been not necessarily get the finance minister in person. I mean, we have two deputies and we have a minister of state. So we can get any of them to, at the end of the day, it's about the release of the funding.
Oh well. So the application is still granted. The referral is now to invite, if I got him right, to invite the finance minister to appear before the committee together with the whips to explain why the Food and Drugs Board's release has not been done. Is that okay? Whip, is that okay?
I think the TOR is defined enough. So we will find out why the release has not been done and report back to the House.
Very well. By Thursday. Very well. So,
with regards to the time, we are now in your hands, and also to put your notice that, Speaker, we have exhausted all business plan for the day. And let me commend my colleagues, particularly the Chief Whip, who has been very supportive, and colleagues, the leader of the Backbench Association, and his role in the Wildlife Resource Management Bill. Speaker, I think colleagues have done so well today, and I think that the two whips have also put our heads together. Speaker, there are other critical concerns that we are following, and I want to assure colleagues that before the House rises, all the other concerns will be sorted duly.
yes.
Thank you, Mr. Speaker. Mr. Speaker, I have a concern, and I want to make a special appeal to you. You were once a member of the Education Committee, and you are aware that last year, July, we presented a report on the UNESCO bill. And it is a year now. We have not finished that bill. And it is affecting the international image of Ghana at the UNESCO. So I want to make a special appeal to the leadership through the Majority Chief Whip. Majority Chief Whip, pay attention. Pay attention. I know he has been doing very well to make sure that we take the UNESCO bill. And I want to make an appeal to you, to him through you, that he should get us finish this bill.
But UNESCO's bill, is it here?
Yeah, it's under consideration.
And where is the chairman?
Under consideration for a year now.
Where is the chairman?
We have not finished it.
Where is the chairman?
No, the chairman is out of town today. So I just want to make an appeal so that we can take it before we rise. That's my appeal to you, Mr. Speaker.
Leader, if the chairman is here, we can do something.
Yeah, the ranking is right, and we've been following up on this subject matter. Today, for instance, myself and my colleague had agreed that it was one of the businesses to be considered. So, and then eventually we realized that none of the ministers were here. As we are in this House, we must also insist that if you are a minister and you have a bill, you have to be in the chamber. If you are not in the chamber, leadership will not be minded to take your business serious. So the ranking has done his part, the chair has also done his part. Intermittently, you don't find the minister and the deputy minister of education. I think we'll keep reminding them that if they want us to pass the UNESCO bill, they must as well also be in the chamber.
So, Honorable Chairman for Constitutional and Parliamentary Affairs, I'm respectfully giving you assignment. And the assignment is that all the bills that are before us, try to coordinate the chair and the ranking so that we'll be able to finish all of them before we go, please. Yes. So on that note, I believe the speaker is still coming, and he's coming to work. Mr. Speaker is coming. Yes. So I'm going to yield the seat to Mr. Speaker, and you know once he comes, we are going to do more work. So, honorable members, I'll cede the seat to Right Honorable Speaker. So, more work, More work.
Honorable members, I thank you so much for the progress you've made so far. I was following, even though I was in a meeting with an ambassador looking at some important issues. I was following on my TV, and I saw you've done a lot of work. I also eavesdropped what my Deputy Speaker was telling you about more work. It's not more work, it's just finishing up some of the things that you have done already. And I'm sure they are not difficult to do in a few minutes. Tomorrow you'll be engaged more with the Minister for Finance than doing work on the floor. And so I wanted us to finish up with these pending bills, which are just at the consideration stage and third reading, with very few amendments. That's what I wanted to plead with you for us to finish up, and then we can call it a day. I'm talking in particular about the criminal offences amendment bills dealing with the witchcraft and the armed forces one. That is they are almost done with. We can just finish that, and then we can call it a day. So with your kind permission, if we can start with item 31. Criminal Offences Amendment Bill 2022 at the consideration stage. Chairman of the committee, are you ready? Yes, so honorable members, the chairman is ready, so we start with clause 1.
Very well. Thank you, Mr. Speaker. Amendment proposed. Section 316.
Chairman, they are just drawing my attention that we've not been done second reading. So we'll then take item 29.
Mr. Speaker, we have circulated the report, but I don't have my report readily available here. Item number 29.
The Criminal Offences Amendment Bill 2020 has been now read a second time. That one on the witchcraft.
Yes. Thank you very much.
I have my reports with me. So.
Mr. Speaker, I move that the Criminal Offences Amendment Bill Mr. Speaker, I move that the Criminal Offences Amendment Bill 2022 be now read a second time. Mr. Speaker, in moving that the bill be read a second time, I would want to state that the object of the bill is to prohibit the practice by any person as a witch doctor or a witch finder to prescribe the declaration, accusation, naming or labeling of another person as a witch, and also provide for related matters. Mr. Speaker, the accusation of a person as a witch sometimes can amount to a death sentence, depending on the community in which the said accusation is made. Mr. Speaker, I beg to move accordingly.
Any seconder?
Mr. Speaker, I beg to second the motion. And in so doing, Mr. Speaker, I present your committee's report, and I pray that the Hansa Department captures the report in its entirety. I thank you, Mr. Speaker.
Honorable members, motion moved and seconded is for the consideration of the House. Yes, honorable member.
Mr. Speaker, thank you very much for the opportunity to contribute to the second reading of the bill under reference. Mr. Speaker, the object of the bill is clearly spelled out in the memorandum accompanying the bill, and the report really has captured that. Mr. Speaker, the purpose of this particular bill clearly is to proscribe the discriminatory and truncated practice where one will be referred to as a witch, not a wizard, and the person will be subjected to a severe beating, ill treatment, and finally dumped at where they normally refer to as a witch camp. In this particular country, Mr. Speaker, we do not have a wizard camp, but what we have is a witch camp. Does it mean that in this country we only have witches and we do not have wizards? Mr. Speaker, that is the basis of me stating that this particular practices is so truncated and discriminates, in the sense that in the camps it's always women who are dumped there under the supernatural belief that they are witches. Mr. Speaker, the time has come for all those witch camps in the country to be abolished, and the activities of those witch doctors proscribed in this particular country, so that we can say never again should these issues happen following the incidents of Equia Dente. Mr. Speaker, if you watch on television the treatment meted out to this innocent woman called Equia Dente, you will come to a conclusion that this private members' bill was brought at the right time. It is up, timely, and suitable. And I urge the entire House to adopt the report of the committee and, as a matter of urgency, pass this particular bill into law in order to proscribe these supernatural activities of people claiming to be witch doctors, pronouncing others to be witches, and then dumping them at a witch camp. Mr. Speaker, it's not only proscribing the activities of the so-called witch doctors, but it's also proscribing the activities of the religious group, which will go a long way to say that because your grandmother, your mother is a witch, she is responsible for your woes. She is responsible for you not prospering in life. As a result, your mother, your grandmother will be subjected to severe treatment. She will be maltreated and at the end of the day, dumped there for nothing. Mr. Speaker, I urge the House to adopt the committee's report and, as a matter of urgency, pass this private members' bill into law. Mr. Speaker, I so support the report and then urge the House to pass this particular bill into law. It will go a long way to help all of us as a nation if the bill is passed into law. And I thank you for giving me the opportunity.
Honorable Member.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, this is a matter that's very dear to my heart. I was born in Birmingham, and I dare say there's no witch camp in Birmingham. The witch camps that we have heard about are in poor communities and sometimes in the rural communities. It is disheartening to see how most of the women who are kept in these shelters are women who have rocked the cradle, have birthed children, raised them, and then when they are menopausal and they are getting to the stage where the state and the family should cater for them and take care of them, then they are labeled as witches and treated inhumanely. Mr. Speaker, Article 15 and 16 of our Constitution says, and I seek your permission to read, it states that the dignity of all persons shall be inviolable, and no person shall, whether or not he is arrested, restricted, or detained, be subjected to a torture or other cruel, inhumane, or degrading treatment or punishment. Any other condition that detracts or is likely to detract from his dignity and worth as a human being. 16 goes on to say that no person shall be held in slavery or servitude, which is exactly what these camps have been doing to our women. I've written a statement on menopause, which also, in that statement, I talk also about how come women are declared witches by people who shouldn't be going anywhere near that. I'm hoping that I'll have the opportunity to read it. But I want to say that I support this bill, and I hope that with your leadership and direction, we will see it passed as soon as possible and make it impossible for anybody to declare another human being as a witch. It is totally unacceptable in this age that we are in. It's 2023. We're not in the 16th century. We are in the 21st century, and how we can still tolerate these camps in our country begs for reconsideration. And that said, Mr. Speaker, I thank you very much for the opportunity to speak on it.
Honorable Muntaka.
Thank you, Mr. Speaker. Mr. Speaker, let me once again thank you for the opportunity to contribute to this very critical motion about the witchcraft. And Mr. Speaker, to also take this opportunity to thank our colleague sincerely for the effort in bringing up this matter that I'm very sure governments after governments keeps talking and condemning it, but not having the guts to take the necessary steps to criminalize it. The Speaker, as my colleague rightly mentioned, this is a very discriminatory practice that have been in our country for a very long period of time. And my worry, I keep saying, is that I've never seen one where they've gathered men and said that they were witches or wizards. All the time, you see that it is innocent women that are being carved and given names. The Speaker, we all know that all over the world, because of the challenges that all of us go through, usually you have more older women than men. And those who are very familiar with having stayed with elderly people, sometimes it starts as dementia. Instead of them to seek help for them, they begin to assume that the way they are talking and behaving, there may be other meaning to it, and then they will try to attack the spiritual misinterpretation to say that these women are witches. And Mr. Speaker, the sad thing is that sometimes the community pressure that is put on these innocent individuals make them to they themselves even believe that they are witches, when in actual sense, all what they are saying doesn't really make sense to any meaningful person. Mr. Speaker, the sad is the teachings of Islam and the Quran and the Holy Prophet have stated time and time again that there was a time that a disciple came to ask the Holy Prophet, apart from the God that I worship, who should I honor? And the Prophet said, your mother. Then he said, after that, who else? He said, your mother. They said, after that, he said, your mother. Then the fourth time, he said, your father. Meaning that mothers are supposed to be revered and be treated extraordinarily. But in these communities, and many parts of our country, at the time that they needed support most, that is the time that you get these kind of wicked guys with some of them fake background come to suggest that these are witches and therefore they should be taken to some isolated place. Mr. Speaker, one interesting agony I have not seen, I'm not that old, Mr. Speaker, but at least over 5 decades, I've never seen a prominent person like Mr. Speaker's mother being called witch. Or a member of parliament who is prominent in the constituency, they say his mother is a witch. Anytime they are going to do this enabling, they are doing it to the very poor ones. In fact, there are behaviors that some of us, our parents may do because of maybe they have dementia, but because of our stature in the society, everybody is even afraid to dare suggest that they are witches. But for the innocent, poor ones, the least provocation, then they say that, oh, she's a witch. And sometimes the painful thing is that her own children, who are struggling in life out of sometimes their own misdeeds, will then say, she's the one that's not making me prosper. And then you see her own children support these witchcraft doctors to maltreat their mother. and innocent persons. And the sad one, Mr. Speaker, is that sometimes when these women have painfully lost their own children, either maybe through accident or through some tragedy, then they now, in addition to this pain that these women are going through, then they come and add that, oh, she's the witch that caused the death of these children. And then they go and put her in a very deplorable environment and virtually enslaving them. Mr. Speaker, this law is long overdue. And I want to thank you sincerely for giving our colleague, Honorable Francis Xavier Sosu, the support to be able to carry out this private members' bill. It is my prayer that when we are done, the presidency will assent to it as quick as possible so that we'll begin to bring to book the perpetrators and stop this heinous crime against very innocent members of our society. So, Mr. Speaker, I'm grateful that we are getting the opportunity to do this, and it's my prayer that if time may permit, we may take it through a fast-track process to finish it before maybe we rise, if time will permit. So I thank you very much for the opportunity to have contributed. Thank you very much.
Yes, Chairman, you want to add something?
Yes, Mr. Speaker. I thought the others had finished contributing, so I wanted to conclude on the report.
Let me finish. Then let me listen to
Very well, Mr.
the honourable member. Then I'll come back to you. I will come to you.
Thank you very much, Right Honourable Speaker, for the opportunity to add my voice to earlier speakers to encourage this House to accept the report and consequently pass the bill. Mr. Speaker, earlier colleagues have spoken very well to the need for us to pass this bill and criminalize the accusation of witchcraft. Mr. Speaker, the only thing I think I have to add is that as a co-sponsor of the bill, what we are trying to do is to stop the practice of witchcraft. It's not to interfere in people's cultural or spiritual beliefs. What we are seeking this amendment to criminalize is that we find it offensive if you, as a citizen of this country, elect to criminalize somebody or accuse somebody of the practice of witchcraft. That is what we are seeking to criminalize. And Mr. Speaker, this is because there are several reasons why people may be involved in or practicing or associated with witchcraft or spirituality or culture that has some leaning with witchcraft. Mr. Speaker, as you may know, in our traditional African religious practices, witchcraft in all its senses is not necessarily a bad thing. Indeed, in some cultural settings, we have positive witchcraft. And those positive witchcraft are practiced in several communities and several cultures to contribute to the advancement of communities. What we tend to find in most cases in the Ghanaian context, in some contexts in Ghana, is that very old women normally and vulnerable groups are accused if something wrong happens. And then you have people who elect themselves as witch finders and witch doctors, who will then sit in places, do some charms and concoctions, and on the basis of that, come to a determination that somebody is declared a witch and therefore subjected to some inhumane and punishment. In most cases, even concentrate them on camps where inhumane treatments are meted out to them. Mr. Speaker, in such contexts, most of their fundamental human rights are violated. Mr. Speaker, during the process of putting this bill together, we had opportunity to travel to some camps, some witches camps in the northern part of the country. And Mr. Speaker, some of the conditions that we find in the witch camps are so dehumanizing that as a country,
as an earlier speaker said, in the 21st century, we shouldn't allow and we shouldn't condone such practices in the place. Indeed, some witch finders and doctors that are heads of these camps take advantage of these vulnerable women. Indeed, some become pregnant for these witch finders and witch doctors, and that is not good enough. Mr. Speaker, some of them have to accept and elect to even confess that they are witches, because that is the only way they can survive in the communities that they find they are bringing them, they are coming from. And so, Mr. Speaker, I think it's an opportune time for us to all rally together and accept that as a country, that accusation of somebody of witchcraft is wrong and we should criminalize it. I thank you very much, Mr. Speaker, for giving me the opportunity to add my voice to this report. And I urge the House to pass it, and let's criminalize the accusation of witchcraft in this country. Thank you very much, Mr. Speaker.
Yes, please.
Thank you very much, Right Honorable Speaker, for the opportunity to add my voice to this all-important bill. As a co-sponsor of the bill, Mr. Speaker, it is very important. I want to use this opportunity to urge this, our great chamber, this great house, to all rally our support to pass all this, this very important bill. Mr. Speaker, we live in a society where innocent women, especially, because most of the victims who are being accused often are women. We live in a society where innocent old women, through no fault of theirs, are accused in one way or the other and branded as witches. I just want to divert a little bit from the many issues that our colleagues have already raised. And I feel that if there is a reason for us to believe that some people have this special supernatural powers, is there a chance for us to harness these potentials for the betterment of society, instead of attacking and, victimizing and abusing them and calling them names? People in our communities have lost their lives. Others have also been separated from their families, all in the name of being tagged or being called witches. And so, Mr. Speaker, through this, I wholeheartedly support the bill, and I believe that perpetrators who go against the bill, or eventually when it becomes a law, will be held responsible and will be made to face the consequences. Thank you very much, Mr. Speaker, for the opportunity to add my voice.
Ranking Member, Defense.
Thank you, Mr. Speaker, for giving me the opportunity to contribute to this debate. Right Honorable Speaker, I am looking at page 7 of the committee's report. And on page 7, Mr. Speaker, the statistics churned out shows clearly that the activities associated with witchcraft and the maintenance of witch camps clearly is an abuse and a violation of the rights of women. And so, Mr. Speaker, we can talk about gender discrimination here. How come that, given the total number of so-called witches we have in the various camps, and the statistics here shows that out of 539, females constitute 498, representing 92%, whilst the males constitute, or they make up 41%, no, 41, which is about 8%. Mr. Speaker, when I attended the University of Ghana, in the first year, we studied a course in African Studies, and witchcraft was one of the topics we dealt with. In those academic encounters, Mr. Speaker, it was brought to light that in the witchcraft industry, the males are actually the executioners. And so when souls are caught for purposes of execution in the spirit realm, Mr. Speaker, it is not the females who are the executioners. Rather, it is the men in the spirit realm. And so, by this logic, by the logic that we were exposed to in our African studies, the numbers in terms of witchcraft and their practices should either be even or more dominant or prevalent amongst males, because in that sense, they are the executioners. And yet we find that in the witches' camps, Mr. Speaker, the overwhelming majority of those kept there under inhuman conditions are females. Is it because they are of a weaker sex? And therein lies the discrimination we are talking about. And so, in this era, in this time and age, Mr. Speaker, the treatment meted out to suspected witches should have no place at all, no place whatsoever. Then, what baffles my mind is that most of the camps, and I asked this question when the committee had its engagements, I don't know how come the camps are concentrated in one particular corner of our country. Why is it so? Witches are supposed to be distributed amongst all the ethnic groups in the country. In fact, according to what we have been taught, they can fly all the way to foreign countries, perform their duties and return. And yet the camps are concentrated in only one part of the country. It gives us a bad name, Mr. Speaker. And so when the discussions around this bill started, I was very happy that for once the stereotype, the stigma that comes or is associated with those of us who happen to come from that part of the country, once and for all, would be nipped in the bud. Don't point accusing fingers at us and say, but you are the people responsible for all the abuses in the name of witchcraft. But, Mr. Speaker, let us even talk about witchcraft and its ramifications in law. The law recognizes the existence of matters of the spirit, but you cannot prosecute anybody in court for indulging or engaging in acts of witchcraft because you cannot scientifically establish it. Now, if you cannot scientifically establish or prove the activities of witches in a legal setting, why must we allow them to be abused? Because when push comes to shove, Mr. Speaker, we are called upon to establish their guilt. If the accusation is that they killed somebody, you are called upon to establish the guilt of the so-called witch. You cannot prove. And so, as a legislative body, Mr. Speaker, it is imperative for us to criminalize the activities associated with all the violations that have been mentioned in this debate relative to witchcraft and their related activities. I am also excited, Mr. Speaker, that in line with the argument I just made, the bill recognizes the fact that, and its focus really is not to proscribe witchcraft, because if somebody is born with supernatural powers and can, Mr. Speaker, predict what will happen in the future, such a person may qualify for a witch. How do you prescribe that? How the person acquired the witchcraft, you may not be able to establish. And so any attempt to criminalize witchcraft itself may be problematic. And that is why this bill says, look, that we are not interested in prescribing witchcraft per se, but the violations and the abuses associated with witchcraft is what the bill seeks to prescribe. And the example is the case of Ekuya Dente, that the bill cites as an example. Several other cases have happened. Ekuya Dente was the one that came to the limelight. But I know of instances where suspected witches were forced to drink concoctions. In fact, they were poisoned to death in the name of exorcising the spirits that are supposed to grant them the powers to kill people from their bodies. They were literally poisoned, forced to drink concoctions. And so, Mr. Speaker, I want to commend the sponsors of this bill. The bill is timely, and I'm happy that this bill, when passed into law, has the prospects to bring to closure the maintenance and operation of the witch camps that have been mentioned in this report. Mr. Speaker, I thank you for the opportunity.
Let's listen to the minority chief whip, then we listen to the chairman, and I put the question.
Mr. Speaker, thank you for the opportunity and want to thank the sponsors of this bill. When passed, Mr. Speaker, I believe would give the opportunity for very vulnerable people in this country to feel safer. Mr. Speaker, I've also listened to many colleagues, and I can say that everybody in this country knows that part of the reason we have this, we are a very superstitious society where people are comfortable to blame the unexplained on things they cannot understand. Mr. Speaker, ironically, in this country, I know people, when they hear an owl chirp in the night, they break into tongues, believing that that owl is an evil spirit flying over their house. Mr. Speaker, owls are simply nocturnal. They can only hunt or see properly in the night. So when an owl flies over your house in the night, it's not actually looking for your blood. It's just basically looking for an insect, as a matter of fact. Mr. Speaker, interestingly, just when you were away, we were doing one of the deals on the wildlife resource management, and the schedule that we've added is calling for the protection of owls. I'm not sure how people are going to be feeling knowing that we are making a law to protect owls. So all those people who have been killing owls thinking they are killing evil spirits, I don't know how they are going to feel about it. But Mr. Speaker, the most important part of this is to, as lamented by my colleague, Honorable Agaga, is to assume that when people get old, frail, and vulnerable, what we do to them is to suggest, especially in poorer communities, that they have become the source of people's misfortune. Like he said, interestingly, nobody accuses old people in homes at East Legon. How do you call it? Cantonment or anything as being witches. It is only in our villages that old people are witches. And it should tell you that it is just a superstitious thing. And Mr. Speaker, this is made worse by a section of the religious community. When we are unable to explain certain things, we just blame it on the fact that it's a spirit. Mr. Speaker goes for an interview and completely underperforms. He goes home, and if he doesn't get a job, he starts looking for whoever he quarreled with, and most of the time, it is his frail grandmother in the house who made him not get a job. In any case, ask yourself, would your grandmother actually wish you bad? Why didn't he do anything bad to you when you were a child in the house? Why is it that when she's rather old that he's going to bring misfortune to you? So, Mr. Speaker, when this bill is passed, I believe it will be one way we can prove to everybody else that we are a society that protects our vulnerable. Somebody said witches are supposed to be flying, can even go to other countries without visa. Mr. Speaker, I am sure if there's any witch in this country that is capable of flying people from Accra to New York tonight, I am not sure that witch will be stoned or will be taken to Agaga's village. That witch would have been patronized more than American embassy. It's simply because it is not true that those people are witches. It is just the fear of the unknown. And so, if you have young people in your society, let's protect them. And I want to once again thank the sponsors of the bill, that this is one of the finest things we can do as a people to protect those who are actually vulnerable. In any case, when you are in this house, you are 30, you are 40, bear in mind, when you are a woman, you will become that witch probably because of your age. If you live long enough to be 80, there will be a young person in your village who will be calling you a witch. Would you be happy about that? I don't even know why they don't refer to wizards that much. Because there could be more bad old men than bad old women. So if you are a man, imagine if you are 90 and you are at home and young people in your community regard you as the source of their misfortune. I don't think it's appropriate. Mr. Speaker, I want to thank the sponsors and encourage everybody to support this so we pass this into law. I hear that this is not to prescribe witchcraft. Is there anything like witchcraft? Where is the proof anyway that there's anything like witchcraft? If somebody can can predict what will happen in the future, why is it called witchcraft? That person is just probably more intelligent than the rest of us. So I don't actually believe, Mr. Speaker, that there's proof that there's anything like witchcraft. I believe in God. I believe the devil exists, but I've never seen a witch before. I've never seen a wizard before. All I know is that when you live your life well, God will order your ways in such a way that whatever He wants to come your way may come your way, and let it be like that. So, Mr. Speaker, I encourage colleagues to support this bill for us to pass it into law. If we can do all of that today, that will be very helpful, Mr. Speaker. I thank you for the opportunity.
Yes, Chairman.
Mr. Speaker, I would have to thank the sponsors of this bill. It's one of the inhuman treatments that we do as a country, and I'm grateful that the committee unanimously agreed on the report, and I'm happy that the House has also unanimously agreed with us that witchcraft accusations and witch doctors and witch finders, as we find in our criminal code, must be done away with. Let it not be told that we are passing laws to acknowledge witches or do away with witchcraft. We do not, and it has never been agreed or proved that the beliefs that we have as witchcraft is a reality. It is a superstition, and it's surprising that all over Africa, it is only, and Mr. Speaker, at page 7 of your committee's report, we stated that in Africa, it is only in Ghana that we have witch counts. And this does not sit well with our constitutional provision that nobody must be subjected to inhuman treatment, or every individual is entitled to decent dignity. It is one of the things that are dragging us down. As far as 17th century and 16th century, United Kingdom had made laws to abolish witch doctors and witchcraft. So this has been long overdue, and that is why I commend the sponsors of this bill very much. Mr. Speaker, my concern rather is the post-passage of this bill. We must, together with the civil societies that assisted in passing or coming out with this bill, for instance, the Action Aid, then we have the Senna Institute, then we have the Amnesty International, and all these organizations, they must collaborate with us to make sure that these camps, these illegal institutions are done away with, so that we can have a good society to live in. I'm grateful, Mr. Speaker.
Honorable members, I think we've come to the end of the second reading, and I'll put the question. And the question is that those in favor of motion number 29 on the order paper say aye. Those against say no. The ayes have it.
An act to amend the Criminal Offences Act 1960, Act 29, to prohibit the practice by any person as a witch doctor or a witch finder, to proscribe the declaration, accusation, naming or labeling of another person as a witch, and for related matters.
Honorable members, the Criminal Offences Amendment Bill 2022 is now read a second time. I hope and believe we had witch and witchcraft in Ghana. It's quite positive to have those things. Those of you who read the Bible, you are aware of the witch of Endor. And the witch of Endor was summoned by the first king of Israel. Who is the first king of Israel? Saul. To summon the spirit of Prophet Samuel. That is positive. So if we had witches and we had the craft to be doing such great things, it should rather inure to the benefit of the people. But unfortunately, for lack of ignorance, for lack of knowledge, my people perish. So they lack the knowledge, they lack the wisdom. They then impose it on innocent, poor people who are suffering other dementia or other old age kind of sicknesses. That is a challenge. That is why the submission that we are not criminalizing witch or witchcraft, but that we are criminalizing those who are criminalizing some people because they lack the knowledge of why the people are behaving that way. And so it's a good thing, and I want to commend members for the unanimous support of the bill. And to thank the sponsors, it wasn't easy going around and getting all this information. We will then move on to the final stage of the bill, and that is to look at item 31. 31st, the procedural motion, item 30, and it stands in the name of the leader of the proponents and sponsors of the bill, Honorable Francis Xavier Kojo Sosu.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, I move that notwithstanding the provisions of the Standing Order 1281, which requires that when a bill has been read a second time, it shall pass through a consideration stage which shall not be taken until at least 48 hours have elapsed. The consideration stage of the Criminal Offences Amendment Bill 2022 may be taken today. I beg to move.
Honorable members, this is second reading. We can up to second or not to second. And so I put the question. It's a procedural one, anyway. Any seconder?
Mr. Speaker, I beg to second the motion.
Motion moved and seconded for the consideration of the House. I put the question. Those in favor of the motion say aye. Aye. Those against say no. The ayes have it. The motion is carried. We go to item 31. Criminal Offences Amendment Bill 2022 at the consideration stage. Honorable members, clause 1. There's a proposed
Prohibition of
amendment.
witchcraft practices.
There's a proposed amendment by the chairman of the committee. Yes, Chairman.
Thank you, Mr. Speaker. As was done in the death penalty, we are almost doing one amendment of one session. So if I may go through the items as we have it in Roman numeral 1, amendment proposed is that section 316A be deleted.
Those in favor say aye. Those against say no. The ayes have it. The motion is carried. Yes, please.
Mr. Speaker, the item number 2, section 316B, subsection 1 be deleted. I so propose.
Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The amendment is carried. Now the third proposed amendment.
Amendment proposed, section 316B, subsection opening phrase, subsection 2, line 1, delete professing to be and insert acting as. I so move, Mr. Speaker.
Honorable members, motion has been moved for the consideration of the House. Being no consideration, I put the question. Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The amendment is carried. We'll go to the fourth proposed amendment.
Section 31B, subsection 2, paragraph B, delete and insert the following. B, administers any substance or test to another person for the purpose of determining the perpetrator of an alleged crime or any act complained of by witchcraft. So I so propose, Mr. Speaker.
Honorable members, motion moved for the deletion of 316B 2B and the insertion of what has been detailed out at page 19 of the order paper. Those in favor say aye. Those against say no. The ayes have it. The amendment is carried. Amendment number 5.
Amendment proposed, section 31B, subsection 2, paragraph C, line 1, delete an unnatural and insert any. And in line 3, delete whatsoever. I so move.
Motion moved for the consideration of the House. Those in favor say aye. Those against say no. The ayes have it. The motion is carried. Can we now move to proposed amendment 6?
Section 316B, closing phrase, delete and insert the following. Mr. Speaker, because it's more than 4 lines, as advertised on page 19 and 20. I so move.
Honorable members, motion moved. Those in favor say aye. Those against say no. The ayes have it. The amendment is carried. We move to the proposed amendment 7.
Amendment proposed, subsection 316C, subsection 1, lines 3 and 4, delete term of imprisonment of not less than 3 years and not more than 5 years, and insert the following. Fine of not less than 150 penalty units and not more than 2,500 penalty units, or to a term of imprisonment of and not more than 5 years, or both, as so proposed.
Motion moved for the amendment as detailed out at page 20 of the order. Those in favor say aye. Those against say no. The ayes have it. The motion is carried. On to proposed amendment number 8.
Amendment proposed, section 316C, sublines 5 and 6. Delete term of imprisonment of not less than 1 year and not more than 3 years, and insert the following: fine of not less than 150 penalty units and not more than 2,500 penalty units, or to a term of imprisonment of not less than 1 year and not more than 5 years, or both. Thank you, Mr. Speaker.
Motion moved. Yes. Honorable Muntaka.
Thank you, Mr. Speaker. Mr. Speaker, I just wanted to be sure whether the chair is aware that we are linking the penalty units to the term of prison, so that we just don't have the penalty units far away from the normal imprisonment that goes with it. I just want to be sure, because if I look at the number of penalty units that we are proposing, about 1,500 penalty units, and its equivalent of prison terms is 1 year, and then 2,500 penalty units and 5 years. Are we checked to be sure that they are consistent, or we are just stating them arbitrarily? Mr. Speaker, I just wanted that clarity.
Mr. Speaker, we've been assisted by the Attorney General's Department in drafting the bill. Thank you.
We have a law on it, and the law has given a range. So it's not always that they must be the same, but if they fall within the range, then it's permitted by the law. And so I think the chairman are working according to that act. Yes.
Mr. Speaker, that has been taken into consideration. A penalty unit is about 12 cities. So 150 is 1,800. That is, if you are giving 150 penalty units, then you are going to pay 1,800, or you go to prison for 12 months. So the reconciliation has been done before arriving at these various figures.
Well, yeah, you answered partly, but he was looking at the differences between the earlier amendment and this current one, and that is why he went to. But definitely, the law guided the committee, and I think the draft person has also clearly explained it further to me as a technical advisor. Yes, so those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The amendment is carried. We now take proposed amendment 9.
Amendment proposed, section 316C, subsection 3, line 1. Delete imputes or, and in lines 4 and 5, delete term of imprisonment of not less than 3 years and not more than 10 years, and insert the following. Quote, fine of not less than 150 penalty units and not more than 2,500 penalty units, or to a term of imprisonment of not less than 1 year and not more than 5 years, or both. I so move, Mr. Speaker.
Motion moved for the consideration of the House. I put the question. Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The amendment is carried. We go to proposed amendment 10, Roman 10.
Amendment proposed. Section 31D, line 1. Delete is present at, and in lines 4 and 5, delete term of imprisonment of not less than 200 and not more than 5 years, and instead the following. 5, fine of not less than 150 penalty units and not more than 2,500 penalty units, or to a term of imprisonment of not less than 1 year and not more than 5 years, or both. I so move, the Speaker.
Motion moved for the consideration of the House. Those in favor say aye. Those against say no. The ayes have it. The amendment is carried. We go to proposed amendment 11. Yes, Chairman.
Mr. Speaker, amendment proposed, section 316E, delete and insert the following as advertised at page 21 of the today's order paper.
Honorable members, amendment has been moved. It's for the consideration of the House. I put the question. Those in favor of the proposed amendment say aye. Sorry. Yes, Honorable Montaka.
Thank you, Mr. Speaker. Mr. Speaker, when I look at the amendments that the chair, the committee is proposing, they seem to be prescribing virtually about the same punishment for almost all the levels. Mr. Speaker, I'm more concerned about the community leader, because if the community leader could supervise this and authorize it, must he not take much harsher punishment than the others? Because if this practice could get stopped, it will start from the community leaders. So I was wondering why we may not propose a harsher punishment there, as to serve as a deterrent. And the way the committee is amending and virtually making whether the witch doctor or the accuser and the community leader all taking about the same punishment. I was hoping that maybe we should consider that for the community leaders, if theirs could be harsher. I don't know. I've not been part of the committee and I've not followed this keenly. I don't know how much work has been done in it, how they concluded to make the punishment, what do you call it, virtually the same. If the chairman could provide some explanation, I'll be grateful. Thank you, Mr. Speaker.
Well, what I know is just to say that it's a range. It's not specific. It's the evidence before the court that will give a clue to the judge as to the specific punishment. So you can see the range being the same, but actually when it comes to the offense, the evidence will show that this person should rather get lesser punishment than the person you are talking about. Or the community head might not directly be be involved, but just by withholding some information, that person too could be charged. And so even though you are the head, you may not have played a major role. So it's the evidence before the court that will determine what specific sentence to be given. That's why they range. But members, if you want to add more value to it, you can do so.
Mr. Speaker, you are right. What I would want to add is that for every event, there is an antecedent factor. If a witch doctor do not pronounce that this woman is a witch, probably the community head wouldn't have a role to play. So the range is given so that the judge will be accorded the opportunity to look at the circumstances, the role that each person has played in giving out the punishment. It's likely somebody may be in prison for 2 years, but somebody may be given a maximum punishment of 5 years, or both the fine and the imprisonment. So really, it's a range.
So, honorable members, I put the question. Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The amendment is carried. We now look at proposed amendment 12. Chairman.
Amendment proposed. Section 316F, head note, delete and counseling.
Honorable members, amendment proposed. The head note now reads is compensation and counseling. And we are being asked to delete that. We just delete and counseling and leave only compensation, because the subject matter under that is just dealing with only compensation. There is no counseling in the 316F. There is counseling. In B, the victim to undergo medical treatment or counseling conducted by or under the supervision. Yes, Honorable Muntaka.
Mr. Speaker, that's just what you drew the attention, because if you delete and cancelling, then I don't know whether you are going to propose the deletion of B, because B talks about the victim to undergo medical treatment or counseling conducted by or under the supervision of a health professional at the expense of the convicted person. So if you delete and cancel it, it will be very difficult to let the B's stay within that head note.
Yes, Chairman.
Mr. Speaker, if you had allowed us a minute, paragraph B will be deleted very soon, so we wouldn't have the counselings. That's why, but we need to go by it clause by clause. That's why we have to. So you will soon understand
so there is a
why.
proposed amendment yet to come. So those in favor of the proposed amendment say aye. Sorry, I just went through page 22 and I saw that what he said is true, because there's a proposed amendment at 14, which says subsection 316F, paragraph B, delete. That's in support of it. But if you have something to say, yes.
Yes, that's where my worry is, because I looked at it and I was hoping that they were going to maybe put it under a different heading or create its own heading. But the deletion is going to mean that they are not going to give opportunity for counseling. And Speaker, as they themselves will allude along the bill, there's this mentioning that people that may be seen doing this act can be referred to a mental health facility. So if now under conviction you want to take away the opportunity for counseling, I find it very difficult. I thought that that's a very important aspect that needs to find expression in the bill. So if they were taking it out to create its own head notes, that would have been understood. But now from the further amendment that we'll be doing later, it will be to delete it completely, and there will be no expression of that anywhere else. And I thought that would be worrying, unless the chair will explain why they want to do away completely with the possibility of the victim undergoing medical treatment or counseling that had been proposed in the original bill. Thank you, Mr. Speaker.
Yes, ranking member.
Mr. Speaker, with due respect to my learned former chief whip, the committee has taken into consideration the constitutional imperative in Article 108.
108.
And bearing in mind that this is a private member's bill, we do not want any provision that will provide financially, we make financial provision. The Speaker, if you are looking at this, if the bill is suggesting that the victim to undergo medical treatment or counseling conducted by or under the supervision of health professionals at the expense of the convicted person. The person is convicted and probably the person is in prison. If this provision is allowed to stay, how is the person going to do that? Then it must be done by the state or healthcare facility, and taking into consideration the constitutional imperative, we realize that if the victim will not be able to do this, it's better we delete that provision from the law.
Yes.
Mr. Speaker, I was surprised my colleague said that the reason they want to delete it is because it will mean that the provision that private members' bill should not attract a charge on the public purse would have. Mr. Speaker, if the way to resolve the issue is for the person to be taken through counseling, or the person needs a medical care, in this case we are talking about victims as well. Why would you want to ignore that simply because you think it will be a charge on public purse? Indeed, when you jail somebody, it is your responsibility to keep the person in decent health. Is it not also the case that naturally prisoners undergo medical treatment at the expense of the state? They do. So, Mr. Speaker, I don't think it's a good point to say that we should delete it simply because we are afraid of breach of that provisional agreement. It will mean that we know very well that the people, we are trying to cure something. The people need counseling. They need medical care. But we can't give them because it will be a charge on the public purse. I don't think that is appropriate. What Honorable Mutakat is saying, the leader is saying, is appropriate. We should leave it in the law. I don't think government will say that they will not accept it because it's a charge on the public purse.
Yes, Muntaka.
Thank you, Mr. Speaker. Mr. Speaker, I'm worried by the rankings explanation, as my chief whip said, because the prison that you are sentencing the person to is going to be at a cost to the state. That is okay, because I was hoping when we get there to delete at the expense of the victim, because if the court proceedings per the judge's assessment, the victim requires counseling and some help attention, I think it's only fair for that person to be ordered to go through that. And it shouldn't be at the expense of that person. Because if you are going to stretch it to Article 108, then it will be very difficult, because when you are incarcerating these persons, they are going to be at a state prison where it will be, the person will be fed and taken care of with state resources. So, Mr. Speaker, I don't think that should be a good reason. I should rather think that we should keep it and even delete. It should be at the expense of the victim, because that will be double jeopardy. You've incarcerated the person and you are telling the person that where the judge strongly feels that the person requires some help attention, it should be at the person's expense. So, Mr. Speaker, I hope that they will end the counseling and also keep the B, and probably if that is done, then I can come with an amendment to delete the expense being borne by the victim. Thank you, Mr. Speaker.
Yes, please.
Thank you very much, Mr. Speaker. Mr. Speaker, I recall that during the consideration of the bill at the committee level, we had memos from stakeholders, and one of the compelling arguments stakeholders made was the fact that you cannot legislate to compel someone to have a medical examination. That it goes without saying. So, for example, on account of our plea bargaining laws now, there are several provisions within which a person who is considered to have been violated to be taken care of. That is, if the offending party accepts his wrong and are willing to make amends, including even payment of compensation and taking care of the victim and all that. So in order not to complicate the provisions that had been proposed, it was okay to remove the mandatory or the legal requirement of counseling, even though we know that it goes without saying because it could be covered under a plea bargaining arrangement. That was the reasons why that proposal was made, Mr. Speaker.
I actually think that the issue raised by Honorable Mutaka has merit. It has merit. Article 108, even though now it's before the court, including the Supreme Court, is understood differently by different people. I don't think that that article is talking about financial implications. I think that article is talking about making provisions for, and they itemize the issues. And therefore, there must be in the bill a provision that is asking that some money be spent on this, a provision that is asking for a charge, a provision that is talking about that is dealing with increase, decrease. You can bring a private member's bill to call for it. That's what the Article 108 is talking about. I don't think this bill is making a provision for there to be a charge or imposition of tax or payment or issue of withdrawal from the consolidated fund of any new fees. But we know already in the existing laws that these things are done. It's not a new thing that you are bringing in. It's an existing legislation, even including our national health insurance. So I don't think it will be offending Article 108. I rather think that the victim needs those things. It needs medical attention, it needs counseling. And it should not be at the expense of the victim. And so I'll rather urge that the committee should look at deleting at the expense of the convicted person and allowing this thing to stay, because that will be what will be really a response of society to supporting the victim of an unlawful act or behavior by any person. So, Chairman, what do you say to that?
Mr. Speaker, I guess that the gravamen of the argument is what the leading sponsor raised. We considered all this at the committee level, but we were of the opinion that we cannot make a law and subject the victim to counseling. It must be at the option. If he wants to go for counseling, the victim can choose to go for it, but we cannot legislate as if we are compelling the victim to go for counseling. And that's why we needed to do away with the counseling.
You should be careful about the subject matter. When you talk about a victim, what is that type of victim you are referring to? You talk about witchcraft. And at the second reading, you all argued, which is right, that usually is the helpless, the marginalized, the poor, the widow, the women who are rather victims, not the affluent, the people with the money to pay, not the men who are more empowered, but is the helpless women, the elderly, old, aged ones who have nobody to fight for them. So you should take that into consideration. And that person should not be called upon to pay for the counseling or the treatment. But you are not also compelling. The provision you have put there says the court, in making an order under this act, may. So you are not imposing. So the court will take into consideration the circumstances of that particular case. And then you know what happens in court dealing with this is there's usual consultation before the sentence or this is imposed. The orders are made. They will ask counsel, this is there, and at the end of the day, it's not like they are imposing it or compelling the victim to undergo those things. But if they need be, the court may do so. So I don't think that you are imposing it. Please.
If I may, for instance, let us use one of the witch counts as an example. Let's say the Gambaga, we pass the law, we would want to, we see that there are victims there. They tell you that I don't want to go anywhere. I'm happy to be here, and this is my home. What do we do? That is the situation that we were confronted with. And we realized that there could be a possibility for an individual that we see as a victim, that person is at disadvantage position. The person says, I am all right. And we have no option of pushing the person to say that go through counseling, or that was the reasoning. But this is our law, this is our bill, and if we want to include it, the chairman will reconsider the position of the committee.
The example you just cited is the main reason why this should be done. You can see that the person then has a problem, a serious challenge that society should respond to. So you cannot just abandon the person there. The person is not even in the position to take a decision. So it's for the society to come to the aid of the person. Yes, ranking member.
Then, Mr. Speaker, with this view, then I beg to suggest that we should look at both the A and the B. Because I believe the A is saying that the convicted person is to pay compensation simply because we were under that particular impression that we couldn't putting it on the state. We look at the difficulty that the person convicted to prison term will be in prison and yet be able to pay compensation. On the B, the second issue is that the court may is giving the discretion to the judge, and the judge may do that without necessarily consulting the victim whether I should give this order or not to give the order. The court will look at the circumstances of the victim and then make the order. Then in that case, will it be left with the victim to comply with the order, even if it is against the person's own faith? Like, I know people who wouldn't even attend hospital based on their religious faith. Then once it is as a result of the court order, a court order is expected to be obeyed. What happened in the circumstances whilst the victim have not subjected himself to that particular order. But if the sense of the House is that we should maintain the provision and delete at the expense of the convicted person, the Speaker, I will agree perfectly to it. And then we can go back and look at the A, whether the compensation can also be done by the state.
Honorable Muntaka.
Thank you very much, Mr. Speaker. Mr. Speaker, you rightly said, in fact, it is the example that the chair gave. That's the more reason why this should be there. Mr. Speaker, I want to encourage the chair to read about the abolition of the slave trade in America in 1865. Most of the slaves, out of desperation said, why? We wanted to continue being slaves because we don't know where to go. It took the state to rehabilitate them and resettle them. That's the responsibility of all of us to do that. So we cannot leave it to the victim because they are not in the position to even take a reasonable decision. So, Mr. Speaker, you said that but the angle that the ranking is adding, I'm not very sure whether, because the heading settles it. The court is making an order under this act may. So the circumstances will determine. So, for example, if it is the ranking, Honorable Anyafo, who is accusing Honorable Doyo of witchcraft, and the court knows that Honorable Anyafo has resources and can compensate Honorable Doyo, the court will order that because the court is averse with all these facts. So that's why we are saying that it's at the discretion of the court. Even where, for example, the victim has a very strong family with strong financial background, the court can look at order and say that, okay, in this case, assist the victim with A, B, C, D. But those circumstances will be determined in the court. But if we take this out, honorable colleagues, we'll be doing so much injury to the victim than if we keep it. So under that circumstance, I want to plead with the committee to adhere to the suggestion by Mr. Speaker and all of us that we keep the counseling at the cost of the victim so I can make progress. Thank you, Mr. Speaker.
Mr. Speaker, in that light, the sense of the House is that amendment proposed at Roman numeral 12 should fall. So I withdraw the amendment.
Well, I think it's better to withdraw the proposed amendment, and I think the chairman has done the right thing. But with regard to religious faith, or whatever faith, I will refer you to read the case of Jim Jones of British Guiana. I'm sure even if you Google it, you will come across it. Jim Jones. Jim Jones of British Guiana, now the island of Guyana. You get to know why we should not allow those things. Jim, J-I-M, Jones, J-O-N-E-S. So, honorable members, the proposed amendment has been withdrawn. Can we now go to proposed amendment numbered is it 13? Sorry?
Mr. Speaker, we are on 13 now.
13,
Roman
yes.
number 13. Amendment proposed, section 6316F, opening phrase, line 1, delete may and insert shall.
Honorable members, motion moved is for the consideration of the House. I put the question.
Mr. Speaker, I'm grateful. In that respect,
you are repeating the same proposed
the 13
amendment.
and the 14 fall. Amendment proposed in 13 and 14 would fall.
Withdrawn.
I wouldn't move them.
Yes. Yes, Honorable Mutaka.
Thank you, Mr. Speaker. Mr. Speaker, I hope that he was going to he's going to amend rather the deletion of line 316F B in line 3 after professional, delete at the expense of the convicted person. So that the reading will now be, the rendition will now be, the court in making an order under this act may order B, the victim to undergo medical treatment or counseling conducted by or under the supervision of a health professional. Thank you, Mr. Speaker.
Let me just handle his withdrawals first. Then you can move your motion.
Okay, sir.
Yes. Honorable members, the motion before us, as moved by the chair, is the withdrawal of the proposed amendment in Roman 13 and 13 and 14. Am I right? 13 and 14. Those in favor say aye. Those against say no. The ayes have it. The two proposed amendments are accordingly withdrawn. Yes, now, Honorable Muntaka.
Thank you, Mr. Speaker. The clause amendment proposed, section 315F B, line 3, after 316F B, line 3, after professional, delete at the expense of the convicted person. So that the new rendition will now read, the court in making an order under this act may order B, the victim to undergo medical treatment or counseling conducted by or under the supervision of a health professional. Thank you.
Honorable members, that's additional proposed amendment moved by Honorable Montakat is for the consideration of the House. Those in favor say aye. Aye. Chairman, yes.
Mr. Speaker, you already treated the question, but I wanted to find out if the court makes the order, who should be responsible for the order to be carried out? Because what you are seeking to delete, we were saying that at the expense of the convicted person, and you seek to propose the deletion of court orders. Is the court going to act? Then we should add something. If it is the state or any other person making sure that the order is carried, I'll be interested, rather than saying that the court should just make an order that the person must go through a supervision under a health professional.
Yes, please.
Mr. Speaker, we are already sending these convicted people to prison. And who pays for the upkeep of the person in prison? Is the state. So I don't think we need to write and say that the state should take care of the medical bills of prisoners. It is a given that when people are in prison and they fall sick, it is the state that takes care of their medical care. So I don't think we should legislate and say the state should, because the convicted person is already in the care of the state. We cannot run away from the fact, Mr. Speaker. I don't even understand whether, and I want to agree with you, Article 108, the good thing is that when you read it, it says, Parliament shall not, unless the bill is introduced by the, or the motion is introduced by or on behalf of the President. And A, proceed upon a bill, including an amendment to a bill, that in the opinion of the person presiding, in this case, Mr. Speaker, it is your opinion that matters. If your opinion is that it is not an additional charge, because the NHIS and everything exists already, opinion of the Speaker, your opinion is that it is not an additional charge, then there's nothing that we are doing which is wrong, Mr. Speaker. You are right perfectly. This provision that strengthens your hand that, in your opinion, what we are doing is appropriate. Because the prisoners would have to be taken care of by the state.
Yes, Honorable.
Yeah, thank you very much, Mr. Speaker. Mr. Speaker, I also write to support the proposed amendment by Honorable Muntaka. And the reason why I make this proposal is that there is an existing legislation on plea bargaining. In fact, under the Plea Bargaining Act, all kinds of arrangements can be made, including the convicted person, opting to pay for compensation and restore even the person who has been violated. So I believe that leaving it under the supervision of a medical practitioner should be sufficient, Mr. Speaker.
Yes, Honorable Member, I agree with you. But I want to add, please, Article 108 is a procedural article. It's procedural. Once the one presiding takes the decision that the bill does not offend those provisions, that ends it. You can only take the person presiding to court for wrong exercise of a discretion. You understand? But you cannot, during the consideration of the bill, be raising the issue because the decision has been taken. And that matter is in court. And I'm part of, in fact, I'm a party. The Speaker is a party to the action, and we've filed our pleadings after thorough research, and I know I'm on solid ground. Unless any of you can say that I have exercised my discretion unlawfully against the letter and spirit of the Constitution or whatever, is now not open to debate. I have taken the decision. That is my opinion. You recall that even the plaintiff went back to the Supreme Court asking for an injunction to be placed on the Speaker from proceeding further on the consideration of the bill. And it was thrown out. Say you haven't established any legal basis for us to place an injunction on. So you can't put something on nothing. It will fall. So please, let's go on. 13 and 14 are withdrawn. We will now, yes, Honorable Member.
Mr. Speaker, thank you for the opportunity. I'm just wondering why in this amendment the Social Welfare Department was not involved. I'm saying in this amendment, I was thinking that the Social Welfare Department will have been involved. Because when you look at the social welfare as it is, and look at their mandate, it says, the Department of Social Welfare and Development is mandated to take the lead role in integrating the disadvantaged, the vulnerable, persons with disability, and the excluded into mainstream society. But in this amendment, nothing is mentioned of the social welfare, especially when it comes to this act of counseling. I think it is, if I am to be counseled, I don't think I will have to volunteer myself that I need counsel. The social welfare must be involved, especially when the matter proceeds to court. The judge must be given the mandate to be able to refer at least the victim to the social welfare, rather than leaving the social welfare out, because this actually falls into their domain.
Honorable Member, your concern will be taken care of by the sentencing regime. That is where they add those things. But we can't continue to put that in the laws that we pass. But that is part of the review of the sentencing regime in the country, so that we bring all these agencies on board. We just don't keep on sentencing people to prison for what we say with hard labor for a number of years, when there are other ways of handling it, because the purpose of actually sentencing or convicting people and sentencing them is for reformation. The main purpose is not for punishment. Punishment comes in depending on the severity of the crime. But usually it's to let the person reform. That is why in the prisons they put a lot of things there for you to go and learn. And I can tell them, the people that came out from prisons are pastors now. They've been reformed, I don't want to mention names, but you know some of them. And they are preaching. So let's leave it at that. That regime, the sentencing regime, will take care of that. Can we now move on to proposed amendment 15? They were withdrawn. They were withdrawn.
Were withdrawn. The
Yes. Honorable Muntaka put up an amendment. I think I put the question. Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The amendment is carried. And the amendment is to delete at the end of 316FB at the expense of the convicted person. Yes. Proposed amendment.
Item number 15. Amendment proposed. Section 316G, line 6. Delete 21G and insert 21(1)G. That reference is correct, Mr. Speaker. I so move.
Where is it? Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The amendment is carried. 16, Roman 16.
Amendment proposed, section 316G, subsection 5, opening phrase, line 1. Insert responsible for gender, children, and social protection. So it will read, Minister responsible for gender, children, and social protection. I so move, Mr. Speaker.
Yes.
Speaker,
Yes.
I would encourage the chairman to abandon this one also, because in the interpretation, minister is defined as, minister means minister responsible for gender, children, and social protection. So there's no need to repeat that in the body of the that provision, because you have already defined minister to mean gender, children, and social protection. So if you can abandon your well, no, this is the first time. So, Mr. Speaker, just for the chairman to abandon the amendment.
Yes, I've seen that. I've seen that at the interpretation. Yes.
Yeah, Mr. Speaker, I think that has been adequately dealt with by the last amendment. The reason being that the minister responsible for gender, children, and social protection was used only once in the entire proposed amendment. So I recall that at the committee stage, it was proposed that instead of adding minister to the interpretation section, we just give the full and that clause. And that is why the proposal, minister responsible for gender, children, and social protection.
Yes, please.
Mr. Speaker, the chairman of the committee is right. If you look at the order paper, we are proposing at the interpretation section to delete the interpretation of minister, so that when minister is used only once here, you just indicate minister responsible for gender and social protection, so that when you go to the interpretation, the interpretation of the minister will then be deleted, and it's just in line with drafting style, because minister has not been used numerously in the bill yet. So that is a section where minister is used. That is why we are saying minister responsible for gender and social protection. And the recommendation is that if you come to the interpretation, you then delete the interpretation of the word minister.
Yes, Chairman.
Yes, Mr. Speaker, and indeed, what the ranking have just said would be our last proposal, and we are done with the bill. So this is an advice that we have been given by the drafting session of the Attorney General's Department and our able drafter within the House, that this is the best style because it's used once. We don't interpret minister, but we should bring it to make it clearer. So if I may move the two clauses together. Mr. Speaker, I move the first one, which is the, I think my colleagues are, so after minister, now section 316J, subsection 5, opening phrase, line 1, after minister, insert responsible for gender and gender, children, and social protection. I so move.
Yes, honorable members, my attention has been drawn to the fact that in the main act, there's a reference to a minister, and there the minister was defined as the minister responsible for justice. And so the use of minister in this proposed amendment will mean another minister. And so if you are defining it here, you are defining minister twice. And so it's better to just put it in the proposed amendment. So the chairman is correct. So we'll take the two together, 16 and 17. Those in favor say aye. Those against say no. The ayes have it. The amendments are carried. And I put the question on clause 1. And the question is that clause 1 as variously amended stands part of the bill. Those in favor say aye. Those against say no. The ayes have it. Honorable members, clause 1 as variously amended is ordered to stand part of the bill. We have come to the end of the proposed amendment, so I now put the long title. Honorable members,
to amend the Criminal Offences Act at 29 to prohibit the practice by any person as a witch doctor or a witch finder, to prescribe the declaration, accusation, naming, or labeling of another person as a witch, and for related matters.
honorable members, those in favor that the long title stands part of the bill say aye. Those against say no. The ayes have it. The long title is ordered to stand part of the bill. Honorable members, we've come to the end of the consideration stage of the Criminal Offences Amendment Act 2022. We now take the motion number 32 and 33. Motion number 32, Honorable Francis Xavier Kujo-Sosu.
Mr. Speaker, I move that notwithstanding the provisions of Standing Order 1311, which requires that when a bill has passed through the consideration stage, the third reading thereof shall not be taken until at least 24 hours have elapsed. The motion for the third reading of the Criminal Offences Amendment Bill 2022 may be moved today. I so move.
Any seconder?
Mr. Speaker, I beg to second the motion.
Procedural motion moved and seconded. Those in favor say aye. Aye. Those against say no. The ayes have it. The motion is carried. We go to item 33.
Yes, Speaker.
Speaker. Yes.
I move that the Criminal Offences Amendment Bill 2022 be now read the third time. I so move.
Seconder.
Mr. Speaker, I beg to second the motion.
Motion for the Criminal Offences Amendment Bill to be read the third time. Moved and seconded. Those in favor say aye. Aye. Those against say no. The ayes have it. Honorable members.
An act to amend the Criminal Offences Act 1960, Act 29, to prohibit the practice by any person as a witch doctor or a witch finder, to proscribe the declaration, accusation, naming or labeling of another person as a witch, and for related matters.
Honorable members, Criminal Offences Amendment Bill 2022 is read the third time and passed. May we now take 36 Armed Forces Amendment Bill 2022. There is not a proposed amendment, so we just take that and that ends the day. Armed Forces Amendment Bill 2022 at the consideration stage. We've done the second reading just at the consideration stage. We haven't done the second reading. Oh. Then we have to take item 34. Second reading. That's item 34. Yes, Honorable Muntaka.
Thank you, Mr. Speaker. With the greater respect, we'll be grateful if Oko at 7 o'clock, they didn't make any provision for double sitting. Mr. Speaker, we could do all that tomorrow, just as we've done with the, the witchcraft bill, if you are minded to. For those of us who have been staying all through, looking at the time now, if we are going to start a fresh bill, do the second reading and go through all that. I wanted to draw attention, if you don't mind, if we could do this tomorrow. We'll be grateful, but we are exhausted, if you don't mind. Thank you, Mr. Speaker.
Yeah, Honorable Muntaka, I agree with you, but we are all in this together. I have not also taken anything at all. When I handed over the chair, I was in a meeting with diplomats until I rushed back. But this is a motion that was moved. That's why I've been jumping the second reading. They were moved together. But the debate that day was focused on only the death penalty. The others were not considered. And that is why we are compelled to go through this. If not, the second reading of this bill should have been said to have been taken. But we still want to give you time if you have something to say, because the proposers or sponsors of the bill did engage, and we have written communication from the armed forces stating clearly that they are in support of this proposed amendment. And so there's no doubt about that. But if members want to express their views, we'll definitely allow it. But this is in line with the current trends globally. So I plead with you, we'll take it. As I indicated earlier on, tomorrow is mostly likely to be devoted to engaging the Minister for Finance. You may not have time to do this. Then from next week, we'll be focusing on the mid-year review. And then during the course of next week, we'll go on recess. So let's just take a few minutes to take this one. But the sense of the House is what will carry the day, not that of the Speaker. So what is the sense of the House? We adjourn?
Mr. Speaker, I get the point made by my colleague about fatigue. However, I also appreciate the fact that the Business Committee, we agree that tomorrow is strictly for our engagement with the Finance Minister, which is in the interest of everybody in the country. The good thing is that the new bill doesn't have any proposed amendments. It's just reading out the various clauses and taking a vote on it. So if members are minded, we can do the second reading without maybe the mover and the seconder of the motion, and we put the question, Mr. Speaker, and then we do the consideration as quickly as possible. Pardon? No, the Supreme Court never said that we need time to do any debate. Maybe somebody said, they cannot tell us how we do our debate, Mr. Speaker. So, Mr. Speaker, we can proceed to do the second reading quickly.
This law we are seeking to amend is dealing with the death penalty, which was extensively debated by this House. So it's not that it's not been debated. It was debated. Death penalty matter was debated here. And this one is just following that. It's also dealing with death penalty, armed forces. So please, we'll take the mover and the seconder, then I'll put the question. Yes. Item 34. Honorable Muntaka, we need 5 minutes of your time, and we'll be gone. I'm sure you are capable of sitting 5 more minutes. Yes.
Mr. Speaker, sorry, I hadn't said the 6 o'clock prayer in 7, so I wanted to rush to do that and come back. But because of the bill we're doing, I couldn't go and say the 6 o'clock prayer.
I know the religion very well. You can go. And later on, I won't compel you to go against your lesson, so you may go to pray. We still have sufficient numbers to continue. Yes.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, I beg to move that the Armed Forces Amendment Bill 2022 be now read a second time. I so move.
Any seconder?
Mr. Speaker, I beg to second the motion, and in so doing, I submit your committee report. Mr. Speaker, I pray that the Hansa Department captures the entirety of the report whilst I read the conclusion. The committee, after examining the bill and its accompanying memorandum, together with inputs from major stakeholders, came to a realization that public opinion supports the proposed amendment. It is the view of the high ranks within the military command and the Ministry of Defense that the death penalty be replaced with life imprisonment in tandem with international human rights laws and value systems of the Ghanaian tradition. The committee accordingly recommends to the House to adopt its report and pass the Armed Forces Amendment Bill 2022 into law in accordance with Article 106 of the 1992 Constitution. Thank you, Mr. Speaker.
Honorable members, motion moved and seconded is for the consideration of the House. There being no consideration, I put the question. Those in favor of the motion say aye. Those against say no. The ayes have it.
An act to amend the Armed Forces Act 1962, Act 105, to substitute the penalty of life imprisonment for the death penalty and to provide for related matters.
Honorable members, the Armed Forces Amendment Bill is read the second time, and we move on to item 35, a procedural motion.
Mr. Speaker.
Yes.
I move that notwithstanding the provisions of Standing Order 1281, which requires that when a bill has been read a second time, it shall pass through a consideration stage which shall not be taken until at least 48 hours elapsed. The consideration stage of the Armed Forces Amendment Bill 2022 may be taken today. I so move.
Let me second that.
Mr. Speaker, I beg to second the motion.
Procedural motion moved and seconded is for the consideration of the House. I put the question. Those in favor say aye. Those against say no. The ayes have it. The motion is carried. We now go to item 36, Armed Forces Amendment Bill 2022 at the consideration stage. Honorable members, I can see from the order paper, but that doesn't prevent any member from coming with an amendment. There is no proposed amendment, so I will take the clauses together. Clause 1, Clause 2, Clause 3, Clause 4, Clause 5, Clause 6, Clause 7, Clause 8, Clause 9. Honorable members, there be no proposed amendment to any of the clauses. I put a question on all of them. And the question is that clauses 1 to 9 stands part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clauses 1 to 9 are ordered to stand part of the bill. Honorable members, we've come to the end of the consideration stage of the Armed Forces Amendment Bill 2022. Sorry. We haven't come to the end. Honorable members, long title of the bill.
An act to amend the Armed Forces Act 1962, Act 105, to substitute the penalty of life imprisonment for the death penalty and to provide for related matters.
Honorable members, Those in favor of the long title standing part of the bill, say aye. Those against, say no. The ayes have it. The long title is ordered to stand part of the bill. Honorable members, we have now come to the end of the consideration stage of the Armed Forces Amendment Bill 2022. Honorable members, item 37, procedural motion. Honorable Francis Xavier Kojo-Susu.
Right Honorable Speaker, I move that, notwithstanding the provisions of Standing Order 1311, which require that when a bill has passed through the consideration stage, the third reading thereof shall not be taken until at least 24 hours have elapsed, the motion for the third reading of the Armed Forces Amendment Bill 2022 may be moved today. I so move.
Any seconder?
Mr. Speaker, I second the motion ably moved by Honorable Susu.
Honorable members, procedural motion moved and seconded is for the consideration of the House. I put the question. Those in favor say aye. Aye. Those against say no. The ayes have it. The motion is carried. We move on to item 38, which is motion standing in the name of Honorable Francis Xavier Kojo-Susu.
Mr. Speaker, I move that the Armed Forces Amendment Bill 2022 be now read the third time. I so move.
Seconder?
Mr. Speaker, I beg to second the motion.
Motion moved and seconded is for the consideration of the House. Honorable members, there being no consideration, I put the question. And the question is, Armed Forces Amendment Bill 2022 be now read the third time. Those in favor say aye. Aye. Those against say no. The ayes have it.
An act to amend the Armed Forces Act 1962, Act 105, to substitute the penalty of life imprisonment for the death penalty and to provide for related matters.
Honorable members, the Armed Forces Amendment Bill 2022 deemed read the third time and passed. Honorable members, yes.
Mr. Speaker, I want to say a very big thank you to your good self and to the leadership of this Parliament for supporting these private initiatives, which, Mr. Speaker, I believe to a very large extent would enhance the image of Ghana, not only locally, but also internationally. Mr. Speaker, it is often said that the quality of every democracy is determined by how we treat our most vulnerable persons. And for the fact that this House, within this week, has passed these very important legislations, clearly shows that Ghana is indeed a democracy that is thriving. And we need to commend the effort of this House and commend the effort of Right Honourable Speaker. Mr. Speaker, I also want to sincerely commend colleagues who worked together with me on the anti-witchcraft bill, especially Honourable Haji Aladi Ayi Ayamba, Dr. Godfrey Seidu Gisao, Honourable Helen Adjoa Ntosu, and Honourable Betty Nana Ifwa Crosby Mensah, who all have actually contributed so well to ensure that these bills were worked on. Mr. Speaker, I also want to use the opportunity to thank the Sane Institute especially, who brought the issue of the witchcraft accusation through petition to this Parliament. I'm sure that today they will stand vindicated that the petition they brought to the Parliament of the Republic of Ghana did not go waste. I want to thank everyone for this opportunity, and God richly bless our homeland Ghana. Thank you.
Thank you so much, Honorable Member. Please, from next week, the House will be having extended sitting, and I have given the appropriate directives as to how members will be catered for all that period. And so some of the concerns raised by Honorable Muntaka will be taken care of. I want to thank all of you for the endurance and for your love and loyalty to Mother Ghana. As we said, time is fast spent, and yet we are still working for the good people of our country. I thank you all. I will not be available tomorrow. My deputies will definitely handle you and handle you well. I want to urge you to cooperate with them and make sure that what you do tomorrow, which basically will be focusing on the welfare of the country, because you are going to deal with financial matters. You are going to do statutory funding. You are going to discuss the mid-year review, make some inputs before the final presentation on Monday. And so tomorrow is very important. I hope you will talk to your colleagues who are not here now to avail themselves of the opportunity to make inputs into what we are going to discuss with the Minister for Finance tomorrow. Very, very important, not only for the country, but even for you as individual members of Parliament. With this, I thank you once again for your cooperation and understanding, and I want to emphasize your endurance. The good Lord will definitely bless you on earth, not only in heaven. With this, I want to adjourn the sitting, and the House stands adjourned till tomorrow, Friday, at 10 in the forenoon. The House is adjourned.